All right, having reviewed my notes and okay, having reviewed my notes in, okay, you tell me when you're ready.
Okay, I'm ready.
All right, having reviewed my notes and Ms. Percefield having reviewed her notes, they both reflect the same thing, which is the last thing that we all discussed was, and I don't have the timestamp, but I have the transcript page number, was transcript page number 389. And I made a ruling on that. And then we moved to the February 21st transcript. So it appears that y'all already had some sort of an agreement, and so we didn't have to discuss it.
Ms. Percefield, you haven't received an email from me?
Not today.
Ms. Hilton, did you?
No, not yet.
Okay.
Maybe hit resend.
I'm showing it was sent at 10:04. But if no one's received it, that can't be right. But it's looking good on my end. Okay. Well, you want me to read the email? I can't. I've checked my notes.
Yes.
And so there, and this is just one part of my notes, but I want to be clear with everyone. 396 line 21 is the beginning of a redaction. This statement that I objected to was on 396 line 19. So there's a distinct possibility. Of course, I don't believe that that's an appropriate thing for the detective to say, but there's a distinct possibility that I misstated the time that the redaction was supposed to start as 21 as opposed to 19, and that may have just it's likely that was an error on my end. So I just wanted to be clear to the court on that.
All right. Well, that may be, but it appears to me that maybe this was something, from my notes at least, that the state and the defense had come to agreement on, and
Right.
not anything that the court was having to make a ruling on.
Right.
But in any event, if in further reflection, your notes of whatever y'all agreed to redaction wise would not have captured his question, is that what you're saying?
It would have been the agreed upon redaction as I have it is just after that. And I believe that's what Ms. Hilton was saying. Of course, I'm of the opinion that that was not an appropriate thing for the jury to hear, but I also recognize that I likely did not articulate that previously. I would ask for a curative instruction, just that the jury is not supposed to consider what was last said by the detective.
Okay. I'm having to give some sort of a curative instruction. I mean, I think it's fairly obvious that this is pressure tactics and persuasive tactics and what have you on the part of the detective doing the interviewing, and not any kind of crystal ball that he has into the future stating any kind of facts. I don't actually think it's particularly damaging, but I understand. And so what language would you like for me to instruct them in?
I would ask that you instruct the jurors that they are not to consider the last statement made by the detective on the videotape before we broke.
As fact or whatsoever, or you want me to say any suggestion made in the last statement, or just
That any suggestion made.
okay?
They're not to consider any suggestion made by Investigator Dennis on that videotape just before we broke.
All right. Any comment by the state?
Your Honor, we would object to a curative instruction. The entire passage of what Detective Dennis said, starting at line 10 through line 20, would put in context what the court just said. He starts off, "To leave Atlanta, why are you so scared to leave this all? I know this is all you know, but there's more to life than the shit that you're involved in, dude. You gotta walk around with a bag with an assault rifle. That ain't life. You're trapped in a war zone. You're at war with your own friends, though. You can't even get in the car with me because you're still indiscernible. What type of shit is that? How can you sleep? You see what I'm saying? Shannon D gonna end up killing you, dude." Like, I don't think.
Yeah, that's the part he's bothered about. The very last part about Shannon and Dee gonna kill you. Doesn't seem like the kind of curative instruction the state ought to be objecting to.
So, Your Honor.
Yes. Would you like to make a suggestion as to how to craft the curative instruction?
No, Your Honor. We just want to make sure that what is disregarded is the last sentence, nothing before the last sentence. Because we stopped it there, then we asked then there was a break. So the last portion, which would be, you see what I'm saying, Shannon D gonna end up killing you, dude. This is to disregard the Shannon D's gonna end up killing you by the detective.
So you want it to be more specific? Do you want me to say something like, you're not to consider a suggestion made in the last question by Detective Dennis about anything that Mr. Stillwell might hypothetically do? Or no?
No, I think that would be drawing more attention to it.
Okay.
I think if we just say the last sentence or the last statement made by Investigator Dennis, the jurors are not to concern themselves with that statement.
All right, you're not to concern yourselves with any suggestion made in the last question by Detective Dennis. All right. Anything more from the state on that?
My only concern around is that it's taking out the entire portion of that, because the last thing they heard is Detective Dennis before I pause. So they may think they can disregard all of it except for the last.
Well, you know what? It's just the question anyway. So that's the instruction I'm going to give. Mr. Steele.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, I just want to again put my objection. I didn't want the any recording to be played the way it's been played over our objection for this reason. And I don't know why anything that Detective Dennis said about, I don't know why you want to leave Atlanta and carry an assault rifle, that shouldn't come into evidence before this jury. So my position has always been the state has to ask a question. If they're going to impeach Mr. Copeland, then they can play the excerpt. But I just don't want it to sound like it was waived by some agreement. I never entered that agreement. I understand the Harvey rule. I'm not going back on anything I've said. But my objection is that it should never have been done in this manner. And we're just watching videos for a day plus. So my objection is that the state should never have played that portion at all from all the lines, 10 through 19.
Okay, because your objection is to the methodology
Yes.
in which they are conducting the impeachment.
Yeah, that wasn't impeachment. Detective Dennis' statements.
All right, well, we had an opportunity to go line by line through every one of these statements and make more specific objections to questions or answers, and that was not raised with this court. So that is waived. With regard to whether you had an objection to the methodology of presenting the statement in full, that is a separate issue. And frankly, given that Mr. Copeland disavowed everything that happened in any of them, you know, I would have overruled that objection anyway. But all right, anything else for the record?
I don't believe I waived anything by my objection to the wholesale playing of the recording.
No, I don't think you waived that objection. I think you have waived an objection you might have had to this particular question by Detective Dennis, because we had an opportunity to make kind of very targeted, specific line by line objections to the things that were going to be heard in the playing of the recording.
I hope that if another court looks at it, that they will see my objection as being to anything that the state does not answer certain question for.
All
So
right.
I believe it's encompassed.
Okay.
Thank you.
All right, let's get Mr. Copeland back in. Hang on, actually, just so do you know where we're going from here? Is there any dispute as to, since it seems that the rest of this interview, y'all did not put before the court to make specific objection rulings, you came to some sort of understanding about what was going to be played. So do we need to clarify anything about what's getting played next?
Not from the state. I have everything that we agreed to. It's been highlighted, sent over to defense. I haven't heard anything
All right.
inconsistent with
The mic that you're pressing right now
Sorry.
is not anything we're using. That is in case the sound system goes out. Your mic's still that one that's attached to the. Well, I'm not hearing it from that anyway. Go ahead.
Sorry, Your Honor. From the state's position, we believe that we've covered all of the redactions. This is what I forwarded to defense to make sure that I was correct with my redactions, and we didn't hear anything otherwise. So I believe.
Well, and as it I want to triple check before.
Yes.
All right, let's get Mr. Copeland in.
Your Honor,
Not yet. Yes.
since there's a curve instruction before the next question's posed, there has to be the renewal of the mistrial motion. Can we do that now and preserve it for an appellate review?
For clarity's sake, Mr. Shard, are you still making a mistrial motion? Because you seem to have said that, clarify that for me. Or have you withdrawn that?
I am making one, but I also acknowledge what I've said to the court.
Okay. All right. So that is denied. I will give a curative instruction and, yes, it's preserved.
Thank you, Your Honor.
Okay. Now let's get Mr. bathroom break. Took one during that break, right? So we don't need one in 10 minutes. Okay. Thank you. All right, ladies and gentlemen, I am going to instruct you that you are not to concern yourselves with any suggestion made in the last question by Detective Dennis. Go ahead, Ms. Hilton.
He ain't nobody know where he going.
So what's in the studio?
The guns.
So what are you talking about getting rid of them?
They get rid of the guns that they using. They're not keeping those guns.
So they trade them, they sell them?
I think take them apart, break them down. I don't know what he's doing with them. But he made sure that they're on my side. But all person they knew what the gun is going with.
Why are you the only one that knows?
Go put him in his position.
You trust him?
Yep, and told him to get rid of him.
What is
Calling at 35703.
Is
there a question on the floor?
Stop tapping, please.
Is there a question, Judge?
Yes. What?
Is there a question on the floor?
No, she's trying to queue up the next part of the tape.
We're resuming at 35947.
Yeah, permission, man.
You ain't been learning.
Yeah, but shit in jail.
You ain't, bro. You,
Yeah, I got somewhere to run and hide.
at the end of the day, Woody, you gotta understand that your hands ain't clean. Not only do you have this case, right? Technically, you have another gunshot charge possibly coming with the gun that was at the house. And you got another possibly possessed of stolen property case coming. So, you got 3 cases technically out.
Help me, man.
Crazy, when you steady piling shit on.
I'm telling y'all what's going on. I'm like,
After the fact. You ain't telling us before the fact. You telling us once you got jammed up. If you was trying to really help, you would have told us this 6 months ago.
hey, y'all really ain't.
We did what?
Y'all ain't like, I'm thinking if I tell y'all ain't gonna protect me or help me, man, like this.
What did I say to you about when you came back in January 3rd?
What you said?
Why you gonna move away? What you tell me? Y'all ain't gonna help me though. That is helping you.
Y'all let me move. What I said, what I know, man. What
It's called protective custody.
You didn't say that. You just.
I said, when you said that, you want to know why it ended at that? Because you said, my mama said, I was born in Atlanta, I was raised in Atlanta, I'm going to die in Atlanta. I ain't ready. They going to have to kill me in these Atlanta streets. Did you not say that? You remember saying that?
I ain't say I
You said it somewhat like that, correct? So I took that as, it ain't even no point in trying to get you somewhere to go
ain't got nothing to worry about. Like right now, I still ain't getting that, but I got a lot of shit to worry about. Like, I ain't getting that involved with what y'all pushing me about, but besides this right here, but
You are all the way with the stuff we asked you about. They connected to you, which makes you connected to it.
I'm not.
Your gun that's in your possession, this gun, was perfect signed. Quindarius Jackson got the paperwork for it, right? He has a gun in his possession that was used to shoot Lucci Mama. You see what I'm saying? You see how the dots connect?
I don't know if y'all got that gun with
No,
me.
I'm not saying that at all. But the moral of the story is, he's a gang member in the same gang with you, y'all friends. It's all tied in together. It's not like a standalone case. It's not a standalone case, it's all together. So therefore, it's like to sit back and say, I ain't did nothing, I ain't did this, I ain't did that. That's not true. That's not true at all.
Okay, I haven't retaliated. I haven't tried to retaliate and none of that. I'm not gonna really protect myself.
Well, listen, I had that question though.
And you know what? I'm sitting right here because okay, these guns. I mean, I'm not sitting here because I'm out there trying to hurt her. I'm protecting myself, man. Like, and then the police never told me. I ain't never tried. I would just stay low key. Man, I would just. But
You ain't gonna say that.
listen to protect myself.
Protecting yourself at your home. At your home.
I was giving it back.
So you say.
Huh?
So you say. When we talk to Lil D, what you think he gonna say?
What you trying to leave up with?
This gun, his gun.
What about it?
What about it?
What you mean? What you gonna say about it?
I don't know what he gonna say. What is he gonna say?
What you think? I don't know what you're doing.
I hope not. I hope this gun don't come back, because then you got another problem.
So when they don't come back, y'all let me go?
No. It don't work like that. What you think is that, like, it's just you say one word, we just pull the button, you walk around.
I'm thinking if I get y'all.
In the long term. Long term, yes. Right now, overnight, next week, no, it ain't gonna be that quick.
Well, y'all be saying this. Man, I think they try to trick me, man. Y'all,
We ain't tricked you. We didn't. We did not trick you at all. How?
I thought y'all were gonna help me.
You thought you was gonna walk out of here today.
I knew I was gonna help
What
me.
did you think?
Huh?
What did you think?
I thought y'all was gonna help me, man. I thought y'all was just gonna.
Long term, yes. You won't instant. You grew up in the microwave age, where you want to hit the button 2 minutes and shit done. It don't work like that. You just told me a pad full of stuff, right?
Man, I can tell y'all everything y'all want to know. Y'all just ain't asking. Y'all can't just. But I just can't think.
Start with the shoes. Who did what shoes?
What shootings? I say every shoe right now, but at the end of the day, y'all gonna tell me now. Oh, we just gotta verify that it's true. I don't have no reason to make that up a lie.
But listen to this. If you wasn't, were you there for these shootings, or D told you?
Nah,
You know what I'm
they
saying?
talk about it.
I feel you on that, but that's rule number one: verify information. They could be telling you a falsehood, and you're telling the same falsehood. That's just like me telling you, yo, dog, hey, I just went with Beyonce. And then you go tell Gator, yeah, Dennis went with Beyonce. And then Gator tell Thorpe, he went with Beyonce. Just because everybody says it doesn't make it true.
So what make you believe then? What I need to say? What I need to?
What flavor then? What gun that was used at? Who else could verify what you're saying? You see what I'm saying? Stuff like that.
So because it's never killed and you want to know the name?
Yeah.
Okay, I'm just explaining to you how it was. So we had a cousin.
Right.
He had a meaner cousin.
Who's the leader?
I think it's going to be enough. But is she going to help me though?
Yes.
She's my long one.
Be right back, here, brother.
we're going to move it to 407-23. God bless you.
Bless you.
Me and Loretta the Camaro on a Corvette. You know, a phone number. You know, Doug's phone number. How do you get in touch with him?
My head hurt.
You know what I'm talking about? Alright.
I don't care no more, man.
You should, bro.
Man. This shit suffering, man. This shit made me suffer. I'm suffering for shit I ain't doing, man. I mean, I'm asking for help, man.
Woman, you have to help after the fact, though. After you done did some shit. You. Did we put this gun on you?
No, I didn't. I did.
Did we put these people property in your house? Did we put all the gun in your house? You want us to go get your girl? You want us to show us who it is?
No.
So how do you want us to play?
I just want to help, man. I mean, this not helping if I'm being jail, sent in jail, no bond, no anything.
It is heavy.
I know it's not.
It is.
It's not.
Because you safe.
People down safe, man. Jail ain't safe. That's expression, man. My head hurt. Keep thinking, man. I gotta go there. Shit, my baby birthday comes up next week. Man, I can't burn it down. I can't do that. I got shit in
How you
everything.
gonna find out anyway?
What you mean?
You said you ain't got no money, huh?
I know.
How you gonna find
I
out?
got a couple cars left my family.
Who?
I got family. I got family.
Call Buzz.
So wait, the nigga ain't giving that guy him count.
He said he'd get it back to you once you get out.
That nigga lied. He told me we got me a lawyer.
He did?
Nah,
Why didn't he get you a lawyer?
I bought one of my own. I paid one with the money I had. I'm just saying, I give y'all all the information to y'all. Hey, y'all keep
You
trying
feel like
to
he's not helping you. Give it time. That's all I'm at. Can you give us time?
y'all trying to do a game.
You know how to get?
No.
No.
I'm not. I'm honestly not.
No.
No.
You ain't good.
No.
So if I show you something to prove you otherwise, you're what?
I'm not a son.
What are
I don't have a check.
What are you?
I'm just me. Don't
And
think
when?
shit, it just always happens. Like, before anything. I know the blood level. I wasn't. No one else put the blood sheet up like that. Why? Nah, man.
Let's see your blood.
I don't remember these same shit told you. I told you.
Look, Dominion?
Yeah.
Quindarius.
The North Cleveland ain't a blood.
Yeah? What is it?
He did. Let these Cleveland.
He don't claim that?
Huh?
He don't claim that? What's the relationship between him and Monson?
Who?
Him and Monson. Why you always up on the Monson? They gave him?
Stopping at 410-58. Resuming at 4:13:15. Resuming at 4:26:15.
What's your date of birth, man?
July 25th, 1991.
So what's your affiliation? What's your affiliation?
I used to be with Doug. I mean, then,
John Purcell?
I'm from Canada.
Okay.
That's that neighborhood.
What, 30?
I was there with that. I mean, we just be out there. I mean, they got them.
Oh, I'm sorry.
Different things, but they were like, I ain't got down with the blood gang. But the people who I was with was a snitch. They snitching. So everybody who was with them, they got kicked out. I mean, so, and I just stayed out there. I ain't never get back down.
Mm-hmm.
Stopping at 4:27:05. Resuming at 4:28:16.
Chill, I got admit, just start hanging with them. I mean, start putting names in songs and stuff. Like, oh man, then we start hanging a lot. Start taking pictures and stuff. I let a person a lot. I appreciate everything you doing for me. I ain't no problem. That's how I start hanging.
What the yeah?
Oh, he got a studio in Metro Park. It's another studio, DJ Drummer studio right downtown by the Stiletto. It's right down Marietta and he got another studio right down Bed Street. And he got a studio on Northside Drive called Garden. It's down like almost toward Highland Road.
Stopping at 4:29:08. Resuming at 4:33:37.
About what I should have been telling them. I was telling them about what people doing to me. You know what I'm saying? I didn't want to tell my so-called friends at the time. But, and the way he said, like, I talk to the police a lot. You know what I mean? Like, you do what I ain't tell, but I'm talking to him. So I don't know how he get his information, but when he said it, I thought he was just talking to him, trying to scare me up or whatever.
Who was that in that?
It started there. His name Jeff too.
Jeff?
Yeah.
Okay. So what makes you why you want to tell all that now?
Cause I'm like, look, Jeff. And it's like, I'm tired of the police. I mean, I've been going, I have a girl, man. And I've been going to beat up for her, but I hate thinking on my shoulders. I mean, I have two big words, man. I have police and I have VP. I mean, and now I'm messed up. I don't got myself in trouble. And then some of the stuff that I'm in trouble for, I ain't having to do with, or I ain't do. I mean, and I'm going to jail, so I just feel like if I should just tell them, let them know what's going on, they should at least take it easy on me, help me out or something. I mean, but I'm just tired of looking on my shoulders about this shit, and I ain't having to do it. I know nothing about it until I see it. I mean, I ain't never know what's gonna happen. I ain't know nothing. I'm tired of being questioned about. I'm tired. I mean, I heard it. Daughter was like having killed, like. So I don't want to go do that, man. At first, I didn't care, but when I look at my baby, she be so happy and she be kicking and it just, man, I try to make weight, man. I just don't want to be in jail, man. I mean, I'm telling, but I've been telling them the whole story and the truth. Cause I didn't want to feel like in jail. I mean, I'm just telling them stuff I was in. I mean, and some of the stuff that I know. And I see now that these niggas gonna trade them, like they coming at me. So I was just like, man, I'm in a lose-lose situation, so I gotta get somebody out. You know what I'm saying? The police think I'm doing something I ain't doing. I might as well let them know that, man, it's them, not me. They plan on killing me, so I don't care. They like, y'all only gotta deal with it. So that's why I went ahead and just said it, but at first I really didn't want like nobody said it. Man.
Stopping at 4:36:37. We're resuming 4:41:35. 4:41:35.
Damn, make this shit worse. You fucking know, telling police. Oh, damn. I'm over jail, man. So gotta get me out, man.
We're going to fast forward to 4:43:56.
Man, damn, man. Yeah, man. I'm gonna do it.
We're gonna pause at 4:44:17. We're gonna resume at 4:59:22.
You told me that earlier, though, right?
Yeah. When I said it did first,
Who did it say?
they did.
Who was that?
Okay, and whoever, he got his own school.
Could be.
His own.
You don't know why?
The D-Run coach.
Okay. So it's possible that Lil D was with him.
I would say probably, but like,
What about Monto?
but I go for Moto.
What?
I go for Moto, bro.
How do you think? Shit. Pokey?
Yeah.
Who else?
I would say Moto, but I ain't for sure. Like you said.
Maybe. Maybe.
Yeah.
I'm gonna put question marks by now. Lil D? Maybe.
He probably went to.
I thought you said he wasn't a shooter.
Say probably went. You saying he had a gun. I know for
Yeah. Like,
Pokey time. That young nigga don't care.
how old is he?
Man, he's 17 now. He was just juvenile.
Where did you locked up a robbery?
Nah, they got caught like 8 guns.
Hey, where?
They took a metro, I don't know, high speed chase.
I need something to get his real name. Where high speed chase? What jig would they go
I
on?
don't know, locked up, what you got locked up?
Like, what county they was in?
Yeah.
Where, though? Like, I need something to be able to find this guy's
He
name.
got codependents.
Who was one that's called it? Government name.
They said the game you push Pokey the Nappy Head Black. Yeah, I think Pokey and what's the other nigga name? Other got tattoos in their face.
Marquise?
Pokey got I think a snake in their face. You know what I'm talking about?
Snake tag. Yeah, please.
I think I made it 40. Yeah, like, Pokey throw a real nigga. It's just, if any son who died.
Do you get what I'm asking you, though? Like a government from
I can't.
what high school he goes to? What
This nigga was going, I think, CEP. CP. I don't think he was going to school. He dropped out.
When did he get caught? Where? What time? Give me one to code again. You said the gang even got him. When?
They were questioning him about, he said they questioned him about the, I mean, heck, y'all.
How long ago?
He had got locked up for a burglary. The police went to CP and got him.
This year?
Yeah, everything, somebody gonna be this shit. Supposed to be like, damn, man, I can't even remember his Instagram name. His code for the name Fitty, I think. Some shit like that. Fitty, yeah, something like that. He got on high speed, he had like 8 guns in the code. 7-hand pistols, I think, a chop.
Why he has so many guns?
I think he ran around robbing people. Last time I heard he was in Metro, he's supposed to be getting shit over the right street.
Oh, he just turned 17.
Yeah.
They said, yo, your birthday. It's what, be 17, he already there.
Yeah, that's what I said, he's supposed to be there. His birthday, what is it, June 8th, May? What January, February, March? I think I lost in March. They don't care right there, though.
He don't care.
Nah, he don't show something. For sure. Who is that? No, okay.
Okay.
Found me. Yeah, I can take credit for somebody
The
else.
first was you know, yeah, man.
Let's get him out, Joe.
I probably ain't know, so.
What I'm saying, y'all can help me, man.
But
I'm telling you, man, I'm gonna go to AZ, man. Listen, I'm telling you, I can't do too much because I'm out here, but if you can put me in the backseat of the car right now, with these handcuffs on his shirt, and I can point each spot right now. I mean, I can already.
that day will come. It's just not today, bro.
I know, right? But
You gonna
I'm just telling you, give you stuff like, I can just be talking. I want to show you that I'm dead serious.
and I believe, like, with this stuff you giving me, I believe you. Because when you telling me something that you really telling the truth on, you sit straight up and down and you talk about it. When it's something you trying to get us some half shit, like when it's time to talk about the neon and you be like, you start doing your mouth. And you don't even know, it's like a nervous twitch.
What you want to know? What you want to know about this?
What bodies?
What he is?
What burn bodies he got?
Like, when he killed himself?
Or he had them.
He had nothing killed.
We're stopping at 5:05:53. Resuming at resuming at 5:09:05.
It's just so much about him. I mean, so when he got killed, I'm just like, And he must have trying to run something like that. And then T see me like, hey, you know what application? I'm like, no, like,
This mother the same person.
yeah. So he like, so he slew me in the tail like that. I mean, what you mean? Like, that nigga told me gangster master, that man is still there.
Court's indulgence for one moment, Your Honor.
I'm sorry.
Court's indulgence for one moment.
Jerry, if any of y'all need to stand up and stretch, feel free to.
Oh, I'm so sorry. 519. So, resuming Your Honor at 519:06.
He told you a lot of things about it. So he told me, oh, what I, dang, you know, told me so many stories, man. He done told me so many on the side. Damn, man. They said a lot, man. Wow.
Well, what's he going to try to find a picture? You know what I'm
That's what I'm like, well, you know what I'm saying? I said, God, man, God is just, yeah, God, God, I don't know what I ever take, man. I think it's that easy.
Please do. You done made it hard for 6 months. We knew you was the key.
I just don't understand, like, I'm not just saying it now, I wanted to say something, but I feel like, man, it doesn't have nothing to do with me, like, I mean, I ain't out here getting in trouble then, so, like, now that I got in trouble, I feel like, I didn't know what it is in jail, man, but I ain't trying to go through none of that. I ain't trying to jump no more, I ain't trying to stay up.
Well, they waiting on you at Fulton and they don't get you moved.
You didn't know what y'all talking about, one?
That's not up to us. That's not. That's
Even if you speak on your behalf, you.
Not only that, you made us literally wait and wait and wait. That was they wait 6 times for 6 months.
So what you want? What you want? What you want? Some new?
No, I can't. I don't have authority to say give it a bond. You understand? Like we definitely gonna let the powers that be know that you've given us a lot of information, but we still have to work these stuff that you do. We can't just go by your word. We still gotta work the cases.
I know y'all should already case and guess what? But I'm telling you, I can help y'all work. I can just.
This is a great start. Like this is a great head start.
I can have this stuff. I can have this. I can have. I mean, I can have like stuff that I can just show y'all how. Yeah, I can do a lot. I can still go around and I will camera. I don't want to go to jail, man. I swear to God.
You don't have to sit down because that's just not how it works. That is just not how it works. You're gonna have to sit
or anything. It wasn't a meeting.
Right, and that's stuff that we not just finished. We've been up here since 6 o'clock this morning. So it's not stuff we finna just push all in the next 24 hours. We ready to get out of jail.
Nah, yeah. Shit,
We gonna work it.
I understand it. Kind of like a jail. I'm not gonna talk to y'all. Need to talk to y'all there like this.
Why not?
You gotta know, though.
Is that it?
Bruh, if you wanna call me and you remember something, whatever the case may be, call Deshaun like Deshaun called me. She just called me. I told her let you talk to her before you go where you're going. But I mean, it's not hard for you to get in contact with one of them and say, have them call me. Yeah, I ain't that hard to find. By a long shot. Or hard to get in contact with.
Stopping at 522.49. Resuming at 524.22.
They did get. I don't know. I think it was somebody else from like somebody one of the other talking to them.
How many damn rental cars?
Stopping again at 524.37.
Man, cold in here. It's cold.
I'll adjust it a little bit. Say what?
I put my hood on my head.
I made it warmer, so it'll warm up in a minute.
Fast one at 525.27.
But see, Ben only one he hit stuff. I mean, he hit the car. He hit the ones.
What the white matter with?
Man, Pee-wee career. See, Pee-wee good with Floyd Mayweather. See, ain't no telling what it could be. I mean,
They go.
yeah, ain't no tear it up.
They not. They brand new.
I think he said GL Z28. I mean, so he not gonna do nothing but cut. He gonna hide. They probably hide it, but they cut the guy a shot. I mean, so no, they're not gonna do nothing with him. They kidding.
Stopping at 526.14. Resume at 533.55. 553. 533.53.
Mikion pretty much told you it was him, Shannon, Nard, Bentley. Nah, they had it. Mikion and Stub, he and Stub, and a girl who was supposed to went to Bentley house. You did? And when they got them doing it, they supposed to pull up on me at the house. But I think the girl at Bush, the girl supposed to be skinny lit. Okay. She know what's going on. I mean, this the girl Shannon trying to get me. Remember they came shot it up while I was in the car. This girl who I thought told them that I was in the hotel room.
So it was Yak driving, Shannon with the AK, Nara with the pistol, and Dua with a pistol.
Nah, I don't think Dua had a pistol.
Okay. All right. But you just know what seats, how everybody was sitting in the car. All you know is that Yak was driving.
Yeah, I just know Yak. They said Yak wouldn't drive.
And that's based on what Mikion told you.
Yeah.
Lil D.
Stopping at 5:35:11.
That's why you haven't been doing stupid. What happened?
Nothing happened. We're waiting for her to
You
come up the
need to
next
say
part.
community time, so you dummy. So this. Put that down.
Something might be. Just confirm that. Resuming at 5:35:49.
So, the story came out. Two people said it.
What?
Shannon them killed. You get like Bentley's girlfriend is not sister. Yes, his baby mama is not sister. And you know what she told him?
What?
How could you be around him and he's supposed to kill my brother? Telling me. And Bentley, like, you feel like you killed your brother, just let me know. One time, this time. That's why me and Bentley fell out. You don't let somebody tell you shit like that. You know I ain't had that dude, then he get killed. You did. So, when I said Bentley, you see how I'm telling this girl that she won't be dead, just said, and they gonna, so I believe you what you saying. They would have killed me to get out them. So, I told her, so like, he just trying to throw out 9 minutes. Hell, nah, I ain't going for it, so.
Stopping at 5:37:02. Resuming at 5:38. 5:38.
Look. Don't it feel good to get it off, though?
It kind of, I ain't gonna lie, bro. At first I was nervous and worried, but now I don't see so much.
My whole thing that I was trying to show you is you are already trapped in a corner, though, with so much where it's like, you know what I'm saying? It's like, if you been told on the media, why do you care what everybody else thinks? To be honest.
I want some help, man. I just know, I ain't trying to be in jail, man. Right Street, man, the folks, this shit, man, you be done this in that motherfucker a long time, man. And I just want to beat up like that. I mean, I wasn't doing that wrong. I was, and I know I be saying last week that I got Sherry Challenge there. Them folks gonna play down there.
Oh, you worried about the wrong thing.
I just don't want to get away from my family.
I feel you, but you need to be worried about them 3 lines.
I just told y'all, I tell you, whatever y'all want to know that ain't tell y'all, that's I'm gonna keep going. I mean,
that's why I keep telling you, we gotta wrap this up at some point, bro. And continue another day. Like, we done had you for a whole shift. Like, at some point, we got families too, you know what I'm saying?
yeah.
So, it's like, I want you to keep talking. Honestly, I wish I could plug into your brain and download everything you know. You know what I'm saying? That would be great. But at the same time, it can't happen at one time like that. It takes time.
I understand. That's why I told you. I mean, I told y'all, okay, if these folks want them, I go to this stuff they want me to go to.
So you willing to sign you up?
Yeah, I will.
You gonna sign the paperwork and everything?
I signed right now.
You'll go for the grand jury and everything?
Yes.
I will.
I'm willing to testify, bro. My life on line, man.
You right about that?
I mean, I'm not joking. I'm not playing that. I'm really. Now, I ain't trying to sit in jail and think about this sitting there. I mean, I don't give a I'm ready to sign, go through every procedure I got to go through. Let y'all get them motherfuckers because at the end of the day, I can't be out there when they out there. You know what I mean? So, I can't now, but at this time I anything, I just need y'all to, I do this, I just need y'all to just give me somewhere to stay. I mean,
So now,
you don't worry about me hanging no more.
after this, you'll be willing to leave your state.
Yeah.
Look at me, what? Why are you looking down?
I look down because I thought about like, yeah, like,
The whole
if they take me to your state and stay out here.
It means, but the point I want you to understand is, it should be about you, your girl, and your baby. And they being safe.
That's why
and the reason I keep saying leave, go somewhere else is because you need to go somewhere where don't nobody know your name. Don't nobody know your face. Don't nobody know nothing about you. All they know you're a little black dude just moved from Zimbabwe.
Yeah.
They don't need to know Woody. Woody, that we know, brings drama. And you don't want that at this point. You know what I'm saying? At this point, it's like, don't you want to be killing? They killing.
You just told me something new. You just told me that if I was these, y'all would help me. You know what I'm saying?
It's called protective custody. Okay? And if you're able to, I can't make no promises, but if you can do what you're talking about, I'm sure they'll try to work with you in some way or something. So why not give it a shot? What are the options are there? You know what I'm saying?
I'm ready to be free in jail. I mean, like I said,
But you're not really free.
listen to this. It ain't what I can do. It's how to do it. You know, I can go, all I gotta do is just talk to them. I mean, if I talk to them, hey man, listen, I need to tell you, bro. I mean, pull up on send me, give me the address, I can come see you. He would never come. I mean, I just didn't want to talk to them because I didn't want to be around them. I didn't want to be close to them. I mean, Jesus, I come up. Wherever person name come up, Kente, I can talk to him. You know what I mean? I can go to any one of these people. I mean, I can do this. I mean, I'm not, I go to Morocco, I go anywhere. I go chill, talk to them, and set them up higher. I can do it. I'm not just talking anything. I mean, I'm not scared to do it in that. I mean, if it would take to keep me out of jail, and long as y'all have somewhere like for me to be at, and I mean, I do this. You know what I mean? All I have to do is talk. They not saying like, I'm snitching. Now they just saying like, nah, most of them, I don't be talking to them but like that. It's just like, most of them keep coming back telling them, I've been talking to the police. And they just feel that there ain't nobody locked up, everybody got no warrant. So I wasn't taking that because the truth is, everybody say, I can't be telling that because whatever I know, they get locked up. You know what I'm saying?
Right.
So they know that. And they ain't get locked up, so they know can't tell. That's the only thing they keep me out of it.
But what happens when they start getting locked up?
So what I'm saying, that's why I need y'all to have my back. That's why I said, if y'all say y'all help me and then I do it, I don't care. I'm still be myself. But if y'all say, if I do it and then I got my back and police still trying to get me and all this, then I would just back out of it just.
You remember she said earlier where she said, you're a small fish.
Mm-hmm.
That's not to insult you. That's being real. Like,
I know. I know.
Stopping at 5:44:31.
If you don't mind me asking, how long left we got?
Not long.
Resuming at 5:46:01.
I mean, it's true. You want to talk to Deshaun real quick?
She in here?
Yeah, we just gonna get us the paperwork done. We got a lot of paperwork to do before we continue with you. But I just called like 10 minutes when I know what I was calling right back.
Like I was just telling him, like, is there anything like that I can do? Like, I just told him, like, yeah,
You doing the right thing now, but I can't. We don't just come up with game plans right at this moment.
Nah, I ain't saying like, I'm just saying like, if y'all feel like stuff I'm not telling y'all good enough, I will watch. I will video camera, and I go around them, and I actually be around them a lot, and let y'all hear the conversation, see this. I go to the house with a gun in, let y'all get out on camera.
Whatever it takes, what you're saying is good, but we can't just take your word for it. We still got to look a little further into it. I'm not saying what you're saying is a lie, but we just not going to take your word. That's just not how we do it. You understand? So we got to do a little bit more digging. Like you given us a great hit. We were here. After we talked to you, we're here. Because now we got what you're saying makes sense with what we already know. We just need something, not just talk. Right. I'm not saying you just talk. I'm saying we still got to get to it. We're right in the middle right now.
So that's what you're in the middle. And I'm going to tell you now, if I do everything else, I'll get you here. Just tell me what you need.
And we have to come up with a game plan. We're not just going to huddle up and throw a quick article at you right now. We got to come up with a real game plan because when we present a case, we want a case to stick. When you put shit on top of shit, your results is shit.
I told them, if I testify, I will. I will sign a ticket to testify. I will anchor monitor to record all this.
And you better that every time we call.
Stopping at 5:48:09. Resuming at 5:48:28.
No, we don't find out. But you got to give us a minute to get shit rocking. Right? That's just how it goes. We won't rock down the cases. So it ain't no chance of somebody else getting out and doing this and doing that. Especially with murders. You got to work murders.
I didn't know how to do it either. You get
Fuck him.
I'm just saying.
Stopping at 5:48:58. Resuming at 5:50:03.
hear, I can work with y'all, and I can hear y'all yell. I get y'all yak. I get him. I know me and him sit back and talk about this work. Get him. I mean, I still have that conversation. Y'all sit there and listen to our whole conversation and have a little quote. I mean, you hear our whole conversation with me and how to talk about. I'm talking to you like I've never had a while. I mean, I talk to D. I mean, stuff I heard these supposed to be had something to do with. I'm talking about all these. Duke, Max, Bentley, Moonco, I go around. Every last one of them. Every last one of them is out. And I'm trusting so many times that you will, but you're the quarterback and I'm the GM. But GM, general manager. Behind football, you got the owner, the general manager, and the quarterback in the face is the star. And at this point, if you're going to help us, you're going to be the star quarterback. But you got to let us run the team. You got to let us run the team. It's not, what you saying, it sounds great. What I know and what I know how to do police work, shit don't always work like that. So you got to let us come up with a game plan. But you, wherever you go, they waiting on you in the county. I don't think you're going to be in the county. We're working to get you moved to another facility.
Stopping at 551.47. Resuming at 553.04.
Listen, I tell you, I keep it on. As long as they know why they look my shirt up and see and like that. I keep it on. I'm gonna never take it out. I mean, even when I'm at home, whatever. I promise you, you it ain't that easy and then like that. You ain't. This Birdman was messing around.
Sorry. Stopping at 533.22. And resuming at 553.35.
That sister? Do you know her?
I texted her. But listen, I just seen her Sunday.
Okay.
But I seen her whole body. You know what I mean? She probably about my height. They look like her though. I mean, they look just like, just seen her Sunday. Sunday yesterday.
I can't give you a full body shot.
Yeah, I know, I'm just saying. I'm looking for a back, you feel me? But looking at their face, they look just like her. You know what I'm saying?
Okay. All right.
Stopping at 554.17. Resuming.
You know, but you ain't got to go tell everybody. You know what I'm saying? Like, he piped up on. Like, damn, bro. They want you to know they trying to figure out who jumped on you. I switched up. They want to find out who jumped on you. Could I don't really know. That means, so she like, well, give you her know. But I'm really doing all that, bro. Nah, we like, nah, bro, I'm just saying. See, when you actually come, you cut the phone out to the battery. I mean, and he told us, Shannon answered for you. Shannon answered the phone. Because Shannon saying he answered the phone. Like, they gave him, he like, gave me the phone. You feel me? They both on listen to you.
Yeah.
ain't there. See, he keeps switching numbers. You know what I mean? So,
You got his number in your phone up there, Shannon?
I don't got his number. They certainly got his number. But he got his number though. You get it? So,
Stopping at 5:56:11. Resuming at 6:04.
yeah, he old, so he be like, but you ain't got
Stop saying he old. He only a year younger than me. I ain't old.
I'm saying, we young. I'm young. What's your age?
I'm 35.
Oh, I moved from my father.
So you calling me ancient? Because I'm 36.
You old, man. We young.
You trying to say about I get 8 drops up in these legs to make it better.
You ain't gotta worry about it. I don't know this. What I'm saying is this. See, it might be like, hey man, you ain't gotta talk to them folks, I mean. Know your rights. Like, that's how he be. Word.
Yeah, I understand. Yeah,
But with them on it, on this situation, like I'm saying, man. Let me see.
Talking 6:01:04.
Like I said, I can get used to tell you listen on the phone, I can have a while. I mean, and I can get used to tell me everything.
Can you call D when you get to jail? Yes, like how they Sean, like do a 3-way or something?
Yeah.
Try it.
But he's not gonna tell them jail phone.
You never know what a person's doing.
I mean, he did when Wayne Silver got shot up. He told me when I was in Henry County. I mean, but that's what I'm saying. Like, he take, I'm like, he like, boy, but he need help. And I'm like, what happened? Like, man, I mean, tell me, man. I mean, he like, boy, so he Wayne Silver is up. I'm like, oh shit. But he just left it there. You know what I'm saying? He ain't go for it.
Yeah, that's the idea, but
I mean, but D know everything. He know everything. Everybody around know. Everybody. I mean, I know this shit because I'm like riding in the truck though, you know what I'm saying? And we don't be riding. I mean, we have the radio on or we have it out. I mean, and I just been telling like people I'm cool with to give stories on people like that. I mean, and he just listening, stuff like that. They tell me how we stay kicking.
Stopping at 6:02:35. Resuming at 6:03:45.
You ain't tell me? Man, like who? Oh, you a tick now? We got a plane, bro. You know we got a plane? I had to push my plane, you know he told me. Who gave you the money? The police. Oh, wow. I about to go say, say, wait. I go, no. I was just saying, who was this? You remember the guy got shot at the green store? Lil Rick. Yeah. That same night got shot. If y'all looked at the camera on the stove, y'all see me a tick in the street fight. Who shot Lil Rick? Man, they said somebody gave him the drugs, he ran out the money. I mean, that ain't nothing to do with all this shit. This bitch, that nigga lying. I first I thought taking them did because we got a fight right there, and they never. You feel? I had made it out, you see I was black. I mean, blood come out of it and everything, but I just did that. I mean, then when I got framed, the next day came through and put it on his face. You feel? So when Philip money paid, in a way he showed me like he's still from. And after all that shit, you would say, shit, that you don't fuck with you. Right, that's what I'm saying. That's why he heard me and he got a fight. And then he put me right up there. Like, they called like, what the hell you in tickets? He ain't called you for. You did. I mean, like, what the hell you in tickets for? That nigga trying to fight up. I told him what he really said. Like, nigga trying to, holy must be paying me. I got like a nigga snitch or something. So I walked up on him and we got a fight. I mean, I started fighting. This nigga pulled up a gun. Yeah. And Shane and D worked with him. They pulled up him. I walked down to the bus. I was got a ride. I thought he was gonna pull up on the side of it. I mean, cause Tick over there punching them niggas in the face. And no, put a gun in their face like they don't even move. So,
Alright, man. No. This is the case in jail, right? You know that, right? Okay.
I froze up and I got scared like because man, I didn't think I had a like over here. I think I just be alone. I mean, it's hard for me. I got a job. I gotta get somebody to show me.
So, anything. It's cold. When somebody knows that you feeding them bull crap, the hand's not gonna be extended to help you. Okay? Look, brother, I'm with y'all all day. Plain and simple. Because my job is not to add you another status, city blind. I would not left you or your family or your girl or whatever out there in the bushes. But you pretty much, all that, pretty much told me to F off. I wanted to tell you. So how am I supposed to respond back to you on that, right? Okay?
You gotta give us something to go on to be able to help you. I've been telling you that.
From the get-go, I told you, I said, I'm here to prove that you have something to do with it. Help me out.
So you want me to testify?
Fine. Testify to what? He told you? Okay? You're secondary. He is first. Understand me? And the dudes who shot. They're up one, not you. If I get everything through them, it's leave me to pull you up. Mm-hmm. You hear me?
So this, what if I can get D to tell y'all?
That's fine. That's fine.
Whatever story you need to tell D. Since you and D so cool and D look up to you and you the big brother, I know I can tell D. Oh, I tell him 10 anymore. Exactly, you gonna get caught up, bro. Save me, bro. Help me. We know you told me this story. And D need to come in out here. Like I said, I ain't hard to get in contact with. This man ain't hard to get in contact with. But D gotta say something at this point. So whatever story he been lying to you, whatever story you need to feed him for him to come down here and tell the truth about it. So we can get this shit cleared up. Because it ain't about none of y'all. It's about nobody deserves to die. You know what I'm saying? About it is, man, it's a different story if I talk to you on the phone. You did. Like, a different story. Yeah, because one thing about he not going to hang up on me. I mean, it makes me all right with him on the phone, but you do so. I mean,
I tell you what, man. We do what we have to do. We set you up on a phone. It's not going to get you connected to the jail. We'll get you connected to a city phone, okay? How about that? You know, when we get everything set up, pull you do what you need to do. That you formulate up here your plan. And when you're ready, you reach out to Gator, you reach out to me. Say, I'm ready to see if I can get D to tell you what you need to know. I'm ready to know. Okay?
If y'all go and get D right now, and Brad, you pull him in here while I'm ready, I'll get D right now and let y'all know what's going on.
Okay, how about when we get everything together, we pull D and you in here together. So D can actually see what kind of personal situation all of us put you in.
Stopping at 6:09:18. Resuming at 6:11:11.
Just get out of the way.
It's getting out of the way.
Yeah, I'm gonna let you go. Is waiting on wait for him?
Yeah. So like I said, man, we're gonna take care of you. Make sure nothing happens to you behind there. Then we get everything set up. I'll be the first place you see. I'm gonna pull you out, put you in here that you need to do with D, either over the phone or in person. Okay? But everything gotta be done right and in a proper order. Okay? We can't skip an order. You know what I'm saying?
Gee, tell my with D, man. I just had to think about it. Like, I'm not sure I was at home. I mean, I know if I tell them, like, my vision, well, this and that, I mean, but they try to get you caught up in it, boy. I mean, but I just don't want to just say, oh, the phone just like tell, bro. I mean,
No, you wanna look the man in his face. Yeah. That's what I'm trying to help you. Okay? So like I said, but there's steps and procedures we have to do. And we can't skip not a single one. Okay? For obvious reasons. Okay? You say somebody shot up in a car. You say somebody pushed out my window. You say somebody told me to go help myself. This is a murder. Plain and simple. This ain't no drug rip. This ain't no money rip. This is a murder. Yeah. Okay?
so, all right. So, yeah, we gonna, with this with us, we gotta come up with a game plan. We gonna put our heads together, and when we come up with something, we know where you gonna be at. You ain't gonna be hard to find. You understand? And we still want you to stick with that full cooperation. But you gotta let us come up with a game plan. Like I said, if you're gonna be the quarterback, let us be the GMs and the owners and run the team. But you can't dictate what we're on. We set the plays out. So let us do our job. I got it. Yeah, top position.
Your Honor, this concludes the playing of the June 10th interview at 6:13:24.
All right. Thank you. I think this is a good time to break for lunch. Let's be back at 1 p.m., please. Thank you. All right, and Ms. Hilton, after the lunch break, do you have any more calls or things to play, or are you going to resume questioning?
Resume questioning, and then we're going to some jail calls.
Okay. All right. I'll see everybody back at 1.
Okay, I'm looking. Let me see. Kouri Richins starts at 11:30. Tellus doesn't start till 1:30 because they're in Vegas. So that's why I was watching Lil Woody there. You guys have any ideas? I guess we could check and see where they're at on Court TV. I'm looking, Jen, trying to find something good. Can't believe there's just nothing on. Let's see what Court TV is doing this morning. I can't tell who's on here because my thing says there's 0 people. Sure, I have it muted. Of course I do.
Accomplishments. And it was alleged during the first run of the criminal trial that Karen Reed had downed up to 9 drinks. This comes after the ruling on Friday by the judge in her murder case that she can be retried on all 3 charges. The defense wanted to get rid of those top charges. The top one.
Okay, I have to water the cats, so I'm going to do all my animal duties before court starts in 20 minutes. So I'll be right back.
Especially, but the top 2 that they claim the jury actually did come to a decision on, but Judge Beverly Cannoni sided with the state. So here's where we stand. Her new trial. It is now likely the defense is going to appeal that ruling by Judge Cannoni in terms of those top 2 charges. So that may get pushed. They did pull the trigger, though, on this wrongful death lawsuit. Let's bring in Denver, Colorado, Eric Faddis is a criminal defense attorney and former prosecutor. This move, what's your take on this move at this time? A lot of times the parties wait for the criminal process to finish. It gives them more ammunition. If the individual is found guilty, they are going now after Karen Reed, C.F. McCarthy's, and the Waterfall Restaurant. At this point, before the second trial, your thoughts on the strategy?
Yeah, Ted, like you said, it makes sense to bring it after a criminal case when there's actually a conviction, because then you have really a leg to stand on. You have all this additional evidence. You have some leverage and some momentum. Here, they don't exactly have that on the civil side, but it certainly makes sense to bring the claim. There is a lesser standard they would have to meet on the civil side. So even if the standard was not met in the criminal trial, they've got a better chance in the civil case.
And we saw that play out in the O.J. Simpson case years ago, where he was able to beat the murder charges in criminal court, but lost in civil court to the Goldman family. That it also might, because this has been so contentious, this case, from both sides. People have leaned into it. And by filing this, will this give the court of public opinion more ammunition, maybe, as the civil side of this track starts to push through? Because to your point, it's a different burden, but also there's going to be different discovery that will likely come in and be honed in on. Your thoughts on that, how it'll change the complexity of the area there up in Massachusetts, and frankly, the country, who's been following every moment of this case?
Yeah, I think there are a number of ways that it could change things. So one is on the civil side, you get opportunities to gather information that you don't always get on the criminal side. Karen Reed's attorneys and the prosecutors cannot serve a subpoena on someone and fully interview them under oath, whereas on the civil side they can. So I imagine there are going to be additional depositions. There are going to be additional what are called interrogatories and requests for admissions that are probably going to bolster the prosecution's case and could be used in the subsequent criminal trial.
And so this civil action can actually produce potential discovery that we could see in January or some point next year just by the process itself. Like if she's deposed, if the bartender at the waterfall or C.F. McCarthy, more information that then could likely come in, right, by the state, the Commonwealth would then have the green light.
Yeah, Ted, that's right. Take the bartender, for example. On the criminal side, there is no real legal mechanism to force him to give information before the jury trial in a criminal context. Whereas on the civil side, they could just subpoena him and question him about nearly anything under the sun and get that information that could add to inculpatory evidence that they might have against Karen Reed. There could also be what's called exculpatory evidence or evidence tending to indicate she's not guilty. So it really could change the game one way or the other.
What about timing? The civil case, just filed today. With your experience, would you think this takes? How long does it take? Let's think ahead. Is this landing sometime next year? Is it still years away from a conclusion? Most civil cases never sniff a courtroom. They're always pled out, and there's insurance companies involved, especially when you have three different defendants here. You've got two restaurants and Karen Reed. Give us a sense for the rules of the road and how things map out typically in the civil litigation.
Certainly. So usually the civil side kind of runs parallel to the criminal side of things. But on the civil side, there will be things that they cannot do as well. So if they try to depose Karen Reed, she still has a Fifth Amendment right to not incriminate herself with this subsequent criminal trial. So she might not give up any additional helpful information. And then in terms of a timeline, I'm wondering if they were coming up against a statute of limitations or something like that, such that on the civil side, they had to file the claim now and get things moving. But certainly attorneys in both of those arenas will be watching very closely what happens in the other and seeing how they can use it for their respective cases.
Yeah, makes sense. And I do think there's also a probably frustration level from the family after that, the mistrial the first time around, that they are seeking justice in each and every form. And there you see John O'Keefe, who is named as the lead plaintiff in the civil case. What, Eric, while we have you on this subject, is your take on this other issue that's playing out? Judge Cannoni says, no, this Commonwealth can still file the murder against Karen Reed, even though the defense seems to have very credible evidence. Commonwealth even also received communications from jurors that the jury had come to a unanimous verdict on 2 of the 3 charges, and that verdict was not guilty.
I think the judge could be on questionable grounds there, because even when there is a mixed verdict or a non-verdict and a mistrial, if the jury did come to a unanimous verdict on a number of the charges, that's the end of it. That's double jeopardy. She cannot, under the Constitution, be prosecuted again for crimes for which a jury ultimately found her not guilty. Now, was there a formal not guilty finding? There wasn't. And so the appellate court's going to have to wrestle with, hey, is there enough here the defense is showing us to throw out these top charges or not? Trial court judge said no. Appellate court judge, we'll see.
Yeah, and whoever was going to lose that first round likely was going to bump it up. So Judge Cannoni won't be the last word, one could assume. Now, we haven't heard that they've appealed it yet, but one would think that that is coming. So that January date is likely in flux for her retrial. She is out on bail during this time period. So for the defense, really time is on their side. The longer things drag out, the better for the defense. That's typically, you know, what the strategy, because everything fades over time, and including witness recollection, etc. Your take overall on this case, when you look at cases that they get some notoriety, they're out, you know, they're on court TV and people watch it for a little bit, and you see people get invested, you know, absolutely. Our viewers are invested in most of the cases, but this was different. This was different for so many reasons. The investment level is off the charts. You bring up Karen Reed and you're gonna have two different opinions with the exact same evidence. And people see it differently. What is it about this case, Eric, in your opinion, of why a civil trial a civil case has been filed? That's breaking news on court. Why? Because people are interested in Karen Reed.
Yeah, I hear you. And the case has been very polarizing, no question about it. You know, I think there's a lot of societal pressure on both sides now because it's such a well-known case. The police are saying, hey, we've got another shot at this. We've got to take it because everyone's watching us. And whereas Karen Reed's supporters are saying they're really going to go after her again after they essentially didn't win the first time. That's ludicrous. And so I think that, you know, a part of it comes down to perhaps the state overcharged it a little bit. Perhaps a mistake was made on Karen Reed's behalf, and perhaps that there's some stuff going on behind the scenes. So it's got so many moving parts: corruption, death, police departments, and I think that has really captivated really all of America who's watching this case.
Yeah, it is a fascinating case, and that's an understatement. So again, the breaking news at this hour: there has been a civil case filed against Karen Reed, also against C.F. McCarthy's in the Waterfall, those two restaurants where Karen Reed and John O'Keefe were drinking, and the O'Keefe family is filed a lawsuit against Karen Reed. Her trial date on the criminal side still set for January. We'll see what transpires as we continue to monitor that case. Let's get a break in here. Coming up, the closing arguments in the Robert Tellis trial set to begin within the next few minutes out in Clark County, Nevada. We'll talk about that as we get ready to watch the closings from both sides. Is he going to take over and do the closing himself? Strange things have happened. We talked about it last hour with Tommy Pope. It's a possibility. Stay with us.
In the world of true crime, the path from victim to verdict is never a straight line. Join me for a Court TV original series that takes you through every dark twist and turn, from the crime scene to the courtroom, in America's most compelling cases.
She killed my daughter, and he marries her.
Victim to Verdict with Ted Rollins, a Court TV original series. New season premieres September 8th.
Only on Court TV.
Storm 911, where's your emergency?
My wife had an accident. She's still breathing.
What kind of accident?
She fell down the stairs.
It's the story that's the focus of the Netflix series The Staircase. North Carolina versus Michael Peterson, a novelist accused of murdering his wife.
Kathleen was my life. I whispered her name in my heart 1,000 times.
You need to go and watch every minute of the entire trial on Court TV.
Let the games begin.
Yeah, baby.
Let's get some order. Oh, okay.
You know I got to get my dance on.
Hey, family. I'm coming back to this show. This is just fabulous.
I'm Marisa Giorgio, live from our studio in Missoula, Montana, and this is America Tonight.
Scripps News takes you ahead of the headlines.
We're reading between the lines there.
in time.
You need to go and watch every minute of the entire trial on Court TV.
Welcome back to Court TV Live. In just a few minutes, the judge will take the bench in the Robert Tellis trial, and then it'll be time for closing arguments. There's a live look inside the Clark County courtroom. Our cameras are there ready to roll. See the seal of the great state of Nevada as soon as they're up and running. We will head in. Tellis, of course, claims he's being framed for the murder of journalist Jeff German. He took the stand last week and gave his testimony in narrative style without being asked questions by his attorney. That was on direct. He had to answer questions on cross, of course. A key piece of evidence for the state is the cut on the defendant's hand. And he told the jury during day one on the stand how he claims that injury happened. Take a listen.
The Sunday after Mr. German was murdered, I learned, and I was shocked. I think that, it was unreal. Then the following day, I know there was testimony about, I'd like to see if, I know there's been an exhibit that's been admitted, and it's regarding a discussion between me and Roberta Lee. I don't know if we can publish that. That would have been a discussion, a text message discussion we had regarding the killer's SUV. It's a state exhibit. Correct. So when we were having that conversation, you might have, she had shared a picture of this SUV, and in the picture, in the comment above it, it said something along the lines of, the front rims don't match the back rims. And I looked at the picture and thought, oh, well, you know what, that's, okay, that's not, that's clearly not my vehicle. And so that's what I was, that's what I conveyed in the text messages that have been admitted. So I don't know if it's... This is the exhibit that you're referring to. Correct, which I would think you'd normally call it hearsay, but they've been admitted, so.
For the record, this is states exhibit 343 that's been...
Thank you, sir. Here, this General Bob Custer, I'm not sure who the gentleman is, but he says that the Las Vegas murder suspect vehicles have a different spoke pattern. Most vehicles have wheels with matching patterns. So when I saw that, I thought, oh, okay, well, obviously it's not my car because my rims all match. And so that was the substance of that conversation. But later, I thought, well, holy crap. Excuse me, sorry. I thought, my gosh, it still can't be a coincidence that the killer is driving a vehicle that's like mine. So I started to get really scared. Right? It couldn't seem to be any kind of coincidence that this person was driving a vehicle that was just like mine. Thank you, sir. And so I went outside, just double check, make sure I'm not losing my mind. I looked like, okay, well, my rims match, okay. And so I went ahead and started washing the cars, trying to just take my mind off things, and I washed the 3 cars, but there's been a debate about whether or not law enforcement knew 1 or 3, and that is what it is. That night, after dinner, I started making, cooking for my daughter's lunches. My one particular daughter, she won't eat the school lunch, or she didn't at the time. So I'd make her chicken fried rice off of a Google recipe. And I was distracted, and while I was distracted, I inadvertently cut my finger. And I cut it across the tip of the finger, right? And if you look at the picture, it was, I don't know if we need to bring the picture up or not, but is that something we should do, or? So basically, you'll see that it may be difficult to see, but the way that I cut it was as I was chopping right across the tip. I don't know what
I don't mean to interrupt, because we do have a photo that was a state.
Oh, okay. Sure, please. While I was being self-represented, I attempted to seek these surveillance videos that included the video of me washing my car, or videos of me washing my cars. The judge granted the production of that. However, I never received the videos. And oh, okay. So
The motion to strike is granted.
I believe the videos show that I didn't have the finger injury. If you think about it, if somebody has a serious finger injury, would they be washing?
Objection argumentative.
I mean, I would not be washing.
Testify about your own experience.
Sure, Your Honor. I believe I would not be washing my 3 vehicles if I had a serious finger injury. And as you've probably already gathered, you're going to hear about the fact that I was at the gym at around noon. And I believe I would not be working out with a serious finger injury.
All right, well, who knows what the jury's going to believe. Eric Faddis is watching along with us. This was such a unique trial. He took the stand. It was narrative style where it wasn't question and answer on direct. And boy, he talked and talked. What's your overall take as we get ready here for the closing arguments?
In my opinion, Ted, Mr. Telles kind of has this misplaced confidence. Like he thinks he's deserving of it, but I'm not sure anyone else does. And so he thinks he's talking his way out of this stuff. I guess he had this cut and allegedly used super glue to repair it instead of, going to a doctor where it would be documented and that kind of thing. So it sounds like he's sort of thought through ways to kind of slither out of all of these facts that appear really damning against him. And I just can't help but think the jury's going to see through that.
Yeah, one would think that this does not look good for him after the 2+ days on the witness stand. At one point, the prosecutor asked him on cross, because he's alleging this massive conspiracy where he was set up, where they came into his house somehow and they put the cut-up hat in his garage, and then they put the cut-up shoe underneath his sofa. And the prosecutor said, well, if that was going on, why didn't they put the murder weapon in your house? Take a listen to what he said.
I got a question for you. If the Las Vegas Metropolitan Police Department wanted to frame you, why didn't they put the murder weapon in your house?
I think that maybe, I don't know. I mean, it's a good question.
Great question, because if the murder weapon that had Gehrman's DNA in it was inside your house, wouldn't that be an even better case?
Yeah, but at the same time, I think
But it's not there, is it?
No.
No, it's not. Even though, according to you, they control everything, they don't put the murder weapon on you?
Mm-hmm.
Does that make any sense?
I think it does.
Okay. How about this? If Compass Realty wants to kill you, why don't they encourage Metro, like, we'd really like you to put the murder weapon in there? Why didn't they do something like that?
I don't know.
That seems really odd that the most significant thing is not in your house.
Yeah, pretty good questions there, and not a lot of answers. And whenever Telles would get to that point, like with the fingernail argument, why is your DNA underneath Telles's argument? He would say, I don't know. I didn't do this. You're like, I'm upset too. You think you're mad? Imagine me. I'm over here just like, well, I don't know what's going on. And he's like missing this sort of filter where maybe he believes it himself.
Yeah, Ted, that could be that he's convinced himself of this, but that prosecutor put on a clinic in cross-examination, and that is why we have it, to try to challenge representations that other folks have made that might have some holes in it. And this prosecutor poked a good number of holes in that. Tellus is claiming that this was some professional hit, but the guy was wearing this massive Raiden-style hat and this orange shirt, and it just kind of fell apart when he was challenged by that prosecutor.
Yeah, we understand Robert Draskevich is going to deliver the close. We were speculating maybe this morning, maybe Tellis is going to get up and give his own close, but his attorney will do the close. What do you say if you are delivering a closing argument on behalf of this guy that has just been on the stand in a way that you could argue 80, 90%, maybe 100% of the jury didn't believe a word he was saying? Do you get up and parrot what he was telling the jury? Do you keep it more midstream? How do you accomplish closing without offending?
I think no matter what, you have to address your client's testimony. And one way to do it is to kind of say, hey, you don't need to like Mr. Tellis, and you might have some issues with him, and that's okay. But we don't convict people because they're unlikable or arrogant on the stand or because they misremembered something. We only convict them in this country if the prosecution can really bring the evidence. And then you really have to try to challenge that evidence, provide plausible, innocent explanations that are alternatives to what the prosecution has provided, but in this case, that's going to be a tall order.
Indeed, and we'll watch it all play out. The state will go first, then the defense, and then the state, of course, will have the last word with the rebuttal close all getting underway in the next few minutes. The parties are starting to assemble at the courthouse. This is a live look inside the courtroom. We're expecting the defense to go about 45 minutes, both sides, and then the combined prosecution argument about the same. So, boy, it's going to be fascinating to see what the defense says. We know what the state's going to say. They're going to regurgitate all the evidence against Robert Tellis. We'll watch it all unfold next.
Storm 911, where's your emergency?
My wife had an accident. She's still breathing.
What kind of accident?
Still downstairs.
It's the story that's the focus of the Netflix series The Staircase. North Carolina versus Michael Peterson, a novelist accused of murdering his wife.
Kathleen was my life. I whispered her name in my heart 1,000 times.
You need to go and watch every minute of the entire trial on Court TV.
8 hours of back-to-back true crime cases every Saturday.
This is crazy.
On America's original true crime obsession. 48 hours on Court TV. Saturdays starting at 4/3 Central on Court TV.
It's really important.
I'm not sure why, but Las Vegas always starts court late. Sucks.
approach, Your Honor?
Sure.
Thank you.
All rise, grand jury, please, jurors.
Okay, good morning, ladies and gentlemen. Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, at this time, ladies and gentlemen, I am going to instruct you on the law. Officer Hawks is handing out the jury instructions. Each of you will have a copy of the instructions. You'll be able to take them with you when you go back to deliberate upon your verdict. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Instruction number 2, if in these instructions any rule, direction, idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number 3, an indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged an indictment that on or about the 2nd day of September 2022 within the County of Clark, State of Nevada, contrary to the form, force, and effect of statutes in such cases made and provided, and against the peace and dignity of the State of Nevada, the defendant committed the crime of murder with use of a deadly weapon, victim 60 years of age or older, as follows. Did willfully, unlawfully, with malice aforethought, kill Jeffrey Gehrman, who was 60 years of age or older, with use of a deadly weapon, to wit, a knife, by stabbing the said Jeffrey Gehrman multiple times about the body, the said killing having been 1, willful, deliberate, and premeditated, and or 2, perpetrated by lying in wait for the said Jeffrey Gehrman, and or 3, perpetrated by abuse of an older person. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of the offense charged. Number 4, murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Number 5, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from an unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief, or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. Number 6, express malice is that deliberate intention unlawfully to take away the life of a human being which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all of the circumstances of the killing show an abandon, and malignant heart. Number 7, the indictment alleges alternative theories of murder of the first degree, as allowed by law. In addition to willful, deliberate, premeditated murder, the indictment alleges the defendant committed the murder by means of lying in wait and or by abuse of an older person. Number 8, one theory of murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder under the theory of liability. Number 9, willfulness is the intention to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. Number 10, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action, considering the consequences of the actions. A deliberate determination may be arrived at in a short period of time, but in all cases, the determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. Number 11, premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Number 12, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Number 13, another theory of murder of the first degree is murder perpetrated by means of lying in wait. The elements necessary to constitute lying in wait are watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily injury upon such person or killing such person. Nothing requires that the lying in wait exist for or consume any particular period of time before the act which causes the death. It is only necessary that the act causing death be preceded by and the outgrowth of lying in wait. Where a killing is accomplished after lying in wait, the state is not required to prove premeditation or deliberation. The killing constitutes murder of the first degree so long as it was committed with malice, either express or implied. Number 14, another theory of murder of the first degree is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of abuse of an older person is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate abuse of an older person must be proven beyond a reasonable doubt. Number 15, any person who abuses an older person is guilty of abuse of an older person. Abuse means willfully causing unjustifiably pain or injury or mental suffering to an older person. An older person is defined in Nevada as 60 years of age or older. Number 16, although your verdict must be unanimous as to the charge, you do not have to agree on the theory of guilt or liability. Therefore, even if you cannot agree on whether the facts establish the defendant is guilty of willful, deliberate, and premeditated murder, murder by means of lying in wait, or felony murder by means of abuse of an older person, so long as all of you agree that the evidence establishes the defendant's guilt of murder in the first degree, your verdict shall be murder of the first degree. Number 17, all murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation, nor by means of lying in wait or by means of elder abuse. Number 18, you are instructed that if you find the state has established that the defendant has committed first degree murder, you shall select First-degree murder is your verdict. The crime of first-degree murder includes the crime of second-degree murder. You may find the defendant guilty of second-degree murder if, 1, you have not found beyond a reasonable doubt that the defendant is guilty of murder of the first degree, and 2, all 12 of you are convinced beyond a reasonable doubt the defendant is guilty of the crime of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or of the second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Number 19, you are instructed that if you find the defendant guilty of first or second degree murder, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting with use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Number 20, deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. 21, the state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Number 22, in arriving at your verdict in this case as to whether the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. If your verdict is murder of the first degree, you will, at a later hearing, determine the issue of penalty or punishment. Number 23, to constitute the crime charged, it must exist a union or joint of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 24. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life if the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. Number 25, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the way to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Number 26, in this trial, you heard evidence of other acts regarding the defendant, Mr. Tejas, in the articles written by Jeff Gehrman. You are not to conclude from this evidence the defendant is a person of bad character or is predisposed to commit crimes. Number 27, the credibility or believability of a witness should be determined by their manner upon the stand, their relationship to the parties, their fears, motives, interests, or feelings, their opportunity to have matter to which they testified, the reasonableness of their statements, and the strength or weakness of their recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony which is not proved by other evidence. Number 28, witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give an opinion expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which the opinion is based, and the reasons for each opinion. Opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proven or has been disproved, you may consider that in determining the value of the opinion. Likewise, you must consider the strength or weaknesses of the reasons on which it is based. You are not bound by any opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. Number 29, although you are to consider only the evidence in the case and reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 30, during your deliberations, you're not to communicate with anyone in any manner regarding the facts and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You're not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You are further admonished not to conduct any investigation, test a theory of the case, recreate any aspects of the case, or in any other manner investigate or learn about the case on your own. Number 31, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation and will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence, these written instructions, and forms of verdict prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 32. Now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. The state may open and close the arguments.
Thank you, Your Honor. Morning. By June of 2022, Jeff Gehrman had caused a lot of problems for the public administrator, Robert Tellis. He had written articles accusing Mr. Tellis of an inappropriate relationship. He had written that he was bullying in the office and had created a hostile environment in the public administrator's office. He had written an article saying that the management of Mr. Tellis was so bad that the county had to bring in a private consultant in order to assist with the management of an 8-person office. After Mr. Gehrman wrote those articles, Mr. Tellis lost his primary race and would not be the public administrator after that. And not just that he lost the race. He lost the race to a rival within the public administrator's office itself. And from the text messages of Mr. Tellis, we learned that this was deeply, deeply troubling for him. He wrote to Mr. Gehrman, "I don't know what to say. I told you how much this all impacted me. You heard from employees who are being harassed by these people, provided you," I think this is a typo, "proof that I was doing my best to actually smooth things over. I had to make hard decisions. Still, you wrote an article that makes it sound like I'm the guilty one. That wasn't fair or balanced." He told Mr. Gehrman, "I'm distraught right now. Clearly there are typos in my message." He told Mr. Gehrman that he was adding to the pressure of his life. "I've done so much for that office. I've told you that I've been followed and that I caught Rita following me. You decided to take it on her word that she wasn't. However, clearly she was. It seems to me that you valued sensationalism or the value of a potential takedown than actually telling the truth. Thank you for helping him drop more pressure on my life." Now, Mr. Gehrman's response was a response that you get probably from many reporters. He says, "Sorry you feel that way. My editors and I feel the story is fair and balanced." Mr. Tellis's response, "I don't know that you could truly feel that. You have concrete proof I provided you of what is really going on. You acknowledge much of it. You mention none of it. If telling yourself that you were fair helps you sleep at night while you're trying to destroy good people, that's your prerogative." And Mr. Tellis does attempt to fight back from these articles. On his campaign website, he posts this letter discrediting the paper and discrediting the allegations in those articles written by Mr. Gehrman. He goes on Twitter and he accuses Mr. Gehrman of being a bully. He says Mr. Gehrman had threatened him. He told other people on social media in this first screenshot that because of those articles, I had to increase my medication to cope with it all. He tells someone who reposted the article or sent it that he was deeply disappointed that they had done that. And he's generally following the fallout of those articles on social media. But the reality is he lost that primary election after those articles were written, and he attributed it to the articles written by Jeff Gehrman. He told his best employee, Nicole Lofton, "Unfortunately, too many people bought the lies." He told his best employee, Nicole Lofton, "I'm so sorry. I'm devastated that everything we worked for is going to be done. I hate them and what they did." And after all that happened and losing the primary, his concern was that another article might be coming. He explains, "I'm going to pull the trigger on the supervisory changes. I'm going to go with the original plan. I think if I do any more than that, they will say I'm interfering with operations." And then he added, "She is probably trying to get fodder to pass to the reporter." And he sent another text after that there's more garbage being gathered for a news article. And Mr. Tellis testified to you that after the primary took place, he actually half drafted, he didn't file it, a lawsuit where he was going to sue his rival, Rita Reid, and he was going to insinuate in that lawsuit, coincidentally, that there was a conspiracy that caused his problems in the election. If you look at point 21, he wrote, "Upon information and belief, several employees conspired to make false allegations of mistreatment by Mr. Tellis. These employees contacted the Las Vegas Review-Journal to share false and defamatory statements in support of news articles against Mr. Tellis." So he was clearly incredibly upset that those articles were written and that it resulted in him losing that primary. In July, Jeff Gehrman, though, isn't done with his stories and his examination of what is going on with Mr. Tellis and the public administrator's office. In July, he sends that request for the public records of the county, where he's asking for communication between Mr. Tellis and Roberta, and then ultimately it expands to other individuals in the county. but he wants all team messages between Mr. Tellis and Roberta. He wants cell phone messages. He wants essentially all of their communications as of July, and that's after those 4 articles were written. Mr. Tellis, of course, is informed by this, informed of this request by the county, and this occurs on August the 8th, and they explain, hey, look, this reporter's seeking all of this information. So the message underlying all of this is another article is forthcoming. Mr. Tellis messages back that he wants to review those communications prior to them being released to the reporter. But as of August 8th, he's on notice of another article coming. And if you look at this email, he responds about 20 minutes after that first email was sent to him. Now, looking at the August calendar, you can see that on August the 8th, that's when he receives the notification of the public records request. And by August the 12th, there are images from Google Maps of Jeff Garriman's neighborhood, Bronze Circle. We don't know the date they were created, but we know they were modified by August the 13th, meaning they had to be created sometime before that. Now, this doesn't mean that Mr. Tellis physically went to Bronze Circle on the days leading up to the modification date of the 13th. It simply means that he went and accessed Google Maps, and Bronze Circle is the area that was searched and accessed by his phone. And those images are, of course, where Jeff Garriman lives. Now, the next date to keep in mind in our series of events in August of 22 is August the 15th. In August the 15th, that is when there's images of all of those cars that are kind of driving along the access road to Jeff Garriman's neighborhood. Now, once again, we have a modification date. That doesn't mean that the images were all taken on the 15th, but they had to exist before the 15th to be modified on that date. And if you recall, Detective Gaddis figured out where this was, and it's right off of Mr. Garriman's neighborhood. His house is right here on Bronze Circle, and she figured out by looking at the photographs where it was located in Las Vegas. And she figured out it was located right at this Popeyes parking lot, and that slanted wall ends up being in almost all of the images. And there are a lot of them, of several cars driving by the access road to Mr. Garriman's house. So we have the notification on the 8th, we have accessing Google Maps on the 12th, we have those screenshots of all of those vehicles in conjunction with Mr. Garriman's neighborhood by the 15th, and then by the 23rd, there have been searches of Mr. Garriman's personal information on Mr. Tellis's computer. This is Mr. Tellis's work computer at his desk. If you look at the screen on the right, you can see like there's a bottle of hand sanitizer, there's an arrow pointing to it. Here's a closer view. And the screenshots from his phone, you can see that the same cap to that bottle is in the screenshot as well. So these were clearly taken on his work computer while he was at work. And you can see that he's looking up personal information of Mr. Garriman, the kind of car he drives. He ultimately is able to get the address of 7216 off his work computer. And once again, those photos were in existence by August the 23rd of 2022. So all of those events, the notification, the accessing of Bronze Circle on Google Maps, the screenshots of the car, and then using the work computer to access personal information of Jeff Garriman all occurs in August of 2022. Moving to September, that's when Mr. Tellis, on September the 1st, receives notification that the county is getting ready to release all of those documents that were subject to the public records request. He's notified, and Ms. Kennan is notified on September the 1st. of 2022, and the murder's the very next day. It's about 15 hours later. Now, we know that on the morning of the 2nd, Mr. Tellis left his house and proceeded into the area of Mr. Garriman's neighborhood, and that he kind of meanders around there, but ultimately ends up on those cross streets and then proceeds on foot to Mr. Garriman's residence. Mr. Tellis's residence is at the top of the screen there on Spanish Steps. He goes down that Silk Tassel Road and then goes on Red Hills Road. And he leaves at 9:12 in the morning. Now, eventually, he's in the area of Rock Springs Drive, which is near Mr. Garriman's neighborhood. The time on that video is incorrect. It says 9:42 a.m. But you heard from Detective Mogg that the corrected time for that particular camera is 10:26. So he's in the area of Mr. Garriman's neighborhood at about 10:26 a.m. in the morning. What's the next thing that happens? Well, you know that this is Mrs. Tellis's Apple Watch, and she sends that message to Mr. Tellis at 10:35 a.m. You can kind of see it says Friday 10:35 a.m. And the message is, where are you? Well, he's sitting in Mr. Garriman's neighborhood, so he's not answering this text message. That text message goes unanswered. Mr. Tellis at 10:40 a.m. is now on Wintergreen Drive, which is the cross street to Bronze Circle. He's on Wintergreen Drive at about 11 a.m. and the murder itself takes place at about 11:18 a.m. Then Mr. Tellis is back at his own neighborhood by 11:51 a.m. And this is video from that Piggott Elementary School, which Detective Mogg indicated that that timestamp is correct. And what does he do? He gets back at 11:51 a.m. and then he's able to get his BMW and proceed to Planet Fitness. So there's his BMW leaving. It's 12:03, and then you know from Detective Gaddis's testimony that it's about a 4 to 6 minute drive. He's able to be at Planet Fitness by 12:09. So by 9/3, which is now the day after the murder, it has been reported that Jeff Garriman has been murdered. And then Roberta, who's working, has heard about the murder, and she's starting to get concerned. She tells Mr. Tellis, I'm working tomorrow now. I don't want to be in the office alone. I'd rather be with the crazy women than alone right now. She's concerned about Mr. Garriman getting murdered, and she's scared about being in the office alone. By September 5th and 6th, the Las Vegas Metropolitan Police Department has released images of the assailant and also of the Yukon itself. And Roberta becomes even more concerned. She messages Mr. Tellis, Rob, WTF, please do not be driving your Yukon around for a while. This is on September the 6th. He answers, whoa, that's crazy. She says, please tell me your Yukon is not that color. He answers, it is similar, if not the same. She says, I'm freaking out, Rob. He answers, my car has all matching wheel patterns. I think they are saying that there's a difference between the front and the back of the assailant's vehicle. But Roberta looks at it and says, fuck, your car is identical. And it actually turns out that Roberta is the one that is correct. His car is identical. From that lighter spot on the passenger side, just below the windshield wiper, there's sort of like a lighter rectangular shaped portion of the car. You can see that in the video. From the differentiating tint between the front and the back of the vehicle, that part is identical. And from the wheels themselves, they weren't different. They were the same. The wheel rims on the front and the back are identical. It is his Yukon. He is the one who committed the murder. So let's talk about the charge of murder. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. And all that means is an act of ill will. When you go back to deliberate, you'll be asked two overarching general questions about the crime. And those are, was a deadly weapon used in the commission of the crime? And was the victim of the crime 60 years of age or older? So as you heard from Judge Levitt, a deadly weapon is simply an object capable of causing substantial bodily harm or death. We obviously have that in this case. The knife wounds inflicted on Mr. Gehrman were definitely not caused by human hands, and they were capable of causing substantial bodily harm or death, because that's ultimately what happened. You may be asking, well, where is it? Like that knife didn't come to court. But the instructions tell you that the state is not required to have recovered a deadly weapon used in an alleged crime or to produce it at trial. You just have to be able to gather from the evidence that a deadly weapon was used. Obviously, the injuries of Mr. Gehrman indicate that this was not caused by human hands. A deadly weapon was used to accomplish his murder. So that overarching question about the crime is probably an easy one to answer. Probably the easiest one after that is, was Mr. Gehrman over 60 years old at the time the crime occurred? And he was 69 years old at the time it occurred. So let's talk about first-degree murder. As Judge Levitt explained to you, there are three theories, three pathways that you can reach a verdict of first-degree murder. The first one is a willful, deliberate, and premeditated murder. The second one is murder perpetrated by means of lying in wait. And the third one is murder perpetrated during the course of elder abuse. Now, the first form of first-degree murder is probably the one you're the most familiar with, and that is a murder that is willful, deliberate, and premeditated. And you'd have to find all of those elements in order to find Mr. Tellis guilty under that theory of first-degree murder. So let's talk about what each of these mean. Willfulness is very simple. It's simply an intent to kill. Do your actions demonstrate an intent to kill? So this part of the video takes about 2 minutes. The entire time of that 2 minutes, Mr. Tellis is attacking Mr. Gehrman with a weapon. So that demonstrates an intent to kill. He's stabbing him repeatedly. Mr. Gehrman is clearly trying to fight back, but Mr. Tellis doesn't stop. It keeps going and going and going. And it's kind of a long time to be inflicting injuries on another individual. He finally walks out on the side. But the duration of that time, the entire time, Mr. Gehrman is being attacked. So let's talk about deliberation, which is the second element. Deliberation is determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action. Well, what do we know about Mr. Tellis's actions prior to the murder? Well, we know back in August, when he got notification that another story was likely coming, he kind of goes into research mode on Mr. Gehrman, where he's located, what kind of car he might be driving, searches on his computer. All of that demonstrates deliberation. Even if you didn't have all of these actions back in August, the length of time of the actual attack itself is sort of a shorter version demonstrating a course of action to kill, right? In the course of 2 minutes, you were stabbing someone multiple times, you could change your mind, but he doesn't do that. He keeps going and going and going, not even withstanding all this pre-planning. Now, premeditation is the last element of that first theory of first-degree murder, and that is simply a decision to kill before you do it. Before you came in and sat as jurors, you may have thought that premeditation is always a case of pre-planning and months in advance and that sort of thing. And that is definitely a case of first-degree murder and kind of exactly what we have in this case. But you're told by the instruction that premeditation need not be for a day, an hour, or even a minute. It can be as instantaneous as successive thoughts of the mind. So what that instruction tells you is, in the law of Nevada, for premeditation, if I make a decision to kill you and I do it a month from now, that's premeditation. If I make a decision to kill and I do it a week from now, that's premeditation. If I do it an hour later, it's premeditation. If I do it a minute later, it's premeditation. If I do it a second later, it's still premeditation. And you have a video of the attack on Mr. Gehrman, and clearly there's a decision made to kill him. But beyond that, you also know that Mr. Tellis took the step of leaving his phone at home prior to the murder. That's indication of premeditation and planning. You know that he bothered to disguise himself by wearing the hat and the orange outfit. That shows premeditation, a decision to kill. And you also know, most of all, that he brought a weapon over to Mr. Gehrman's house, and that shows premeditation as well. So that theory of first-degree murder has been established in this case. Let's talk about the second theory of first-degree murder, which is murder perpetrated by means of lying in wait. And the instructions explain what that is. Another theory of first-degree murder is murder perpetrated by means of lying in wait. And what that is kind of taking on a place of concealment in order to inflict injury or death upon another person. It's sort of the second paragraph. It says, watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily harm upon, or serious bodily injury upon such person, or of killing such a person. And in this case, you actually see the actions of Mr. Tellis literally lying in wait. He goes into Mr. Gehrman's yard and recedes to the back in order to be in a place of concealment in order to attack him later on. And that is literally lying in wait. So that theory of first-degree murder is established as well. The third theory of first-degree murder is murder occurring during the perpetration of abuse of an older person. And this is kind of like the like child abuse, where if you abuse a child and a child happens to die in the course of abuse, it's automatically first-degree murder. The same is true for individuals who are over 60. If you abuse an older person and they die during the course of that abuse, that is an automatic case of first-degree murder. And it's sort of a policy judgment to protect vulnerable members of our society. The instructions tell you another theory of first-degree murder is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of an older person is deemed to be murder of the first degree, whether the killing was intentional, unintentional, or accidental. We have that in this case. Mr. Gehrman was over 60 years old, so by abusing him and causing his death, it is automatically another theory of first-degree murder. So this is a picture of the verdict form that you'll have back in your deliberation room, and you can kind of see on the top in all caps it says murder with use of a deadly weapon, victim 60 years of age or older. That was those very first two questions I discussed with you at the beginning of the closing that you would answer as jurors. And then as a jury, you should ask about the individual theories of first-degree murder and vote on them. So you have to vote if all 12 of you think that this was a willful, deliberate, and premeditated murder. Do all 12 of you find that it was perpetrated by means of lying in wait? Do all 12 of you agree that it was perpetrated in the course of abuse of an older person? If you find all of those, then you mark those boxes. If you are in disagreement, say only 3 of you think it was willful, deliberate, and premeditated, or some combination, you have to take a vote to decide if all of you believe that it's first-degree murder under some theory. And if it is, you mark that last box and say, we don't find unanimously under any of those 3 theories, but all of us agree, 12 of us agree that it's some form of first-degree murder. The law tells you, although your verdict must be unanimous as to charge, you do not have to agree on a theory of guilt or liability. So if all 12 of you agree one form of first-degree murder, then you mark that last box. But it's the state's position that all 3 of those theories, willful, deliberate, premeditated, lying in wait, and elder abuse, clearly apply in this case. And really, Mr. Tellis isn't disagreeing that this is a case of first-degree murder. He's just saying that it was a Compass Realty assassin who did it. Now here we see Mr. Tellis leaving his house at about 9:12 a.m. And it's the state's theory, of course, that at that point he's left his house and his cell phone is sitting back at his house on Spanish Steps. The state's theory is that Mr. Tellis leaves his residence, leaves the phone at the residence, and is proceeding to Mr. Gehrman's residence. And as we've discussed, the Yukon is seen at Rock Springs at about 10:26 a.m. Here's 2 different images of it. Meanwhile, Mr. Tellis's cell phone, which is sitting back at Spanish Steps, is getting some incoming messages. There's an incoming and unanswered message at about 9:44 a.m. about a work case. There's an incoming and unanswered message at about 10:16 about another case at his work. There's an incoming unanswered message from his wife saying, "Where are you?" at 10:36 a.m. Now you'd think, given that some of the allegations in the articles, this might be one he'd answer pretty quickly. There's an unanswered incoming call from his wife at 10:43 a.m. that doesn't get answered by him. And there's another incoming call that occurs at 11:16 a.m. Meanwhile, he is at Mr. Gehrman's house. So ask yourself this. If this was really a Compass Realty assassin who was committing the murder at Bronze Circle, how would that individual know that Mr. Tellis, with his phone at his house, wouldn't have answered a call, or wouldn't have gotten in another text string, or wouldn't have made a call himself? How could anybody but Mr. Tellis be the killer? No one would have that level of assurance, because if any of those calls had been answered from his house, it would be clear that he wasn't the one involved. Now we know from the video evidence from Bronze Circle that after the murder occurs, Mr. Tellis actually returns to Mr. Garriman's house, and he goes to the side area of the yard where Mr. Garriman is located. And then he returns back to the Yukon. And eventually does that U-turn and drives away. But if you're wondering why there isn't blood in the Yukon, he had to walk all the way out of that crime scene, and anything that had been deposited on his shoes would have come off in the rocks. Besides that, the crime scene itself is not drenched in blood on the ground. These are Mr. Garriman's shoes. There is some blood on them, but they're not exactly drenched, and he's the victim. So after Mr. Tellis leaves Bronze Circle for the second time, he goes east, he goes on Wintergreen, he goes on Washington, he goes on Rampart, he goes on Apple, and he goes back to his neighborhood at 11:51, and then he leaves again to go to Planet Fitness at about 12:03. You also know that Mr. Tellis is the killer because of the DNA evidence in this case. Remember how this comes into play. They collect the samples from the scene, and the Metro DNA analyst has this result of foreign DNA being present on September the 5th. They haven't even collected a DNA sample from Mr. Tellis until the 7th. So it's not like Metro or Compass Realty has a sample of Mr. Tellis's DNA to come insert in this crime scene. It's Mr. Tellis's DNA in this scene. It's literally on the body of Mr. Garriman. The items from the search warrant also tell you that Mr. Tellis is the person responsible for this crime. Those shoes that were found in the house, they weren't planted, they were hidden. They were cut up. Anyone who planted the shoes would have no reason to cut them up. The cutting up is to benefit Mr. Tellis so he can get rid of them. If you were just planting them, you could leave them alone. And they're clearly his shoes because, one, they're in his house. Two, his DNA is present on them. And if you don't believe that, there's pictures in his phone of those shoes on a day when he apparently went rock climbing. You have the bag that was located, and ultimately the hat as well. And you heard a lot of testimony about how all of this evidence was collected from the scene. There's the detective who physically finds it, working with other detectives who are also doing the search. There's the detective that's assigned to be the scribe, to write down where everything is located. There's a crime scene analyst assigned to photograph it in place. There's DNA analysts who actually analyze the physical evidence after the fact. And all of this occurred, this whole search occurred while his wife is sitting in the house and aware of what they're doing. None of this evidence was planted. There's the bag, there's the hat, that was the location of the hat in his house. Finally, you know from the searches, the Bronze Circle, where he accessed the Google Maps of Mr. Gehrman's house, that he is the one responsible. He's not friends with Mr. Gehrman. He doesn't have business to do with Mr. Gehrman. There is no reason for images of Bronze Circle to be in his phone prior to the murder occurring. You also know that he is the one responsible from the sort of amateur surveillance that occurred in August prior to the murder itself. There's no reason for any of this to be in his phone, but that he's attempting to gather information on Mr. Gehrman. And finally, you know he actually used his work computer to gather information on Mr. Gehrman as well. At the end of his testimony, I think yesterday, Mr. Tellis explained that he's really a victim in this. He's been victimized by the whole process, and he told you that he was wronged by his coworkers who didn't appreciate his changes that he made in the office and didn't appreciate his management style. He was wronged by the county who didn't understand that he was being a good leader. He was wronged by Zach Schilling, and by Kristen Riffle. He was wronged by them as well. He was certainly wronged, according to him, by Compass Realty. He was wronged by Steve Wolfson. He was wronged by the patrol officers who preserved that scene at Mr. Gehrman's house. He was wronged by Metro Police, in particular Detective Gaddis and Detective Jappy. He was wronged by some mysterious, illusory phone hacker. He was wronged by DNA analysts at Metro who found his DNA on the fingernails of Mr. Gehrman. And then, of course, he was obviously wronged by Mr. Gehrman, too, in the articles he wrote. Or maybe it's not that he was wronged. Maybe he's the one in the wrong.
Thank you very much. At this time, we're going to take a 10-minute recess. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary, do research, consult dictionaries, the internet, or reference materials, do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. We'll be in recess for 10 minutes.
Thank you all. Rise. Next speaker, please, George. come to order. Court is now back in session.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Fasquich, you may begin your closing argument.
Thank you. Am I on? Proof beyond a reasonable doubt. It's the highest standard in this country. It's not presumption, preponderance of the evidence. It's not clear and convincing. It's proof beyond a reasonable doubt. This concept was borrowed from the Old English common law. Our founding fathers thought that it'd be better to let it's better to let 10 guilty men go free than to wrongfully convict an innocent person. Additionally, I would submit to you, few people have the reason he'd be entitled to a verdict of not guilty. Let's talk for a minute what the state hasn't proven. And again, there is no burden whatsoever on that man. Jeff Garman DNA wasn't anywhere but at the scene of the crime. And this is significant because we heard a very able explanation of the state's evidence from their point of view. There was no blood or DNA evidence concerning Mr. Garman in Mr. Tellis's home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tellis. There had been discussion on the state's closing wherein there was blood everywhere in the, in the Bronze Circle address. Obviously, it was a stabbing. You can see through the exhibits that you will have with you in the jury room. There was blood everywhere, on the bushes, on the bird dish. Nowhere in Mr. Tellis's vehicle do we find blood. You recall the testimony, blood presumptive negative, on both doors on the driver's side, the seat belt, the brake pedal, the gas pedal, the mat, nothing. There was no blood on his person, clothing, anything else. You didn't hear from any witnesses concerning any personal knowledge to contradict Mr. Tellis's version of the events for September 2nd. There was not a positive identification of the subject vehicle or Mr. Tellis at the scene. There's no evidence whatsoever of any gloves being recovered. And you've seen, and it's fairly clear, from the video evidence that you've been presented, that assailant was wearing gloves. There was no recovery of a murder weapon. That vest with the reflective strips, you didn't see that. And the pants, I mean, we had pants that were recovered. You saw the blue pants. Obviously, that didn't bear any evidence to implicate Mr. Tellis. And I would submit to you that the facts and common sense would dictate that had he been the murderer, there'd be evidence of it on these articles, on that getup that that person was wearing on September 2nd. This is a point that I would urge you to consider, because I would submit to you that's crucial in determining whether the state, and again, it's the state alone that bears the burden, has proven their case against Mr. Tellis. There's no surveillance or eyewitness testimony showing that Tellis left his house that day headed to Mr. Gehrman's home. We did hear evidence, and it was uncontroverted, and that came through Detective Gaddis, that on the day of the stop, September 2nd, it's Metro policy to have body cam. The officers that stopped him in relation to the warrant that was obtained with Mr. Jappy's, Detective Jappy's participation, it was issued at 2 a.m. on the 7th. The officers that stopped Mr. Tellis, the officers that detained Mr. Tellis, didn't have the body cam on, and that was requested multiple times. Ultimately, there was an order from Her Honor on July 18th of 2023, and after that order. And you recall going through the cam, the reports, the CAD reports, there was intervention, but again, that key piece of evidence was overridden. It was destroyed. Again, is that indication of some wide-ranging conspiracy? And I'm not going to stand before you today and necessarily argue that there was. But what that shows is that Metro makes mistakes. Metro officers, Metro detectives are human. I mean, you think of the old proverbial idea of police officers, their brass buttons, blue uniforms. They're human beings underneath their titles, underneath their uniforms, and they're just like all of us. They make mistakes. That shows you that mistakes are made on behalf of Metro. And the Las Vegas Metropolitan Police Department is not infallible. Let's talk about Robert Tellis's blood, or the lack thereof, at the scene of the murder. You had seen some pretty good videos capturing that person leaving Jeff Gehrman's house after the stabbing. I would submit to you that it's the state's argument that Mr. Tellis cut himself through that incident. You heard his testimony. You are the sole judges of the facts concerning that. What we do have, in addition to the state's video, is we have this assailant walking away from the 7217 Broad Circle address. That finger was cut. That finger had been damaged by a knife or otherwise severely injured. Wouldn't there be blood? Wouldn't common sense dictate that there'd be blood in the bushes surrounding Jeff Gehrman's body, in the rocks which were recovered, in the sidewalk outside the house? Nothing. And again, it's the state's burden to present you every bit of evidence in their prosecution, and you should take into consideration the evidence that they've presented to you. But by the same token, you should take into consideration determining whether or not they have proved their case beyond a reasonable doubt, and they have the sole burden for the production of evidence. Ask yourselves what evidence is missing. Let's talk about Robert Tellis's body in relation to a struggle that the state would have you believe occurred between these two gentlemen. Recall the evidence that we had brought in during their presentation of evidence, and I believe a number of these pictures came through Detective Gaddis, and there's a lot. It's defense exhibits B through V. This is just kind of a capture of these photos, and there's a lot of them to evidence that there were no injuries to his body. Neck, front, And there's more, and we could stand here and click through each and every one, but we're not going to. You can look at them. You can ask yourselves, well, if there was this struggle, where are the markings? Where's the bruising? Where are the scratches? Defense exhibits B through V will demonstrate that there were no such injuries. Let's talk about the cell phone usage on 9/2/2022. You know, the state would have you believe that Mr. Tellis's lack of responses to junk messages mean that he was occupied with murder. And through analyst Aguero, you heard, and you had the opportunity to see through the course of this gentleman's testimony, it was uncontroverted. We went through the messages during the key hours, the key times of September 2nd. The vast majority of those messages were automated. They were spam. How many of us respond to spam? It wasn't like he had every person reaching out to him, family, friends, repeatedly. Where are you? What are you doing? It's not. The vast majority of those messages were of no significance. They were junk. Additionally, the state did not establish a pattern of phone use behavior which would indicate that Mr. Tellis's communication activity on that day was anything different than his normal behavior. They had the devices, they had the access. You heard no testimony that his accessing his phone, his using his phone on September 2nd was anything different than the day before, the day following, the weeks before, or the weeks following Mr. Gehrman's murder. And let's talk about the deleted messages. You recall that was quite a big point that was underscored and argued through the course of testimony, and it was actually through Mr. Aguero, our expert, the issue concerning this deleted message. And you recall then we had the subsequent witnesses in the state's rebuttal that came forward with and it was through Mr. Tellis's testimony. Do you remember the watch, the Apple Watch? Then there was questions asked, what about the other device that presumably these messages were being received on? We didn't get the benefit, and again, it's their burden to compare the Apple Watch with the Pixel phone. We didn't have that. But what we did hear from that detective is that he couldn't say one way or the other. Do you remember that question, where are you? Obviously, if someone's home, they can speak with one another. But we didn't hear and we couldn't hear any evidence. And for you to just make a judgment based upon their own expert, their own witness who has special training and knowledge, say, I couldn't say one way or the other whether that message was deleted on the Pixel device, the device that they have alleged was Mr. Tellis's phone, that's significant. Let's talk about what the state does have. They've got a cut-up straw hat and shoes. There's really no reasonable explanation, rational explanation one way or the other. Obviously, if this person's the murderer, why not get rid of the shoes? You'd have to presume that he had knowledge of the shoes and their whereabouts. Let's talk about that hat. Why wasn't that hat discarded? Again, we'd have to presume knowledge on the part of Mr. Tellis where that hat was. And again, neither the shoes nor the hat tied him to Jeff Gehrman's residence. We had a shoulder bag with balls in it. Do you recall that exhibit? We had a basketball and a football that looked like some sawdust, and you'll have all of these exhibits. What's going on with that? I guess you're to use your common sense, which is one of the latter instructions, and assume that this bag is somehow implicated in the murder of Jeff Gehrman. And then it winds up in a storage area in the family home with a basketball and a football and what I would submit to you looks like sawdust in the middle of it. The image artifacts from the cache of Robert Tellis's phone, as well as the vehicle and the address inquiries on Mr. Tellis's work computer, it was fairly clear through the course of the testimony that that work computer had access to the Google account that would presumably be accessed by his Pixel phone. If one has password to that, one can have access to the devices. Matt Havaness said that he could not say the date of the cached images on the files of Mr. Tellis's Google Pixel phone. We were shown a calendar. We were to draw inferences. We don't know specifically who accessed, who searched for those images, and we don't know when they were created. And I would submit to you that that's significant, and the state should explain that to you. On Defense Exhibit 03, Robert Tellis's user accounts on his Dell Omnipex located the Public Administrator's Office. Again, this is the report. You have it. This is Mr. Aguero's summation of his analysis. Again, it shows that this Google account, where these damaging photos and images are shown, it's the same. It's the same account. It can be uploaded, accessed by both the cell phone and the work computer. Obviously, we know what was going on from the testimony of multiple witnesses, what was going on at the Public Administrator's Office and the turmoil. I would submit that's something that you should consider and determine what the facts are and what the state has proven beyond a reasonable doubt. There is a positive DNA hit for Mr. Tellis related to Jeff German's fingernails. And you recall at the beginning of the state's presentation last week, you heard from the crime scene analysts, and I would submit to you that it was fairly clear that there was a little less than an airtight investigation because, after all, police officers, detectives, crime scene analysts make mistakes. Reference to the lab techs, Ms. Brown and Ms. Koljenovich, they were trainees at the time that they did this DNA collection and the processing for presumptive negative or presumptive positive blood evidence. This is significant. It was Claire Manning. She had testified, she was young, blonde. She had testified that she couldn't recall who bagged the hands. That was at the scene of the murder. You never heard testimony as to who initially bagged the hands of Jeff German's body. One would think, and common sense would dictate, that they'd be able to tell you that. They couldn't, not from a single witness. She testified that she took custody both of the fingernails and the evidence concerning Mr. Tellis, but again, she couldn't tell you who bagged the hands. Again, this Google search on the recipe, you heard that this the last day of trial, like that was somehow significant. Do you recall in the recross of the detective, there was at least 2 computers at the Tellis home that were not reviewed. They weren't checked for those recipes. So again, I'd submit to you, we have a wash. Detective Mogg, Christopher Mogg, he's now retired. He's an analyst, he lives in Texas. You recall at the beginning of this trial, he gave what appeared to be fairly detailed testimony concerning the whereabouts of the subject, Denali. Do you recall on cross, it was addressed that at 9:10, that vehicle was entering in from the Piggott Elementary. And again, you saw the map, it's in evidence. You can see that this right here is not the entrance to Mr. Tellis's neighborhood. It's streets away. It's not close. He gave you testimony that apparently he drove through the neighborhood where Mr. Tellis lived, off the Spanish Steps address. He said to look for things of evidentiary value. We heard nothing. We heard nothing concerning other vehicles in the neighborhood. Do you recall the testimony that there was at least 67 red Denalis? We heard testimony that that number at one point perhaps was greater, Perhaps it was at 67, which nobody contradicted, but we never heard what it was ultimately narrowed down to. We had Detective Mogg, and I'll refer to him as detective because in essence he still is. He testified and just said he was sure that it was that man's Denali, period. Do you recall the testimony that was shown concerning, and I would submit to you because you are the sole judges of the facts, that there was something peculiar about this Denali, something in the right-hand window area, that plastic stripping. You have the photos. Please look at them. We are given testimony based upon his analysis. We have at the same part near Piggott Elementary, we have this vehicle leaving at 9:12:32. But what's significant about the 9:10, where we see it entering the neighborhood or the area, again, it's not Mr. Tellis' specific neighborhood, we're not told where it was before that, who was driving it. What's important, and I want to back up, is at 9:10, we have this vehicle entering the area. And you have to ask yourself, what's occurring between 9:10 and 9:12? If we're to take the state, based upon the evidence that they have presented, what went on during that 2 minutes and a few seconds? We don't know. Did it even make it to the Tellis' house or some other other house in the area? But as to the 9:10, it's important because it's the state's theory, and we heard it argued that Mr. Tellis left his phone. Well, we have, and this is Defense Exhibit A3, we have that phone receiving messages. Look at the times all throughout the morning. We have that phone receiving messages 7:44, 7:45, 8:47. You can see, and this will be given to you. It's close to the cell tower next to Mr. Tellis' home. So then you have to ask, well, where was this vehicle? And I'd ask him specifically, did you follow this vehicle? Did you see this vehicle prior to the 9:10 time taken from Piggott? He didn't. But we can see, based upon the evidence that was provided to you by the defense expert, that phone is in the area all that time. It's in the Spanish Steps area. So obviously the argument, and I would submit to you, common sense would dictate, well, if that is going to Mr. Tellis' home and it's not arriving in that area until 9:10, why do we have all of these other pings at all of these other times close to the home, if not at the home? He laid out very specific detail, and he had talked about this approximately 5.3 mile trek that he wants you to believe was Mr. Tellis' vehicle, and that vehicle was occupied by Mr. Tellis. His video analysis takes 2 hours. It covers 2 hours and 39 minutes. The state couldn't show you what happened during that 2 hour and 39 minute period. 5.3 mile trip to and from. They basically show you closed circuit TV coverage, which it wasn't. There was a lot of dark spots of the vehicle driving there. But then the vehicle driving back, and I won't say it was driving to and from Tellis' home because we have no evidence of that. We're to believe the state that there's no ring cameras in a fairly affluent neighborhood. I'd submit to you, does that make any sense? What we're going to ask you to look at, and please do, you've done a lot through the course of this trial. It's your duty to be here, and you have fulfilled that duty. You've taken notes. Through the very last witness, it's been apparent that you've been paying attention, that you've maintained an open mind. Oftentimes we suffer, especially law enforcement, from what's called confirmation bias. You reach a judgment, sometimes early on in the case, and you work backwards to confirm what the judgment that you've arrived at the beginning should be at the end. And I would submit to you that that's what happened. This was the 1405 wintergreen. As you recall, there was an issue concerning the timing. This was channel 3, all right? This is State's Exhibit 372. You have that. You'll be given a laptop. Look at this. This was an image that was not part of his presentation to you at his testimony and during his testimony. This laptop has the ability to pause. It has the ability to zoom. Watch this. We're going to slow this down now. You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald. Look at the face. Look at the eyes. I'd submit to you that those look like glasses. And again, this is part of the evidence collected by the state. It's been presented to you. It wasn't addressed during their case in chief, and it wasn't explained by Detective Cliff Mogg. I'd submit to you, look at that image. There's hair. There's glasses. Now, the state, in rebuttal, and we'll address the significance of that, they have the opportunity to come and address what I've presented to you, but that's undeniable. What I'm going to show you next is the image on channel 2. That's the same video coverage, but now it has the vehicle coming from a different direction. It's parked. Do you remember the testimony from Mr. Martinez? I think it was John Martinez, of no significance. It was fairly unmemorable on that date. He said he saw the person. Nothing caught his attention because nothing was memorable. There's no talk of a disguise. Glasses, nothing. It's bland. Nothing was memorable. Take a look. Oh, hang on. That's Mr. Martinez that I discussed. Look at this image. Look at the profile. It's hair. We have two captures from two different angles. The profile does not match the profile of Mr. Tellis. And they're consistent. It's not open to dispute. You know, you've heard testimony, and you heard it primarily through Mr. Tellis. You heard it from Nicole Lofton. Mr. Tellis was fairly concerned about the goings-on with Compass Realty in relation to heirs, in relation to the trampling upon the legacy of heirs by the mismanagement of the properties that were left through intestacy. I would submit to you that Detective Jappy inserted himself into the murder investigation. And again, I want to draw, a couple of arguments from this Compass Realty testimony. I mean, we know that Mr. Tellis was very concerned about Compass Realty. He was the whistleblower. He was concerned about the actions of Compass Realty. During the 2 years that he's in custody, I mean, what would a man do? He's fixated on that. He's ruminating on that. I would submit to you that common sense would dictate, and your experience would dictate, well, he's going to focus on the involvement of individuals who he was focused on prior to his being arrested. I mean, really, what are his alternatives? And again, this goes back to the burden on the state and not the defense. What can you really do when he's locked up? He's going to focus on Compass Realty. It's easy to dismiss him as being crazy. Oh, that's Looney Tunes. But hey, he's been in custody for 2 years. He was worried about Compass Realty prior to being incarcerated. He was worried about the goings-on with the old guard, about his work at the public administrator's office for financial reasons he testified concerning, and you've heard testimony supporting that. Why wouldn't he continue worrying about that? Why wouldn't he keep thinking, well, I'm being framed, I'm being charged with a murder that I don't think I committed, I didn't commit. He's going to focus on what he was focusing on before he was arrested. We heard testimony from Detective Gaddis. Do you recall the exhibits, the information that was presented about the release on September 5th? The video release of that individual walking. They started getting tips. Do you recall the email that was in her 70-page officer's report where she had communicated with Detective Jappy predating that? The first communication that we have on record and that's referenced is September 4th. Detective Jappy, when asked, did you incriminate him? Did you give him, did you give her evidence implicating him in this crime? And he said, I gave her information. But then we heard from Detective Gaddis that she had a communication with him again on September 5th. And again, she was given motive. In Detective Jappy's mind, she was given motive to focus on that man and his alleged motive to kill Mr. Gehrman. So he wouldn't agree from the stand that he implicated Mr. Tellis, but to call a detective or to email a detective on September 4th, and then again on September 5th and say, look at this guy, he's got a motive to kill. How could it be anything but an implication? You heard crime scene investigator Baxter. Her testimony concerned the goings-on at the public administrator's office during the execution of a warrant on September 8th of 2022. Her testimony, and it was adopted by Detective Gaddis, she stated Mr. Jappy, she said Detective Jappy, was taking his own photos and collecting his own evidence during the search warrant at the public administrator's office on September 8th. And it wasn't a mistake, because it was asked to her on cross, and it was confirmed what she had said before you, the sole judge of the fact, by Detective Gaddis, the primary detective concerning this homicide investigation. We had heard testimony that Mr. Tellis, as a result of the warrant obtained by Detective Jappy on August 17th, 2022, that man was under surveillance. It appears until Detective Jappy inserted himself into this investigation, we had dual investigations, a short one and a much longer one concerning Robert Tellis. We know from Detective Jappy's testimony that he was exonerated. There wasn't this kickback scheme. He had been implicated by an agent who was a real estate agent who was a detective at the time. That provided to Detective Jappy in part the probable cause to get that warrant. So we have a member of Metro giving another member of Metro evidence, testimony, opinions about a kickback scheme implicating Robert Tellis. We also had heard through testimony that Compass had a direct line into the Public Administration Office. And again, I discussed Mr. Tellis as being incarcerated because I would submit to you it's understandable why he believes there's this wide-reaching conspiracy. What other options does he have in his circumstances, under these circumstances? We do know that the District Attorney's Office refused to pursue action against Compass Realty, and again, I'd submit to you that that's significant. You know, the purpose of closing argument is for counsel to stand before you and highlight the evidence that's been presented to you. I'm not going to stand here and go through every witness, discuss every piece of evidence and all the testimony, because you have been here. You have been attentive and you are fulfilling your duties. You're being good jurors. But again, my job is to argue the law and, in essence, the facts to you and what we feel is significant. As I said at the beginning of my remarks, it's the state's burden, and the state's burden alone, to prove this case beyond a reasonable doubt. This is our last opportunity to discuss matters and discuss the evidence and the inferences to be drawn from the evidence. Mr. Hamner now is going to take the floor and he's going to argue concerning matters that I perhaps didn't bring up. Address those on your own. Look at the evidence. You've got over 3 dozen exhibits that were marked and admitted through the defense in this case. Watch the videos. Look at the drive concerning those images of that gentleman with hair, which Mr. Tellis does not have. But since the state carries the burden and the state alone, they get the opportunity to get 2 bites of the proverbial apple. Mr. Hamner now can stand and argue why you should convict Mr. Tellis. And I'm going to ask you with your open minds and your attentiveness to address those concerns. And at the close of this process, you find Mr. Tellis not guilty.
Thank you very much. Mr. Hamner, you may begin your rebuttal.
Yeah, if I can just get a minute just to set up.
Sure.
Okay, thanks so much. Can you take your computer down? Absolutely. I will do that too. If we can move, is it possible to move the podium out of the way? I'm not going to move the podium. Thank you.
everybody hear me okay? All right. This is quite the setup. Okay. May I proceed? All right. Well, it's been 2 weeks. You guys have heard a lot of evidence. We thank you for your patience, and I will try to be as brief as I can. But as you've seen, with witness after witness after witness, the evidence is absolutely clear. The defendant murdered Jeff Gehrman. He murdered him because Jeff's writing destroyed his career. It destroyed his reputation. It threatened probably his marriage, exposed things that even he admitted he did not want the public to know. And he did it because Jeff wasn't done writing. He was informed on August 8th that a records request was being made by Mr. Gehrman long after he had lost the race, well into his lame duck remaining administration as a PA. And he learns that Jeff wants to write more. And when he learns about the subject of it, it's not about him and Alicia. It's not about him and Rita. It's not about anybody except him and Roberta. And what you see unfolds over the course of a month. We learn from his phone expert that he shut off all location data, even though that phone, as we learn from his expert, 13 years of location data magically disappears for the month of August. Why? Because of the August 8th email. He's over it. He's building a reconnaissance case. He starts to go on to Google Maps. He starts doing surveillance at Popeyes. He's using the power of his office and their computer software to find private details about Jeff, so it can culminate in murdering him. And that's what he does. But as I've told many, many juries, especially in the last few years, it is really, really hard to plan the perfect murder in the digital age, because you leave too many breadcrumbs behind. And he's no dummy. He's actually quite smart. He is thoughtful. But you will see during this rebuttal, there are mistakes that he makes. And there are things that he simply cannot account for, that when a police starts to look into an investigation and deploys the tools that the police have at their disposal, it uncovers the inconsistencies. It uncovers his mistakes. But I gotta start with what he got up and told us about, the alleged conspiracy. When Mr. Tellis got up here over the course of, I think it was 3 days, and testified, it was remarkable what he had to say, and not in a good way. His testimony was incredible, and not in a good way. He explained, or at least attempted to, explain this conspiracy. What we learned over the course of the 3 days, and actually the course of this trial over 3 weeks, is the conspiracy grew, and it grew, and it grew. Who's exactly in it? It starts with Compass, nebulously Compass Realty. We learned that Adam Fenn can't be ruled out, right? Because he makes donations to Rita Reed. Cindy Sauerland gets mentioned at one point. In some of those briefings, you'll see her name is mentioned. She's a source of consternation for the defendant. It expands to the old guard, as they coin that phrase. Rita Reed, Alicia Goodwin are all part of this, right? The conspiracy, and let's remember, it's a conspiracy to murder Jeff Gehrman. We then learn it expands to Derek Jappy. He's in on it as well. when he testified, he's not really able to link up why Derek Jappy would want to help Rita Reed or Alicia Goodwin or Compass Realty or Adam Fenn or Cindy Sauerland. That testimony is lacking. A lot of times when I pressed him, and I pressed him, and I'm going to explain to you one of the reasons why I cross-examined him so hard. When you stand on the stand under oath and you make allegations about businesses in our community, government service workers, and the police department, we deserve answers. I genuinely wanted to know, how is all this connecting? Explain it to me. And respectfully, Mr. Tellis absolutely failed in doing so. It didn't make sense. And that is one of your instructions, which is to use your common sense. It's got to make sense. And it actually has to link up with evidence. But a lot of times, the most common answer I would get back from Mr. Tellis was simply, well, no, I never saw Jappy take a bribe, but I think that. It was a lot of times just like, that's just my gut feeling. That's my opinion. That's not evidence. That is not evidence. But yet, it was Mr. Tellis's answer for almost everything when it came to this conspiracy. But let's continue. It stretches out to include Cliff Mogg, Justine Gaddis, the entire DNA lab. He said there were also patrol officers in it. I asked him which patrol. I don't know which ones. And then it literally culminates with Steve Wolfson, like the DA. It culminated with him. He can't quite link it up, but he threw that name out there. And here's the thing that struck me when I took over this case. I would submit to most people, probably before ever hearing about this case, had no idea what a public administrator was. He is not a U.S. senator. He is not a governor. He is not a congressperson. He is a duly elected official who manages an office of approximately 8 people. And their job is to assist people who pass away, who don't leave a will and leave property behind. The public administrator's office is not at the forefront of everyone's mind in this community. No one learns about this until who brings the office to light? Jeff Gehrman. And what's amazing is if you believe that story about this conspiracy, all of these people and all of these entities were willing to sacrifice their reputation, their business, their police department, even the public administrator's office. They're all willing to put it on the line to kill a reporter, to get that guy, even though he's leaving in 3 months? Does that make a shred of sense? Absolutely not. But what it does give you a window into is what's in his mind. That is how important Mr. Tellis views himself. That every single one of these people, every single one of these entities were literally willing to kill another human being who is not him, just to frame him. Does that make sense? And more importantly, where is the evidence to support that? Where is the evidence that you received in this trial that supports that? And the answer is, you didn't. There isn't any evidence of that. Why would Compass conspire to frame him? Why? I asked him. I wanted to know. He couldn't give a good answer. His best answer was, well, I was going to do a lot of work in the next 3 weeks, or next 3 months. Has anyone ever heard of any sort of legal filings, lawsuits getting settled up in a brief, tidy 3 months? That's not a thing. That didn't happen. That doesn't happen. There was no need to frame him because they already succeeded getting him voted out of office. And all they had to do was donate a whopping, I guess, 15 grand at best to get him out of office. They didn't need to kill him. He was on his way out the door. He is a lame duck. And lame ducks don't matter. What incentive does Metro have in this conspiracy with a real estate company to frame a lame duck. That's an even bigger one. Why would they do that? What did we hear that would show us that Compass is like, hey, guess what? Hey, Metro Homicide, we need you to join us to go frame this outgoing politician. I mean, we killed the reporter. That's not important. But I want you to join us in this, and let's go frame this guy. And all of Metro's like, sign me up. Sounds great. Does that make any sense? Absolutely not. It makes no sense. And it's not supported by the evidence. And again, if Compass is literally willing to kill, why not just kill him? Just kill him. Why does Jeff have to suffer? It makes no sense. And it gets even worse. Well, before we get to that, here's the thing. When we go back, when you think about the Compass question, right? Isn't Compass in cahoots with Rita Reid and Alicia Goodwin, right? They're funding Alicia Goodwin, right? Or no, Rita Reid. They're funding her campaign against him. And who do they get to help write the story? Jeff German. Like, why would they kill the guy who wrote the stories that got this guy out of office? Why would Compass do that? That doesn't make sense. And then, yeah, if it's really a frame job, the murder weapon should have been in the house. The orange shirt should have been in the house. The DNA should have been all over the place. Like, they're claiming, well, why weren't these things located? The state would submit to you, he got rid of them. He got rid of the murder weapon and the orange shirt. He cleaned the outside of his Yukon. He even admitted it. And here's the thing. We only know that he wiped down his Yukon because on that one particular day, he was being watched. He wasn't watched every single day after the murder by Metro. Did you hear that testimony? There were other days he could have wiped the interior of his car if he wished. And I've always thought about the shoes. Like, the shoes to me was kind of an interesting one. My co-counsel's right. Like, the only one who benefits of like chopping up the shoes is Mr. Tellis. It's this awkward, amateurish way of getting kind of rid of the evidence. But I thought to myself, maybe Mr. Tellis didn't even think to like bring an extra pair of shoes. Because like, what happens if he walks in and he's totally barefoot? His wife would be like, why do you have no shoes on? He probably had to bring his shoes back in. He doesn't need the orange shirt. He doesn't need the murder weapon. It is his kid's bag, right? I mean, he said those were my kid's sports bag. So like, he probably needed to bring that back. I'm not sure what he was doing with the hat, I'll admit. But clearly he's chopping it up to try to get rid of it, just like his shoes. And why kill Jeff? Like, this is the question that is so destructive to this defense. It's his writing that shines a light on his behavior. He is sought out by the co-conspirators to do this. And he admits, and he admitted on the stand, one of the rare times he admits it, he admitted, yeah, his writing was the difference in the election. That's why I lost. I got that out of him. He was at least willing to concede that. But for Jeff German, he's still a public administrator. His writing is why the defendant is out of the job. And therefore, under this theory, he's got to be the one who's killed. That's his reward. He's collateral damage. Like, really? Rita and Alicia are like, sorry, Jeff, you got to go. It's been really nice. Thanks for the help, but you're out now. We got to clean up loose. I mean, is that really what's being suggested here? And the answer is that is what he's suggesting. But it defies common sense, and it's not supported by the evidence. And here's the other thing. Jeff's putting together a fifth article. A fifth article. And now, what we can tell from the records, it's just about Roberta and him. It's the salacious stuff. So who in this realm, if you think about everyone in the conspiracy, and you think about Mr. Tellis, who is the one that wouldn't want another article written about him engaging in an affair? You think Derek Jappy cares? Cliff Mogg? Adam Fenn? No. It's him. He's the only one that would have a stake in making sure that article never got written. No one in the conspiracy would want to prevent that coming out. Especially not the Rita Reeds and the Alicia Goodwins. If they want that exposed, I mean, they went to have that exposed. They wouldn't want that being not put out. And I'm sure Compass Realty wouldn't either. I'm sure they would have wanted him discredited. Like, another article would in theory be great. They wouldn't have killed him. And then we have his walk. Like, he's got a little hitch in his getup where he kind of leans to this one side. You can kind of see it. There's something that is about his little walk. And look, you don't have to take my word for it. You can evaluate whether you think what Zach and Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellis, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes. Like, that was the thing. Like, they noticed the shoes, which I think is really interesting, you know? But they don't act on it at first. But it's only when they see the Yukon that they kind of flip out and they're like, well, we probably should call on this. The only other person who came and said that wasn't him is Nicole. And listen, you'll have all of Nicole's texts. The state would submit to you that, look, there is no doubt she has a kinship to Mr. Tellis. You can see it in the text messages. You can see it. You can go read through them. The state would submit she has a bias. And, like, she cares about him. And I think he was probably good to her in the office, which is understandable. But, look, you can judge it on your own. You can judge the testimony of those other people. You can make that call for yourself. But I would submit to you, when you look at this, think about all the other evidence in the case. Think about all the other evidence. The motive, the physical things found in his house, his DNA underneath the nails. When looking at this and being like, is that him? And the state would submit to you, when you put all that together and you watch this video, absolutely, it's him. Professional killer versus amateur killer. Mr. Tellis would like you to believe that this was an assassin with combat training. The state would submit to you, you don't need combat training to stab people. You don't have to go to knife school. You don't have to do that. If you're angry and his way up through law school. He had got himself elected, and this guy took it all from him. And so he wanted to take something from Jeff, and that was his life. Professional assassins don't use their personal vehicles. They don't use their personal phones or work computers to conduct reconnaissance. They don't wear attention-grabbing outfits. They don't flee the scene and then double back to pull right up to a murder scene to look for possibly dropped evidence. And they don't leave items of clothing or apparel they use in the murder inside their own house. Professionals don't do that. The state would submit to you that what this was an amateur attempt by Mr. Tellis to pull off this killing. But here's the thing. It is thoughtful. It is deliberate. He really did a thoughtful job about it. I give him credit. I give him credit. But in the world of the digital age, we leave behind too many breadcrumbs. And when you're not a professional and you are an amateur, you tend to make mistakes. And that's what he did. For example, really smart idea. He knew about IDI Core. Hey, I've got a really easy way to look up personal identifying information on people. I'll use my work computer. But what does he not realize? That we can, as the police, download the computer and literally see your keystrokes. How could he have known that? He wouldn't. It's an oversight. It's a mistake. It's a slip. And it's evidence that we collect against him. What else? He does the Google Maps surveillance. Really clever. What an easy way. You don't even have to go to the neighborhood. Just pull it up on your Google Maps. He does the Popeyes surveillance. He takes the photos off his work computer, right? But he forgets to delete his cache files. And let's just make this clear once and for all. Matt Hovanetz told us what? He said that these are not created photos. They would say created in a date, in a time, and you'd have it. Those don't exist on the phone. I wonder why that is. Why do you think there aren't all those images? Forget the Google Maps surveillance, right? That's just, those are probably images that the program pulls up. Sometimes it's referred to as tiling. But like the Popeyes photos, which are coming from the phone, and the one from the work computer, why don't we have any created photos? The state would submit to you that Mr. Tellez, being the smart guy that he is, the techie, as he described himself, deleted them out of his photo album. But the problem is, he didn't delete his cache. And we learned from Matt Hovanetz that the caching of photos is what happens. The example that we heard was, say you want to send an email, and the computer will shrink down the actual image to get down data size lower so it can go out. He didn't delete the cache. He deleted the actual photo, but not the cache. And so those dates tell us that essentially in the month of October, he is doing all of these things. He tried to get rid of it. He couldn't get rid of all of it because he's an amateur. He conducts reconnaissance in August, but doesn't realize that the police are going to acquire the 8.8 email about the public records request. Right? Like, did he really? Maybe he probably didn't realize that we would go to the PA's office and say, hey, we want what communications are out there, and we get the email. Now we understand the significance of why these things are all happening in August, because we get the email. He didn't account for that. Here's another thing. He shut off all his location services in August, but doesn't realize it's going to stick out like a sore thumb during a location services analysis. And here's the crazy part. His expert gave it to us. His expert said, I have 13 years of location data on this phone, but for the month of August, it's a 0. It's a bagel. Why? Why that month? Because it's right. It's when he's planning the killing. He knows he's going to those spots. He doesn't want to be tracked. He's no dummy. He's smart. But the problem is, that is an electronic breadcrumb. An entire month, no location data at all for anywhere that he traveled? That was the testimony of his witness. And he didn't claim that that information was hacked or compromised. What else? He decides to wear gray Nikes, but forgets to delete the shoes off his phone. And then he fails to get rid of the shoes in time by the time the cops do the search at his house. Maybe life just kind of gets in the way, right? He's maybe doing it late at night when the kids are asleep, and his wife's, doing a little, I don't know where he's planning on sprinkling the bits of the shoe, but like clearly he wants to do that to shrink it, and maybe it's harder to find. Like he's putting it in a place that only he would find it, like underneath the recliner. And like he can't account for like the one random photo where like his murdering shoes are right there when he's out rock climbing. Like he can't plan for that. And all the hundreds or thousands of images are there. He can't plan for that. Creates the disguise of the construction worker, but doesn't account potentially for an interaction. And then again, he leaves his phone at home, which is smart, right? So we don't see the movement of the phone kind of going with the Yukon, right? But the problem is that when you go radio silence for like 5 hours and you start ignoring your wife's calls and texts, that's a problem. And then, great example. He gets up here and he tells us the whole story about the chicken fried rice. He was so happy to share that story. I was making my daughter lunch because she doesn't eat the school lunches, and I cut the tip off and I started bleeding, so I went and got the super glue and I cut it and it got blood. And so that's why the DNA, that's the one time he was fine with DNA. But like, he doesn't realize that all we have to do is start checking it. Is there a Google recipe for chicken fried rice on your phone? And there wasn't. Because that's what he said he was doing. He didn't just say I was making a meal. He specified how he was doing it. He was like using a recipe. And that's the most logical place you would do it. People are not bringing their desktop computers and putting it in their kitchen when they're cooking fried rice. Like, that's not how that's going down. Like, if that story was true, and we would submit it as not, because it's not there in the phone, he probably would have sat there with his phone on the counter, hit the YouTube or the Google recipe, and then he's working. So it should be there. But it's not. because that was something used to explain why in the world would my DNA be on the scissors. Again, another example. He goes to great lengths to park down the street. And then it all goes down the drain when he leaves because he realizes, oh, I probably forgot something. So he wheels back and parks right in front of the house. That's a huge mistake. It's an amateur mistake. Here's another one, and I just noticed it while watching it. He left the garage door open. If you watch the video after he does the killing, he walks away, the garage door is totally open. And then when he drives back and he gets out, he has 2 opportunities to close the door. What did we learn about what prompts the neighbors to worry about Jeff? It's the garage door. The hitman, the assassin shuts that garage door. But not an amateur, like Mr. Tellis, because in the panic of the moment, he's just like, I gotta get out of here as quickly as possible. It's a slip. It's a small slip, but it's reflective of who we're dealing with. And then he forgets to get rid of the hat. He forgets to get rid of the bag. He forgets to wipe his phone entirely. Next time, factory reset. Full factory reset. Hopefully that'll clear it all. Probably be up in the cloud. But the point is, he doesn't do the things he needs to do. They're amateur mistakes. It happens. But that's why it's hard to pull off the perfect murder in the digital age. And about that gray bag, the defendant told us on the stand he'd like to think he wouldn't have removed his children's basketball and football to use it in a murder. Remember that? And there's the bag. And there's the bag. And there it is. And the defense in his closing arguments said, we submit that there's sawdust inside the bag. Well, let's take a closer look at the sawdust. See that bag? Let's take a closer look. Remember the big sun hat? Sawdust? Doesn't look like little... Here's the hat. Here are those bits, long and rectangular. The state would submit to you, he put his chopped up hat in that bag and then transferred the bag into the Sprouts bag, put the basketball and the football back inside. That is not sawdust. I want to touch on some things that were brought up in closing argument. That Garen's DNA is the only one at the scene. Well, our response is, well, his DNA is underneath Garen's nails. So that's a huge problem. Not in his vehicle or in his clothing. He got rid of his clothing. We'd submit he cleaned his car. He also wasn't surveilled 24 hours a day. There was no positive ID from him at the scene. And that is correct. And listen, that's why we have this instruction about direct and circumstantial evidence. Because in Nevada, the law doesn't make a difference between the two. You can weigh it as you wish. Some cases have incredibly powerful examples of circumstantial evidence. Sometimes you've got a combination of both. Sometimes it's all direct. But there's tons of direct evidence, like him in the Yukon. Like that's to be tracked from literally silk tassel all the way to his house and then all the way back is incredible. You heard about how many officers it took to track and go business to business to business to business. That's direct evidence. You've got the circumstantial evidence of his DNA. You've got the shoes with his DNA in it that's chopped up. You've got the hat. You have the surveillance in the phone. You have the whole motive laid out from the articles. I mean, okay, you're right. We didn't have one person standing out going, I watched Mr. Tellis stab Mr. Gehrman. You're right. But we got a whole lot of other evidence. There's no surveillance of Tellis exiting his home. You've heard testimony about it repeatedly. There wasn't cameras in the area. We just have surveillance of the street that's perpendicular to his driveway. And I thought I had pulled up, maybe I didn't, I apologize. I tried to put the image of that, but I want to address that. It might be still in here. Go back and check the map. Because the way it actually works is Piggott Elementary, when he's coming in and out in his red Yukon and going to the gym in his BMW at the end, the street that comes down perpendicularly to turn out along the Piggott Elementary, that street is silk tassel. And when you look at a map, if you follow Silk Tassel, it perpendicularly, it runs into his driveway. Like all he has to do is like drive out of his driveway and he's already on Silk Tassel. So you're right, like we don't have him getting out of his car from his driveway, but we literally have the only street he needs to take to get to Pickett Elementary. It is not streets and streets and streets. It's the street before his driveway. There's the argument, well, Metro makes mistakes. There's that deletion of a traffic signal. Well, as I've just pointed out, Telus made a ton of mistakes himself. So we will own that, you know, on one traffic stop, we didn't mark a proper event number. And you can give it whatever weight you want. Telus cutting himself while cooking. You know, again, we've talked about the chicken fried rice thing. That's not backed up. Wouldn't there be blood from the cut? Not necessarily. What if he had gloves on? And he's kind of cutting his tip. It may not be pouring everywhere. And again, look at that scene. The majority of the blood of Mr. Gehrman is actually just kind of pooling from where he's resting. It's not splattered all over the house walls. It's not that type of scene. I mean, Gehrman's shoes are such a good example of that. Like, he's the guy who gets killed. He's the one stabbed 11 times, and his shoes are relatively clean. And he's not doing a lot of walking. A lack of responses to junk messages. That's true, but there are work messages he's not responding to, and his wife is reaching out to him, and he ain't responding for hours. That's a problem. That's a problem for him. Especially, go look at, when you're not in the murder window, go look at the communications. So like when his daughter reaches out to him in the morning, he responds like that. No issue. Like at 3 o'clock or so, or 2:30, when Tonya, his ex-wife, responds with a question about the kids, he responds immediately. And what did he tell us on the stand? What did he tell us on the stand about being at Summerlin Area Command? What was his big worry? My family doesn't know where I am. I was so worried about being detained there because I couldn't reach out to my family, because that was the most important thing. And what do we know on the day of the murder in the murder window? His wife wants to know where he is, and he's not telling her. That is significant, because his pattern is, when you look outside the murder window, he promptly responds to family members about family matters. But he goes silent with his wife when he's literally in Mr. Gehrman's neighborhood. And another thing, remember his face when I showed him the Apple photo for the first time? If anybody remembers, store that one away. Because he was very comfortable on direct talking about the timeline. And he had his story all lined up. And when I showed him the photo, the message that wasn't there, that face really changed. And you can weigh that when evaluating his credibility and his responsibility for this. And then there was the argument about DFL analyst Hovannes couldn't say one way or another if it was deleted. Well, you're right. He's like, I can't definitively say it. What he does say is, I can see from the photos the message is there. I can see in the timeline it's not there. Sometimes there are situations where people delete things deliberately and it's marked as deleted, so it'll appear in an extraction report. But sometimes people delete messages and it's not. But he can't definitively say for certain. So I would submit this to you, ladies and gentlemen. Look at all the surrounding evidence in the case. And then you can reach a conclusion about this. Because, ladies and gentlemen, circumstantial evidence is a chain of facts that lead you ultimately to a conclusion. It's like connecting the dots. And so if you're wondering about this, look at the phone evidence. Look at the motive. Look at the physical evidence in his house. Look at the timeline of when he's gone. Look at when the Yukon is where it is in relation to just nothing is going out on this phone. And then you decide, you can make a call about whether, and his manner on the stand, listen to him testify, and then you can decide whether he actually deleted that message. And I'm going to get to the significance of why maybe that message was deleted in a bit. And again, claims Hovannes couldn't tell you the cache date on the phone. The state would submit, and you can check your notes, that's not his testimony. He never said, I can't tell you the cache date. He said, I couldn't tell you the creation date. He said, the cache date is something different. That's what the report is showing me. That's the last time this image interacted with the phone. So that's the time that those smaller images are interacting with those phones, all those dates in August. Not bagging the hands. And that was an argument being made. Like, no one could tell us exactly. So I would say, what means what? Has there been testimony that the DNA evidence was compromised? There was no evidence of that. What is being asked of you? You're being asked to speculate. And you have an instruction on reasonable doubt. And reasonable doubt must be actual, not mere possibility or speculation. Speculation doesn't get you there. It's improper to speculate. Ah, here it is. I knew I didn't forget it. Colin was streets away from his home. That's not correct. That's his house. This is the road. When you're watching that Yukon come in and out, and his BMW coming out, this is what you're seeing. So you're right. We didn't get any homes in this area with camera footage. But we got about 5 miles worth other than that. There was an argument, does it make any sense that there aren't any other cameras in the neighborhood? And my response would be, did you see Mog's presentation? Does this appear to be a case of Metro's not interested in collecting video? There's like 28 sources. The state would submit to you, if there was a camera that was working, that was closer to his house, they would have gotten it, and we would have wanted it. And then there was the video that they showed of this other car, right, with someone presumably with hair and glasses. The state would encourage you, by all means, go compare it to the rest of the videos. Compare it to the rest of the videos. And compare it with all the other evidence. And then you get to weigh it. Because we did hear from Mr. Martinez. What did he also say was going on in that neighborhood? There was a 7-day-a-week, 24-hour construction project where they're repairing a sewer line. I asked Mr. Martinez, what did you guys wear? We wore orange things, right? And in that video of that car, there's someone in an orange thing. Is it possible that that's one of the workers from the sewage project? He seemed to be coming down the road in that first video. He's coming from the road where Mr. Martinez said he was waving people off, remember? Martinez said, I saw that when we saw the first video, right, of the car approaching and the white truck pulls up, he said he was going out there to tell that person, you can't come down this other way. And the video that the defense shows you shows a car coming from that other way. And if we marry the testimony of Mr. Martinez, the state would submit that's the construction area. In all likelihood, that's just another worker. But you get to weigh it. You get to weigh it with everything else. Then there's this argument about Jappy mysteriously inserting himself in the homicide event. Really? Is that the testimony? Detective Jappy told us that he had to attend the Metro briefing that night. Why? It makes sense. He's literally a detective that's working on an investigation on him. Does it make sense that Metro would want all people maybe involved or some kind of connection? Absolutely. But did you really hear a situation where he was injecting himself into Justine Gaddis' investigation? The answer is no. Detective Gaddis talked about contacting him from time to time, and when contacted, he either met the person or responded, but there really isn't any evidence of him interfering with an investigation. And then here's the other thing. There's testimony from a CSA saying he was taking his own photos and collecting his own evidence. What is the significance of this? We do know from Detective Jappy, he is conducting 2 investigations at that time for Compass and Tellus. It goes on until January of 2023. So is it possible he is collecting information tying to one of those? It's possible. But the better question is this. What evidence do we have that Jappy's presence being there compromised any CSA's collection of the information they needed to get? Did you hear a CSA say, like, he didn't let me pick up that computer that I needed to take? He didn't let me take Roberta's computer. Did you hear anything like that? That he was some sort of obstacle from the CSA's doing their work in the PA's office? The answer is no. So what is the point of bringing this up? It is an argument or suggestion asking you to speculate because there isn't any evidence that he interfered with their collecting of evidence at the PA's office. It's not there. And then the DA didn't pursue charges, and I would submit that was significant. That's what he said. Respectfully, the defense doesn't expound upon the significance. He just said it was significant, but doesn't expound why. Why is that significant? He never explains it. It just stops. And the state would submit to you the testimony of Derek Chappie is really significant because Mr. Tellis would have you believe that like he's being framed by Derek Chappie and his complaints about Compass are not being taken seriously. And he got up on the stand and Derek Chappie told you the exact opposite. He exonerated Mr. Tellis from what he was hearing from Reader Reed and people in the PA. He exonerated him. But he's supposed to be the head co-conspirator for Metro. Why would he exonerate him? And then he did go to the DA's office and said, I think we should pursue charges against Compass, and was told, listen, due to this loophole, it's not going to work. Like, you have inconsistent information about what these people are notified or not. And the court records do show that, Cindy Sauerland is identifying, when they want to file on this case or, notify next kin. Like, there's records that match up. So even it's just like, it's literally the exact opposite of what Mr. Tellis wanted to have uncovered by Chappie. And like, he didn't, if he really was out to get him, like, he should have just stopped when the arrest was made and we could be done. But that's not what he does. So I want to get to the defendant's testimony. There's a credibility instruction. You were instructed that you need to consider witnesses, and since he testified, he's a witness, consider his manner upon the stand. Think about what his fears, motives, interests, or feelings are, and the reasonableness of his statements, and the strength and weaknesses of his recollections. And then here's the kicker. Under Nevada law, if you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness, or any portion of their testimony, which is not proved by other evidence. The state would submit to you that arguably, Mr. Tellis' testimony, he might have been our best witness. Based on his manner on the stand, based on the things that he said, he spent 2.5 hours on that first day, and almost 80% of it is talking about things he did in the public administrator's office. It's not about the actual murder or what he's doing on that day. He just wanted to regale you with all of his achievements as a public administrator and how he fought against people standing in his way. And the state would submit to you, as my co-counsel told you in opening statements, that's not what this case is about. It's not about whether he was a good manager or not. It's not about if he had an inappropriate relationship. This is about whether or not he had a motive to kill Jeff Garman, and did he in fact do it? And he did. Think about his difference in how he spoke to you on direct on a narrative versus trying to answer my questions. How many times did I have to repeat, sir, my question is this, bring you back to my question. Sir, I didn't ask you why. I asked you a yes or no. Think about that for a second. And think about this. What are his fears and motivations in this point in time when he sits on that chair and he's talking to you? And we're going to get to something about that I think is very significant. And it's right here. He took the stand and he admitted on cross-examination that he lied during his May 11th, 2022 interview with Jeff Garman. I asked him, what was it the part that you were untruthful about? And he said it was about my relationship with Roberto. And he said, and I said, he said, I didn't think the public should have to know about that. And it was really important to conceal that information from his family. This is really significant because what it tells you is that back in May, when he was facing just an election, he was willing to lie to protect his job and to save his marriage. Now, the stakes are even higher. They're far higher. So you get to evaluate, are the things that Mr. Tellis is now saying, is it possible he could be lying about some of those details? Because this is far greater than that. Think about the difference in his body language, his ease of sharing information. When I'd ask versus when he just had free reign to say whatever he wanted. They're like night and day. And the state would submit that the defendant's view of this situation is completely divorced from the evidence in the case. It's like he's talking about a thing that's, it couldn't be farther apart. He talks about these conspiracies, but he's so short on details. Always. Oh, he took a bribe. Did you see someone take it? No, I didn't, but it's just in my gut. I think that happened. That doesn't work. That's not evidence. Something in your gut, or I just feel it, that's not evidence. And when you think about it, it does make sense. Because if Mr. Tellis had to be honest about what the evidence is in this case, it's a very difficult thing for him to explain away. It's his DNA underneath the fingernails. It's his car that's there. It's his Google Maps images in his phone. He's conducting surveillance at Popeyes. He's using his computer to look up information on this guy. He's got these text messages explaining how upset he is about everything involving Gehrman. That's a huge problem. Because really, he's the only person who wants Gehrman dead. He's the only one. And really, this was kind of, in my mind, what jumps out to me. It's like a because I said so. Like when I pressed him on things, like why is this? Why is this? And it was just simply because that's how I feel. That's not evidence. And again, the defendant is also selective during his testimony about what evidence had been compromised versus properly collected. Great example was the scissors DNA. At the beginning, I'm like, the DNA in the fingernail, you couldn't get an inch out of him agreeing with that. I'm like, you at least agree with me that it's been planted, and you didn't even want to do that. But he had come up with a story about cutting his finger, so he's fine with that DNA being on the scissor. That's a nice contrast. And he picked and chose, and you can check your notes on that. But that, to me, is really significant, because he was fine talking about certain pieces of evidence that he thought was good. Great example, the timeline on direct. He's happy to tell you his narrative on direct because he forgets about the where are you. And then on cross, when I confront him with the where are you, now things are a little bit different. But he had no issue with anything in that timeline at first. And another thing, when the defendant testified, a lot of times he didn't use phraseology like, I didn't do this, or I didn't do that, or I didn't stab him, or I didn't go to that scene. It was never that. I mean, maybe from times he would say it, you'll check your notes, but the vast majority of the time, Mr. Tellis would say it like this. I'd like to think I wouldn't do something like this. I'd like to think that I wouldn't do that. I'd like to think I wouldn't take my children's sports balls out of the bag to use for a killing. It's an interesting phraseology. The state would submit it's a bit of a tell. Because he could have just simply said, I didn't do that. I didn't touch that bag. But that's not how he words his behavior. It's this like Monday morning quarterback. I'd like to think I wouldn't, because it's really bad. You can weigh that when you're evaluating how honest and truthful he was when testifying. And again, for all his talk about being conspired against by powerful enemies, it's actually the defendant that uses the power of his office's proprietary software to spy on and discover where Gehrman lives and what type of car he drove. He used the power of the office, Mr. Tellis. And here's another thing. Remember the map that they brought up, kind of trying to show the drive from the PA's office to Popeyes? When you study that, remember it's Analyst Hovanet's testimony. Those reports out of Axiom from the work computer aren't converted for UTC time. So he was trying to use it to say, like, I couldn't have done this at this certain time. It's not UTC converted. And then we get to where are you? Remember, every single message between the defendant and his wife on 9/22 are on the timeline, with the exception of where are you. So here are the messages, where are you? Now they're talking about his daughter, collecting or selling things. Wow, that's incredible. There's a doctor's appointment. Are you at the doctor's appointment? No, we're at the barbershop. Okay. Then there's text about the scheduling of the appointment, and then he also has picture read. All of that's on that Apple Watch. Oh, and also the deposited message. And then when you look, it's all the same stuff, with the exception of where are you? That's the one thing that's not there. There's the cards thing, there's that's incredible, at the doctor's appointment, the barber shop, okay, the appointment last week, picture day, and then the deposited message. It's all there except for where are you? So why is this significant? Number one, the defendant cannot answer this text or pick up her call because the phone is at home while he is murdering Gehrman. Number two, the defendant couldn't leave this message on his phone. Why? Because it would reveal that even his wife is looking for him at the time of the murder. And third, given the state of their relationship at that juncture, given what you've now kind of acknowledged what he was doing privately, if your wife calls and you have your phone on you, you're going to take that call. You're going to answer that text message. You're not going to let that sit for like 5 hours. No way. No way. Some final thoughts. I want you to think about this one. This is something I never actually asked Mr. Tellis on the stand, and I really tried to ask as many of these, but this one really struck me. The Las Vegas if the Metro Police Department, the Las Vegas Metropolitan Police Department, was really in on the conspiracy to get the defendant, right, to truly get him, here's a question for you. Why not let him die in the tub? You saw the video. Why not let that man bleed out? You had your opportunity, and yet they don't take it. Mr. Tellis' life is saved that day. And who ends up saving his life? Why, it's none other than the head conspirator from the Las Vegas Metropolitan Police Department. It's Detective Derek Chappie. He testified that he spent 2 hours on the phone talking him off this ledge. 2 hours. And then you got to watch the footage. They saved his life. If the conspiracy is really true, Derek Chappie doesn't do that. Metro doesn't do that. They literally let him bleed out. But that didn't happen. And the reason is, ladies and gentlemen, is because there never was a conspiracy. You made a commitment when we did voir dire to follow the law. The law in this case is abundantly clear. These three theories of liability are abundantly clear. He is guilty beyond a reasonable doubt on all three theories, and it's not close. And so we ask you to follow the law and follow the evidence. Do not speculate, but follow the evidence. As my co-counsel brought up, in the end, this is not a case about politics. It's not about alleged inappropriate relationships. It's not about who's a good boss or who's a good supervisor or favoritism at work. It's just about murder. And I want to end, if I could, I want to make sure that this is working, with something that Mr. Tellis said in his interview that really struck me. And I noticed it during the opening statement. And it's this.
And people just cannot get to do whatever they want.
And it's just that people don't get to do whatever they want. For once, the state of Nevada is in agreement with Mr. Tellis. He doesn't get to do whatever he wants. He took the life of an individual who was simply doing his job because he didn't like how it impacted him personally. Please hold him accountable for murdering Jeff Gehrman. Thank you very much.
Okay, at this time, the clerk will swear the officers of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed. So help you God?
Yes. Yes.
Okay, at this time, ladies and gentlemen, you're going to be excused. When you go back, you're going to have lunch. After lunch, our two alternates, Mr. Max Gross and Zachary Crayson, you will go with one of the court officers. At that time, the clerk will bring back all of the evidence, and you'll begin to deliberate upon your verdict. So when you're done eating lunch, make sure Officer Hawk's nose, and the clerk will bring back the evidence. Thank you very much, and you're excused.
Thank you. All right.
Yeah.
State make their appearance, please.
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervinack, Joseph Hill, and Fred Burmester for the state.
And for the defense, please.
Wendy Lewis, Catherine Lester, and Alexander Ramos for Ms. Kouri Richins.
Okay. I appreciate everybody here in the gallery has exercised great patience this morning. We needed to discuss some legal issues related to the admissibility of evidence. Couldn't have had that discussion in the presence of the public in a way that would preserve the integrity of the process going forward. So I appreciate your patience. Mr. Bloodworth, before we get rolling this morning, I understand there's some housekeeping details we need to address.
Yes, Your Honor. The state would like to provide the court with something of an overview regarding how the state will present its preliminary case. The state has presented most of its evidence and argument in paper in advance of today, notably including the transcript of the detention hearing, which the court has already admitted into evidence, along with 60, I think, since now other exhibits. We intend to be mindful in our presentation to not belabor well-established evidence. To that end, we ask that the court moves along when appropriate. The opposite, of course, holds true. If the court seeks additional information, if the court would let us know, we will present it.
Understood.
Speaking of our papers, back in May, the state had submitted a bench memo. I have two errata that I would like to put on the record. The first is on page 20 and 24, Your Honor. Reference to a divorce consultation. The state wrote that occurred in January of 2022. The state asked that the court strike the date. The court will call some litigation related to this matter that occurred after the state filed that bench memo. That litigation revealed that date was not accurate.
Any others?
Those are the errata, Your Honor. The state will call in its presentation Detective Jeff O'Driscoll and experts Chris Kotrodemus and Brooke Carrington. The state has provided the defense with advance notice of those witnesses. When the state calls Detective O'Driscoll, the state will not conduct a direct exam. Instead, the state will refer the court to his testimony at the detention hearing. The state is essentially offering Detective O'Driscoll for cross-examination by current defense counsel within that scope as, in the best interest of a fundamentally fair proceeding, since they've not yet had an opportunity to cross-examine him. The state provided the defense with advance notice of this approach and reserved the opportunity to redirect Detective O'Driscoll. Finally, Your Honor, I'd like to, by stipulation, admit a few more documents. The first is what we have labeled as 7A. Exhibit 7 in the court's binder.
The self-right extraction report.
It does, Your Honor, and it's in there, and we refer to it in our papers because it has a screenshot of a navigation system. It is in 7A, but absent a telescope, the the court's not going to be able to read it. So we have blown that up and labeled that 7A, if I may pass it up to the court.
Ms. Nestor, Ms. Lewis, any objection?
No, Your Honor.
Okay.
Your Honor, the other document we've labeled 67, and that is some notice for claim stage from true stage. They've been provided in discovery. They've been referenced. They just have not yet been.
What's the number?
67, Your Honor.
What is 66? You referenced 66, but
Right.
understood. It's already in the plan. Got it.
It is, Your Honor.
And 66 is exhibit, correct, counsel? Stipulated. My apologies. Is 67 stipulated?
It is, Your Honor.
Okay. 67 and 7A are.
Your Honor, may I?
Of course.
Thank you. Your Honor, the final two exhibits are docket references 123 and 124. I'm not sure how they got left out of some of the earlier discussion on this, but they did. So the state moves 123 and 124.
Any objection?
No objection.
Docket entries 123 and 124 are admitted for the purpose of today's preliminary hearing.
Your Honor, unless the court has anything to say, we'll call Detective O'Driscoll.
Ms. Lewis, Ms. Nestor, Mr. Ramos, anything housekeeping-wise?
No, Your Honor, nothing possible.
Okay. Detective, let's get you sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to offense and penalties of perjury?
Yes, I do.
Your Honor, the state tenders Detective O'Driscoll for cross-examination in the scope of the direct conducted at the detention.
Understood. Ms. Lewis.
Good morning, Detective.
Good morning.
We haven't met. I'm Wendy Lewis. I'm one of Ms. Richins' attorneys.
Thank you.
So, Detective O'Driscoll, when was it that you were first asked to take over this case?
In March of 2023.
And who was on this matter before you as the lead detective?
Detective Jamie Woody.
And why was this matter turned over from Detective Woody to yourself?
Detective Woody moved divisions from the investigations division to the patrol division. She had an opportunity to have some auxiliary assignments that are only available in that division, specifically a K-9 handler position.
Did you ever become aware of any evidence or any issues with Detective Woody mishandling evidence in this case or other cases?
No.
All right, when you first took over this case in March of 23, what was it that you reviewed initially?
I was not able to review the entirety of the information that was available in the case, but specifically, most of the information that I received was from updates from investigators that had been working the case prior to me. I was able to review some of the supplemental reports that had been entered into our CAD file, but I don't recall the entirety of every document or piece of information that I reviewed.
Did you review all the police reports that had been written up to that point?
From our office?
Yes.
I don't believe so.
Did you review all the Detective Woody's reports?
I believe so, yes.
Now, who did you interview initially when you first took over this case?
The first interview I conducted, I believe, was with Ms. Richins.
All right. So that interview, well, I'm going to get back to that in a minute. Before we talk about the interview with Ms. Richins, did you, I want to go back to the early morning of March 4th, 2022.
Okay.
Did you review evidence about the investigation that was done that night?
Yes.
And what investigation was done at the home that night? Or that early morning hours of March 4th, 2022?
Responding deputies conducted an initial interview with Miss Richins. Detectives were then called out, and they conducted, I believe, a separate interview with Miss Richins as well as other people that were then at the home by the time they arrived. And I believe they conducted a search of the home for any kind of evidence that may have helped them understand what had happened.
And what was seized from the home that night as potential evidence? Are you aware?
I don't know a complete list, no.
Are you aware if anyone was searching for any illegal drugs in the home that night?
I do not know.
Were any illegal drugs found in the home that night?
I don't believe so.
So no fentanyl was found in the home?
Not that I'm aware of.
Were there any unidentified pills, light green pills, blue pills, dark green pills, anything like that found in the home the early morning of March 4th?
I don't believe so.
Were there prescription medications taken at that time?
I believe so, yes. Part of death investigation is to document and collect prescription medications for the scene. I can't tell you specifically which ones, though.
Okay, sorry, let me just speak over you. Were there any non-prescription medications or illegal substances taken from the home that night of any kind?
I don't believe so.
Eventually, or early on when you started the case, were you able to review the medical examiner's report?
Yes.
And what was your understanding of what caused Mr. Richins' death based on that report?
The medical examiner's report identified that the cause of death was drug intoxication with a specific drug being fentanyl.
All right. But nothing was found or seized the early morning of March 4th that included fentanyl. Is that correct?
No fentanyl was seized that I'm aware of, no.
All right. Was there any glassware seized in that initial search?
I don't know.
You don't know if there was glassware seized, such as copper mugs or shot glasses? You're not aware?
I know with review of supplemental reports I could find that information, but right now I don't know if during the first search on the morning after Richins' death, if those were collected or not.
Were they collected at some other time?
Yes, I believe some copper cups were collected from the home subject to a search warrant.
All right. When was that search warrant that was executed on the Richins' home? You said after.
There were multiple that were executed. The first one after Eric Richins' death, I believe, was in April that same year, mid to late April. I don't remember an exact date.
Was this after the medical examiner's report had been reviewed?
Yes.
Were you present for that?
No.
But you reviewed reports regarding that search?
Yes.
Was there any Oxycontin found in that search?
I know during one of the searches that there were some prescription opiates that were not in a prescription container that were found in the home. I don't know if they were specifically Oxycontin.
Were they fentanyl?
No.
Were they tested at some point in the course of this investigation?
I don't know. I could review supplemental reports and get that information, but I don't know.
But you don't know. Were there any illegal drugs or drugs that were prescribed that were seized in that April of 22 search?
I don't believe so.
Did there come a time that some THC gummies were seized?
Yes.
Do you know when that was?
I would have to check dates on the receipts of those items and evidence. It could have been during that first search in April, or it could have been on a subsequent search. I'm not sure.
So there may have been illegal substances or THC, which is an illegal substance, found in that search.
I believe THC was found in the home during one of the search warrants executed on the home.
Right. And were they in the form of gummies or some other form of THC?
They were edibles.
Edibles. So were the edibles, were you made aware, or are you aware of who the edibles belong to?
We received statements that they belong to Eric, to the decedent.
Were those edibles tested?
Yes.
And did you review a report regarding those edibles?
Yes.
And did that report, that initial report, say that there were traces of fentanyl in those edibles?
No.
You did not review a report that said there was fentanyl in the edibles?
No.
So, as you were investigating this case, well, let's strike that. I'll come back to that. So you talked about that your first interview in this case was with Kouri Richins. What was the date of that interview?
I believe it was April 14th of 2023.
So this was about 13 months after Mr. Richins' death.
Correct.
So you said before that conversation with Ms. Richins, and where did that conversation take place?
At her home at 282 West Willow Court in Francis.
All right. And you had reviewed a number of reports prior to that interview.
Several, yes.
So you had an idea of the investigation that Detective Woody had already done on this matter.
I had a partial understanding of the investigation that she had conducted.
Who was with you when you did that interview? Were you alone, or was there another officer with you?
No, Sergeant Hoffmeyer was with me as well.
Sergeant. Had you discussed this matter with him prior to this interview?
I just requested that he accompany me because we had both newly been put into the investigations division and would both be fairly involved with the case.
All right. Had you read correspondence prior to this interview with Ms. Richins, from Ms. Richins' prior counsel to the Summit County Sheriff's Office?
No.
So you hadn't read any correspondence where Ms. Richins' counsel asked that she not be interviewed with counsel present? You hadn't read those yet?
No, I had not.
Now, taking over as lead investigator, didn't you know that she was represented by counsel?
No, I did not.
During the interview with Ms. Richins, did you become aware that she was represented by counsel?
Partway through the interview, it became apparent, yes.
But you didn't ask her at any time during the interview if she wanted counsel present, correct?
I did. I told her partway through the interview, her mother, Lisa Darden, came to the home, and she made a statement about whether or not Kouri should talk to us without, she said the word Sky, the name Sky. I assumed that that was an attorney that she had contacted. And at that time, I told her, if you would rather have an attorney present here while we talk, that's fine. And she declined.
Let me show you just a portion of that interview. Hopefully, if you can give me that. Page 215. Can we show this on the screen to the witness? Thank you. If I could direct you, Detective, to the very bottom of that page as your statement at the bottom of that page. If you could just review that, not read it out loud, but if you could review that. Now that statement was made as you were leaving the house, correct?
It appears so, yes.
And do you recall that statement that you made to Ms. Richins as you were leaving the house?
Yes.
And what was it you told her then?
I'm sorry, I don't understand the question.
What was it you told her as you were leaving the house, reflected in that statement?
In this statement?
Yes.
That she could have an attorney present while we talk. I'm guessing that's what you're getting at.
Well, but you finished talking for that day, correct?
I believe so.
This was, in fact, the very end of the transcript as you were walking out of the house, correct?
It looks like it.
And you told her if she wanted an attorney at future interviews, that would be fine.
Yes.
Right. Does that, we'll start that. Isn't it true, Detective, that that is the only time that you told Ms. Richins that you wished to?
Statement midway through the conversation. If it's not in the recording, then I didn't. But I do remember making the statement that we were happy to have an attorney present while we spoke to her.
At least as you were leaving.
Yes.
So let's talk about some of the investigation and interviews you did prior to Ms. Richins' arrest. As part of your investigation, is it true, isn't it true, that you looked into Kouri's relationship with a Mr. Grossman?
Yes, some other investigators, I wasn't directly involved with contacting Mr. Grossman, but yes.
And that is someone that you have referred to, or I don't know if you personally, but has been referred to in transcripts as Ms. Richins' paramour, correct?
Correct.
And you reviewed texts between Ms. Richins and this individual, isn't that correct?
Correct. Detective started investigating associations and contacts of both Kouri and Eric Richins. Investigators from our office were familiar with her background in having a criminal drug history, and she became the target of a separate investigation as she related to Ms. Richins.
Could you maybe just explain that for me a little more? How was she a target related to the Richins case?
Text messages were located in the defendant's phone from a phone number that was found to belong to Carmen Lauber. At that time, detectives started looking into Carmen Lauber and her activity. They found that she was on a drug court program in another county, and started investigating her as related to Ms. Richins, having worked with her and having cleaned houses for both her business, her realty business, as well as her personal home.
So just to clarify, Ms. Lauber did cleaning for Ms. Richins' business and in the Richins' household. Did I have that straight?
Correct.
All right. And did you execute a search warrant, or was a search warrant executed on Ms. Lauber's home?
Yes.
Were you present for that?
Yes.
And were there illegal items seized during that time?
Yes.
Was she arrested at that time?
Yes.
All right. Do you recall when that was?
I believe it was towards the end of April 2023. I don't know an exact date.
So after Ms. Lauber's arrest, did you interview her?
Yes.
How many times have you interviewed her since April of 2023? You or others associated with this investigation? Clarify.
I believe 4 official planned interviews
about unplanned, unofficial interviews?
I've spoken with her, but not in an interview setting. Since that's what I'm getting at. Interviewing her in connection with this case, there were 4 that I'm aware of.
Do you know how many hours you've spent interviewing her or others associated with this case?
I believe at the detention hearing, I testified that it was around 10. I believe that's accurate.
So when did you initially interview Ms. Lauber?
It would have been, I believe, April 26th, shortly after her arrest, maybe the day or 2 after her arrest.
All right. And during that initial interview, can you tell me what took place during that interview?
We spoke to Ms. Lauber about the items that were found in her home subject to the search warrant. We told her that the charges that she was facing, that she was on drug court probation for in the outside county, could continue to be charged against her due to a violation of her drug court. We told her that she was facing felony distribution charges in that case.
Can I interrupt for 1 second? Distribution of what?
Controlled substance.
What did you seize from her home?
So the charges that she was facing in relation to her drug court were separate from the ones that resulted from the search warrant. But we found illicit THC products as well as a firearm in her home.
And why was the firearm of significance?
It was a violation of her drug court probation to be in possession of a firearm.
Well, she was a convicted felon, isn't that right?
Yes, that's also pertinent.
So she was also potentially looking at charges of felon in possession of a firearm, correct?
Correct.
And you told her that in the first interview?
Correct.
Did you tell her that those would be state or federal charges?
I believe we told her that they could be both.
They could be both, or either.
Either, right.
Did you tell her potentially how much time she could be looking at in prison if she was charged and convicted of these additional offenses?
I don't recall saying a specific number of days, but I know we made mention that there was significant jail time attached to those charges.
Significant prison time.
Prison time.
All right, so what did she tell you in that first interview about her associations with Kouri Richins?
She confirmed that she had worked for Kouri in the past. She told us that she knew Kouri through Kouri's Aunt Doreen, whom Carmen worked for, cleaning houses. She initially stated that she didn't know anything about what had happened with Eric's death or anything about fentanyl. And we explained to her that the position that we were in to try to investigate anything that might have happened, whether that was inculpatory or exculpatory for anyone, and that any information that she might have about it would be helpful to us.
All right, if we just break that down just a little bit. What did she tell you about ever dealing fentanyl at that time?
She said that she hadn't really ever, in her words, messed with fentanyl. Then she later admitted she had tried it once and didn't have a good experience with it.
Did she tell you a daughter had overdosed on fentanyl?
I don't recall. I could review the video and give you an answer on that, but I don't recall.
And isn't it true she told you she never dealt with fentanyl, that she dealt in pain pills and marijuana and other things of that sort?
In the first interview, yes.
And what did you tell her you could do for her if she gave you information about Eric Richins' death or anything that could help you in the investigation of Eric Richins' death?
We explained to her that if she had information regarding Eric Richins' death, that we could work with the prosecutor who was responsible for her charges for both the search warrant and the drug court charges. We didn't make her any specific promises, but we told her that we were willing to work with the prosecutor's office on those charges.
Is Ms. Lauber in custody at this time? Is she in jail?
No.
All right, was she ever charged with anything that was to do with dealing drugs, a violation of her drug court, or with anything that was seized during that search?
I don't know. I don't believe so. I had no dealings with the inner workings of that county's prosecutor's office after we interviewed Ms. Lauber. After we interviewed Ms. Lauber, we informed the prosecutor's office that she was being cooperative with our investigation, and then they and her attorneys worked out whatever kind of deal they worked out with her.
Well, isn't it true, Detective, that you went back and spoke with Ms. Lauber and guaranteed her that she would not be charged in any way as connected to Eric Richins' death if she continued to cooperate?
I didn't make that statement in those words, but we impressed upon her that, yes, in exchange for helpful information in this case, that she could potentially have reduced or eliminated charges.
Well, I'm going to jump ahead a little bit because I know you had a number of interviews with her, and I've certainly reviewed at least 6. Because those interviews were recorded, correct?
Correct.
And any interview that you had with her would be turned over to defense counsel, correct?
Correct.
All right.
Well, we turn it over to the state, and I believe it's their
All right.
opportunity to turn it over to the defense.
So if I represented that they have turned over at this time 6 interviews with yourself and Ms. Lauber, or with, who was the other detective that was with you during those interviews?
Detective Maynard.
Detective Maynard. That they've turned over 6 at this time. Would that sound correct to you?
Yes.
All right. So I want to go to the 6th interview, which was May 13th, 2023. Does that sound right?
Yes.
So isn't it true at that interview, you told her that she was going to be testifying in front of a federal grand jury?
I don't recall that.
Yarkis?
Am I in the video that you're referencing?
Yes, you are.
Okay. I don't recall that.
So you don't recall that you told her that you and Detective Maynard had discussions with the U.S. Attorney's Office, and that they had guaranteed you that she would not be charged in connection with Eric's death so long as she testified in front of the grand jury?
I don't remember it, but it doesn't sound unreasonable.
You're the lead detective, right?
Yes.
Did Ms. Lauber testify in front of the federal grand jury regarding this case?
I don't believe so.
You don't believe so. Do you know? Yes or no?
I don't know for a fact.
You don't know. Did you testify in front of a federal grand jury regarding this matter?
No.
Do you know of anyone in your investigation that testified before a federal grand jury?
No.
But you do recall telling her that she would be testifying before a federal grand jury the next week.
I honestly don't remember it. I'm not surprised by the information because when we were working with prosecutors' offices at the time, there were both federal prosecutors and state prosecutors that were involved in it. And that sounds like a likely discussion that could have been made that she would need to testify before a grand jury.
The next week.
Like I said, I don't remember those. If I review the video, I probably could speak to it more.
Did you review an interview that Detective Maynard did with Carmen Lauber on the day before that, May 12th, regarding a Zoom meeting he had had with different agencies, in this case, federal and state?
I believe so.
And do you recall in that he explained to her what she would be doing in terms of testifying in front of a grand jury?
Again, I don't recall the discussion about the grand jury. If I review the video, I can speak to it more, but I just don't recall it from my memory.
All right.
I don't believe that video is one that I have recently reviewed. I reviewed the initial 3 or 4 that we had with Carmen prior to this hearing.
All right. We'll go back to those in just a minute. Let me ask if you recall this. Do you recall telling her on May 13th, that she would be testifying in front of the grand jury, and that the goal would be to convict Kouri Richins of murder. Do you recall that?
No, I do not.
Ms. Lauber got a letter of immunity from the United States Attorney's Office for the District of Utah, did she not?
I believe so, yes.
But you don't know if she testified in front of the grand jury.
I do not.
So tell me the first interview. I'm going to go back now to that initial interview in April 2020, or April 27th, 2023.
Okay.
How did that interview end?
Can you tell me the date again? April 27th, the first time we
Yes, the
spoke.
very first time you interviewed her.
We told her that she probably had some things to think on and consider, and that if she decided she wanted to talk to us about this case, that she could contact us, or that we would be in contact with her again shortly.
Yes. So did you tell her you'd be back in a few days after she had some time to think about what had happened?
Yes.
All right. And did you go back in a few days?
Yes.
Do you recall the date that you went back?
I believe it was the following Tuesday.
So if I told you that was May 2nd, 2023, would you have any reason
Sounds
to?
accurate, yes.
Sorry, I don't mean to talk over each other. Go ahead.
That sounds accurate, yes.
All right. So the second interview. What did you tell Ms. Lover in that interview?
We told her a lot of things. Do you want to talk about something specific?
All right. Did you ask her if she had time to reconsider her relationship or her activities with Ms. Richins?
I believe so. When we first sat down and she entered the interview room, she immediately started telling us that she had been thinking about calling us and wanted to talk to us.
All right. And you reminded her that she was looking at serious charges, and you guys would have her back. You would help her if she cooperated.
Yes.
Had you seized a phone, a phone from Ms. Lover at that time?
Yes.
Was there more than one, or did you seize one?
There was more than one. There were two, I believe, that we relied on for evidence and content. There were multiple old phones, I believe, that were seized from her home, but the two that we downloaded and were subject to our investigation, there were two.
Were either of those phones, were either of those phones ones that she was using in March of 2022?
I believe so, yes.
I think one of them was. All right. So what did she tell you in that second interview about communications between herself and Ms. Richins that she thought might be helpful to you? Sorry, I'm interrupting her.
In most, if not all, of the interviews that we had with Carmen, her memory went back and forth on what happened, what didn't happen, and which times those things happened. So chronologically, it's hard to say where we went in the interview. But she began very slowly, and it appeared to us that she was minimizing her involvement, but said that she had participated in some way in getting Kouri illicit substances. And like I said, it began small and her minimizing her involvement, and developed into more specific statements.
And these statements took place over the course of 3 or 4 additional interviews.
Correct.
Your Honor, the state objects on relevant grounds. As the court's aware, Ms. Lauber submitted testimony by 1102 witness statement. And the standard for the preliminary hearing is notwithstanding credible testimony to the contrary. The court's also well aware that Article 1, Section 12 of our Constitution and progeny case law says that discovery is not a proper purpose for this hearing.
Well,
help me out, where are we headed here?
Well, Your Honor, Mr. Bloodworth had stated as we were at the beginning of the hearing that in large part he was putting Detective O'Driscoll on in the interest of fairness and justice because Ms. Richins' current counsel had never had the opportunity to cross-examine him on his prior testimony. And he testified in his prior testimony about these things. So my understanding was that this was our opportunity, since we haven't had one before, that was agreed upon and represented to the court, to cross-examine him about that prior testimony, even though this is a preliminary hearing. And these facts very much go to probable cause.
It's the last part that I'm not following you on. How do these go to probable cause? I don't think I've heard anything that sounds like testimony that Carmen Lauber did not have the opportunity to perceive or know the things that she claims to have perceived or known. I don't get to weigh credibility outside of those extraordinary circumstances in a preliminary hearing. I'm trying to give you as much latitude as the state will agree to. I'm staying out of the way, but at some point the limits on probable cause determination kick in.
All right, well, based on the earlier discussion with the court, I'd like to go a little farther in terms of reviewing his testimony from the prior hearing.
Understood. If you need clarification of it, but if I imagine, don't hold me to this, but I imagine that if we keep reviewing the investigative steps and potential sources of bias on Ms. Lauber, you're going to continue drawing objections regarding relevance.
I understand. All right.
We'll give Ms. Lewis some additional limited latitude here, Mr. Bloodworth. Let's see where we go.
So when you testified before, did you testify as to how many times Ms. Lauber had allegedly provided drugs to Ms. Richins?
I believe so, yes.
And how many times did you say that happened?
At that time of testimony, we understood there to be 3 transactions that Ms. Lauber participated in with Ms. Richins.
And what were the dates of those 3 transactions?
February 11th, February 26th, and March 9th of 2022.
March 9th, after Mr. Richins had passed away.
Correct.
Right. And did you testify at the prior hearing, or do you recall what Ms. Lauber said she provided to Ms. Richins, what sort of drugs she provided to Ms. Richins on those 3 occasions?
Again, it went back and forth with details and was clarified the more information she was presented with from phones and other physical evidence. The determination we came to after the conclusion of all 4 interviews was that she had procured some type of prescription or non-prescription opiate on the first transaction, and that the following 2 were fentanyl pills, counterfeit fentanyl pills.
And so you said that in the first interview, she told you that she didn't deal in fentanyl. Can you just explain what you did in your investigation to try and confirm? How did you come back around to that it was fentanyl?
So in the initial interview with Ms. Lauber, and the statements she made about not having dealt in fentanyl before, in my opinion, my experience with interviewing people, especially in custody, I think she was minimizing her involvement. I think she was trying to cover herself from any type of further legal problems. And then after we came back the second time, I think she had changed her mind about how much information she wanted to reveal to us. And that's when she started talking to us about the fentanyl pills, and that she recalled specifically that they were fentanyl.
And did you interview other people regarding those transactions?
Investigators from the Summit County Sheriff's Office did, yes. I wasn't involved in every single interview, but yes.
Did she tell you how many pills total that she provided to Ms. Richins, or that she recalled providing?
One moment, please. Mr. Bloodworth.
Your Honor, the state reduces relevance of objection. What's going on here is defense counsel is asking questions about the detention hearing, which the defense counsel has a transcript of. Did she tell you this? Well, we know this because he testified to it.
Let's just assume that this question, which goes directly to the probable cause determination, is foundation for whatever's coming next. So I'm going to allow this.
I appreciate it, Your Honor. All these recordings are, all these interviews are recorded in discovery and can be interviewed.
I understand. Your objection to the extent it's relevance is overruled. Ms. Lewis, please proceed.
Did she tell you a number of pills, the number of pills she provided to Ms. Richins?
Are you meaning in total or per transaction?
Either way, whatever is easiest for you to
She
explain.
made an estimate of approximately 15 to 30 pills per transaction.
So a total of
Maximum of 90.
75, 30 to 90,
30 to 90.
45 to 90 pills. All right. Did you have any of those pills ever been found?
No.
None in the Richins' home?
No.
Correct? None in Ms. Richins' car, correct?
No.
So you've never had the opportunity to test any pills that were allegedly provided from Ms. Lauber to Ms. Richins, is that correct?
Correct.
Not one, correct?
Correct.
So the only knowledge you have as to what those pills were came from Ms. Lauber, correct?
And corroborating witnesses.
Corroborating witnesses that
That supplied Ms. Lauber with the pills or put her in contact with the person that supplied her the pills.
All right.
Or drove her to the transactions where the pills were purchased.
Okay. Again, though, have you tested any of those pills or found any of those pills so they could be tested?
No, we have not.
So you actually do not have any idea what the pills were that were given to Ms. Richins, correct?
Just based on the testimony, witness statements by Ms. Lauber and others.
But you don't know.
I don't know.
So you don't know if the pills were OxyContin, correct?
No, I do not.
You don't know if the pills were fentanyl, correct?
Based on what Ms. Lauber told us, she was sure that they were fentanyl. And her description of them match what I know currently to be Drug Trends street illicit fentanyl pills, with the description being a light green to blue round pill.
So let me ask you again. Do you know if any of those pills contain fentanyl?
No, I do not.
Do you know if these pills contained illegal drugs, opioids of any kind?
I do not.
When is the last time you sought evidence in this case?
Sought evidence, is that what you said?
Yes.
The case is active and ongoing until trial. I presume any new information that comes to us will continue to be considered as evidence.
Are you still interviewing witnesses?
Not at this moment, no.
I know you're not at this moment. You're here testifying. Have you recently interviewed witnesses or others investigating this case or involved in this case been interviewing witnesses?
Yes. Some of our team have reached out to witnesses that we've talked to in the past and have kept in contact with them.
Have you been provided statements or interviews by a private investigator in this matter?
They've been entered into systems that I have access to, yes. Not personally been provided with them, but yes.
Who does that private investigator work for?
The Richins family, the Eugene Richins family.
Is that who pays this private investigator to provide information to you?
I assume so.
When was the last time you executed a search warrant in this case?
I believe it was 1 or 2 weeks ago on the Richins home.
Still looking for the bills?
That was to seize a voice recorder that was located in the home.
All right. Okay, one moment. Just back up for one moment about the pills. So you said you interviewed other people. I think it was one other person who provided allegedly fentanyl to Ms. Lauber. Is that correct?
There were 2 individuals that we interviewed that were reported to have provided Ms. Lauber with the pills. One with the non-fentanyl opiates, and then with the fentanyl pills.
Okay, so one provided the one that did not have fentanyl, and one provided the ones that she claimed did have fentanyl.
Correct.
Okay, so that individual, or actually either of those individuals, were they manufacturers of those pills?
I don't know. I don't believe so.
Well, one of them told you it was for prescription, correct?
I believe Ms. Lauber told us that. Would you like me to use names? That's fine. I believe Ms. Lauber told us that Ms. Kohler, who she claimed she got the non-fentanyl pills from, that they were somebody's personal prescription.
Okay. So we don't actually know where those pills came from either?
No.
All right. And the individual who provided fentanyl, he was not the manufacturer of fentanyl. He told you he didn't manufacture fentanyl, correct?
I believe so. Other detectives in our office, yeah, interviewed him.
All right. Do you know what red devils are?
No, I do not.
Did you record all of your conversations with Ms. Lauber, or if someone else was interviewing them, were they all recorded?
Interviews, yes. We've yes.
Besides Kouri Richins, did you interview or investigate into any other possible suspects in this case?
Interview, no. I personally try to keep an open mind as to all possibilities of what could have caused Eric Richins' death. But I didn't conduct interviews with any other suspects that were persons of interest labeled as suspects.
You didn't collect phones or look at anything else from any other suspects, correct?
We collected several phones from involved individuals in this case, and potentially people that could have had access to the Richins home at different times, that could give alternate explanations of how the fentanyl got in the system. But I didn't conduct any interviews of individuals regarding their involvement.
One quick moment. Nothing for me, Your Honor.
Mr. Bloodworth, a brief scheduling question. Roughly how much time do you have on redirect?
Less than 10 minutes.
Okay, please proceed. Wait, can we get some more water for the witnesses?
Thank you, sir.
Honor, I've marked the State's Exhibit 68, Utah Bureau of Forensic Services forensic analysis report related to the collection of THC gummies. I'm going to, can I approach?
Of course. Ms. Lewis.
I just can't hear Mr. Bloodworth.
Okay.
So I'm
Stay
sorry.
a little closer to that mic.
I'm forced to remark.
So am I.
Evidentiary
Obviously.
argument this morning.
Oh, yeah, well.
Sorry.
I'll try to talk into the microphone, Your Honor. Detective O'Driscoll, do you recognize what's been marked as State's Exhibit for Identification 68?
Yes.
You testified earlier regarding toxicology on some THC gummies. Do you recall that?
Yes.
Does that toxicology report reference the THC gummies that you were testifying to?
It appears to, yes.
And then are you familiar with the difference in toxicology reports between fentanyl being indicated and fentanyl being found?
Yes, I'm remembering discussions with our evidence technicians, our forensic technicians, and that there's a difference there that I didn't know before.
I mean, what was the bottom line of that discussion with the evidence technician?
The bottom line was that something could be tested and indicate for precursors or some chemical structure that I don't fully understand that could indicate possibilities of fentanyl, but the state crime lab won't say for certain that fentanyl is present.
And in that instance, the reports read as that one does, am I right? Fentanyl indicated, not identified.
Correct. It says fentanyl was indicated in the gummies in the plastic bag.
May I treat this? Your Honor, the statement states 68 in the evidence.
Ms. Lewis, any objection?
No objections under the same considerations of all the exhibits in this
It'll
hearing.
be admitted for the purpose of the preliminary hearing only.
Yes, Your Honor. Your Honor, the state directs the court to item 14, which begins on the bottom of page 2 and continues to the top of page 3.
Thank you.
Detective O'Driscoll, you testified on cross-examination regarding interviews with Carmen Malver. Do you remember that?
Yes.
Are all those interviews either audio recorded, video recorded, audio recorded or audio and video recorded?
Yes.
And to the extent your testimony recollecting back over a year would differ from the recordings, do you think the recording is the accurate testimony?
I do. I sympathize with Ms. Lauder at this point, having been a year past the last time we talked about this.
Sure. Did you have an opportunity to watch a video recording of an assistant U.S. attorney and some federal investigators interviewing Ms. Lauber?
I didn't view it, but I was told about it.
Were you told that they were interviewing her kind of pursuant to a grand jury subpoena and before the grand jury testimony?
Yes, I'm remembering now that their appearance there, their interview of her was in regard to a grand jury subpoena that at the time we were not aware that they were planning.
Regarding Ms. Lauber's testimony, Ms. Lauber's interview with you and Detective Mayer, I want to perhaps clarify some of the transactions. Is it right to say that Ms. Lauber testified to one transaction with Susan Kohler involving Roxy's?
Yes.
And then a transaction involving fentanyl on February the 11th, a second fentanyl on February the 26th, and a third on March 9th.
Yes.
Regarding the fentanyl portions of the conversation, separate than the Roxy portions of the conversation, did detectives from Summit County talk with the intermediary between Cartman Lauber and the ultimate fentanyl dealer to Ms. Lauber?
Yes.
And did that intermediary say that Ms. Lauber requested fentanyl?
Yes.
Did Summit County detectives talk with the man who distributed the fentanyl to Ms. Lauber?
Yes.
And did he say that she requested fentanyl?
Yes.
And that he ultimately provided fentanyl?
Yes.
Thank you, Your Honor. Nothing further.
Just 3 or 4 questions.
Within the scope of reprint, please.
Yes, understood. You said that all interviews with Ms. Lauber were recorded, correct?
For sure, all the ones that I was involved in, yes.
All right. So does that mean that there have been meetings and discussions with her, with Ms. Lauber and either yourself or other people, the Summit County Sheriff's Office or the prosecution not recorded?
Not that were substantive in content in regards to the case. We have on occasion spoken with Ms. Lauber because she was placed on supervised probation by an out-of-county court and was to be under ankle monitor that was supervised by our department. So we have talked to her about compliance with those orders. We have also transported her, given her a ride to meetings with her attorney, and so there has been small talk, but not interview about the case that has not been recorded.
Okay. You drive her to her meetings?
She needs a ride sometimes.
So you just, in discussing this with, in answering Mr. Bloodworth's questions, you said that Ms. Lauber provided fentanyl to Ms. Richins 3 times.
I know that Ms. Lauber had difficulty remembering all the details of her interactions with Ms. Richins. I know at the time that we conducted the interviews, what she had told us in those interviews is what I testified to at the detention hearing.
And that was that there was 1 time that was oxycodone and 2 times that she said she delivered fentanyl. Isn't that right?
Correct. Since those interviews, new forensic information from cell phones was received, was reviewed, and determined that there were 3 transactions involving fentanyl, including one after Eric Richins' death. I believe the most accurate statement from Ms. Lauber is the 1102 statement that she submitted for today's hearing.
All right. You said that you spoke with the individual who allegedly provided fentanyl to Ms. Lauber, and you just testified that he told you she asked specifically for fentanyl. That's not accurate, though. Correct?
He told, from what I'm remembering from watching the video of the other investigators that interviewed him, he told us that Ms. Lauber requested, in his words, blues, which I understand to be fentanyl pills.
Didn't he say she requested Roxy 30s? Or Roxy's?
It's possible. I think blues was also mentioned.
Roxy's are typically oxycontin, correct?
Yes.
So as you're sitting here today, Detective, can you say with certainty that the pills that Ms. Lauber allegedly gave to Ms. Richins were the pills that were taken by Eric Richins, or were pills that were taken, if any pills were taken, by Eric Richins?
No.
And as you sit here right now, do you have any idea, like actual knowledge, not an idea, let me rephrase that, do you have any knowledge of how fentanyl got into Mr. Richardson's system?
No.
Mr. Richards' system? I'm sorry.
No.
I
Anything further for the detective, Mr. Bloodworth?
No, no.
You can step down, sir. Thank you. Mr. Bloodworth, it's now an appropriate time to take a lunch break.
Yes, Your Honor.
Ms. Lewis, any objection?
No, Your Honor.
All right. Come back at 1:30. Does that sound workable?
Yes, sir.
Thank you.
Okay. We will be in recess until 1:30. Please follow the deputy's instructions so we can do this in an orderly way. I wish you all the very best. Thank you. Court's in recess.
Alex, do you want to step here?
All right, Rich, let's go there. All right, counsel, let's go back on the record. We're back on the record in 231-500-139. Mr. Bloodworth, anything before we continue with the state's case?
No, Your Honor.
Ms. Lewis, Ms. Nestor?
No, nothing else right now.
Okay. The state's next witness, please.
Your Honor, the state calls Christopher Kouri.
Oh, we have Frankie swear you.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the fees and penalties of perjury?
Thank you. Sir, could you please tell us your name?
Chris Kouri.
Is that a common spelling of the last name?
Yes.
Thank you. Mr. Kouri, what can you briefly tell us your background?
Yes, I'm a 23-year law enforcement veteran. The last 11 years of which was spent with the Salt Lake City Police Department Homicide Squad and the Salt Lake County District Attorney's Office Homicide Team, where I was an investigator there.
And did you retire from law enforcement?
I did. At the end of 2022, I retired.
What have you been doing since then?
I started an investigations firm.
And what's the nature of the investigations that you do?
So we do investigations, training, and consulting work. So regular investigations for criminal and civil offenses, training for attorneys and investigators related to various subject matters. And then I also do some consulting work in criminal and civil cases as well.
Do you have any education, training, or experience with forensic digital evidence?
I do.
Can you briefly describe that for the court?
Yeah, so formal training. I have a 40-hour certification from a ZX Trax. It's a 40-hour training course, call detail record analysis and location mapping. I also have a 40-hour formal training, also with ZX Trax, as a subject matter expert. I'm a Cellbrite certified operator and a Cellbrite physical analyzer certified as well.
Judge, may I ask if Mr. Kouri was going to put the mic closer to him?
Thank you. And since you've talked about that, what is Cellbrite?
So Cellbrite is it's extraction, it's device extraction hardware and software. It extracts data from electronic devices.
Have you been retained by the state in this case?
I have.
In what role?
As an investigative consultant and to analyze digital forensics data.
And have you analyzed and reviewed digital extractions of cell phones in this case?
Yes, I have.
I want to talk to you about a few phone numbers and just to identify phone numbers of different cell numbers or cell phones you have analyzed in this case. Do you recognize the phone number 435-671-1987?
I do.
Whose phone number is or was that?
That was the primary cell phone for the defendant.
You get kind of quiet again. Can you pull that microphone?
It's and the phone. There you go.
Normally that's not an issue.
There. Can you just repeat that answer?
Yeah, that's the primary phone number for the defendant.
When you say primary, does that mean that there were other phone numbers that the defendant used?
Yes.
And do you recall what those numbers were?
Yes, there's two other numbers that we're aware of. One ends in 1152, and the other ends in 9592.
And when you say that the 1987 was the primary phone, what leads you to believe that was your primary phone?
In this context, it's the phone that the defendant utilized for normal, everyday business, communications with most friends, her business, that type of thing.
And the other numbers, let's talk about the 1152. What kind of device was that associated with?
That was associated with her 1987 device, but it was a number being utilized on that device. It was a Google Voice number.
Okay. So, can you just describe what a Google Voice number is and how it can be used on a cell phone?
Sure, it's basically a number that you create through Google Voice services, and you can use it just like a normal cell phone. You can make calls, receive text, that type of thing, and it's utilized through Google Voice app.
Now, the 9592 number, was there a device that was associated with?
Yes.
What was that?
It's referred to in evidence as a blue phone, but it's an iPhone that was obtained by the defendant after her original phone was seized by police in April of 2022.
So was that phone activated roughly at the same time?
Yes.
Now, speaking specifically to the device that the 1987 number was associated with, did you observe a forensic extraction of that phone?
Yes.
And did you analyze that extraction?
I did.
Did you notice any information or data deleted from that phone between January and mid-March of 2022?
Yes.
And can you describe what type of, or types of data have been deleted off that phone?
A lot of data. Primarily and most relevant to the investigations in this case, the call logs, texts, web history, and web search.
So when you say that the texts have been deleted, does that mean the entire text threads between different parties?
Yes.
And was it everybody in that time frame, or were there specific people?
Pretty much everybody.
Now, you mentioned that web history had been deleted.
Yes.
And was there a specific date that prior to which that web history had been deleted?
Yes. So there, on that phone, the web history for that device, that primary device, was basically ended. It picked back up on March 10th of 2022, but prior to that, all of it was gone.
The deletions that you observed on that extraction, can you say how those deletions were made?
No. I would presume it was completed like most deletions are completed on a phone, which is manual deletion. But there's no indication in the software of, any other means of that, whether it was active or remote or anything like that.
Okay. The data's just not there.
It's just not there.
I want to talk to you about a person came up during this investigation by the name of Josh Grossman. Did you associate a phone number with a device belonging to him?
Yes.
Do you recall what that number was?
The last four is 1260.
And a witness by the name of Carmen Laubert, did you identify numbers belonging to devices that were associated with her?
Yes.
And was there a primary number that was associated with her device?
Yes, and I believe the last four of that was 6127.
Same question for a Robert Crozier. Do you recall the number for him?
Yeah, Indian 0540.
And finally, you're almost done with this test. Mr. Richins' phone number. Do you recall his phone number associated with him?
Yeah, last four of 9317 for Mr. Richins.
Thank you.
That passed.
Great. We'll get back to you. I want to talk to you about the defendant's communications with Carmen Lauber. Between the time period, well, let me ask this first. Were you able to determine by other means besides the defendant's phone whether there were communications between those two?
Yes.
And specifically for the time period of roughly January 1st, 2022 and March 15th, 2022?
Yes.
And where were you able to see evidence of those communications?
Through the call detail records.
Whose call detail record?
I primarily focused on the defendants, but also Ms. Lauber's as well.
And what does a call detail record tell you?
A call detail record is exactly what it sounds like. It's a detail of calls recorded through a carrier. It will tell us, tell an investigator or anybody looking at the record. The timestamps and the direction of the communications would, yes.
What about location data?
Yes, potentially.
What you say potentially? What would cause it not to be available?
Time, quite frankly, is usually the inhibitor there. But most carriers retain call detail records for a year to 2 years with location history. It could also be that a carrier does not report location data for, say, for instance, text messaging. Some carriers do, some carriers don't.
I see. Specifically, the carrier for the defendant's phone, was location data available for the call detail records that you analyzed?
At the time the records were sought, no.
And do you know why that was?
Time. Okay. Yeah, Verizon retains location information within call detail records for 1 year.
I would like to turn your attention, if I can grab a binder of the exhibits that have been pre-admitted here, to Exhibit 33. Have you seen that Exhibit 33 before?
I have.
And what is that?
This is a Facebook Messenger record between Ms. Lauber and an individual named Nicole Cummings.
Do you know who Nicole Cummings is relative to this investigation?
I do.
Who is that?
My understanding is a friend of Carmen Lauber, in which the friend is the one in which Carmen received a second phone number for Mr. Cruzier.
I see. Now, turning over to 34, State's Exhibit 34, do you recognize that document?
I do. 34? Yes.
Yes. And what is that?
This is it's like a phone extraction record.
And the bottom input in that record, is there any number there that is relevant to this investigation?
Yes.
What is that?
This is a message, or this is a contact in a device for a number identified as Mr. Crozier's number, the ending in 0540.
And is the name of that contact Robbie-Nick?
Yes.
And is that the same Nicole that we spoke of a moment ago?
Yes.
Now, I don't necessarily need you to go through those, but I'm referring now to State's Exhibit 35. In Ms. Lauber's call detailed records for her device, do you see communications between her and Crozier on February 10th of 2022?
Yes.
And do you recall approximately when those began?
It was in the evening. I don't recall the exact time on the 10th.
Do you see calls between them on February 11th as well?
Yes.
Also on February 11th, through Ms. Lauber's call details records and the defendant's, did you observe any text messages between them on that day?
Yes.
Do you recall how many?
About 30, I believe.
And were there any text messages the next day, February 12th of 2022, between Ms. Lauber and the defendant?
Yes.
And do you recall when those occurred?
I don't. I want to say midday, but I'm not 100% sure.
Okay. But those would be contained in State's Exhibit 35, that call detail record?
Yes.
And speaking of these, the call detail records, are these in Mountain Daylight Time or Mountain Standard Time?
These are UTC time.
Okay. And UTC is what time?
It's Greenwich Mean Time. It's basically 0. It's a method for everybody to basically stay on the same time zone, as odd as that sounds. Basically, you just add or subtract your time zone from UTC to get local time.
So if these are in February of 2022, what subtraction would have to be made to find the local time?
7 hours. So during daylight savings, when we fall back in November-ish, we go to -7, and then we spring forward in March usually, where we're -6.
Okay. Thank you. Moving ahead to the February 14th, 2022 call detail records. Did you observe any, moving away from that. Did you observe any text exchange between the defendant and Ms. Lauber on that day?
On February 14th?
Yes.
Yes, sir.
You recall approximately how many?
I don't, not off the top of my head. It's several.
More than a dozen?
Yes, I want to say 30 again. Seems right.
I want to turn your attention now to State's Exhibit 43. Well, and before we go on to there, I just want to clarify, when you see this call detail record, you're not seeing the content in any of those messages, correct?
Correct. Only that the message was completed, sent and received.
Okay. But when you do a forensic extraction of a device, if those the content of those texts are still on the phone, can you see the content at that time?
Yes.
On February 26th of 2022, do you see communications between Ms. Lauber and the defendant on that day?
Yes.
Do you recall when they started communicating?
It was in the evening. I want to, if I recall, around 5 p.m., 4 or 5 p.m. on the 26th.
And you recall when they stopped?
About 10:30 that night.
From those call detail records, specifically from Ms. Lauber's, were you able to see where she traveled that day?
Yes.
And was she at or near a Maverick and Draper that day?
She was.
And how are you able to tell that from the call detail record?
So within that call detail record, AT&T is Ms. Lauber's provider. AT&T does provide location data for SMS messaging. So we're able to determine what tower is being utilized within Ms. Lauber's device made or received text messages as well as calls. So we put it into a mapping software and are able to determine which tower was servicing the device during any given point in time.
So it's the location of the tower that phone is connected with, right?
Yes.
And down in the Salt Lake Valley near Draper, are you able to see multiple towers that, I mean, fair to say there's more than one tower in the Salt Lake Valley?
Yes, typically speaking, the more dense the population and the urban area, the more dense the cell phone arrays are.
Does that make it more accurate to pinpoint where that phone is?
Typically, yes.
And is the contrary to that true, the less populated an area is, the less cell towers there are?
Typically, yes.
Speaking specifically about Midway, are there less cell towers in Midway, Utah than there are at Intermediate Draper, Utah?
Yes, significantly.
Now, when Ms. Lauber's phone appears on those towers near Draper Maverick, was she there on any other dates besides that 26th?
Yes.
What dates were those?
February 11th, 2022, and March 9th, 2022.
Did you observe her phone being tracked in that area on any other time in the records you were?
No.
Were you able to track her movements from Summit County to Draper and back?
Yes.
And is that, again, just through tracking the towers that she's pinging off of?
Yes, the tower utilization, yes.
Okay. And we talked a little bit about Midway. Does the precise location become more difficult when she's in a more rural area?
In this case, yes.
Okay. And why is that?
You have less towers serving a larger area, so with a larger estimated range or area in which the device can be in, the harder it is to pinpoint more precise location.
I want to turn your attention now to Exhibit 31. If you could flip back there. Do you recognize what's depicted in Exhibit 31?
I do.
And what is that?
Is a depiction of messaging on a device from January 18th and January 20th of 2022.
And the top of that, the first page there says Kouri. Do you recall whose device these images are taken from?
I believe they're from Ms. Lauber's.
Can you take one more look at those?
I will, yes.
Could those be from a phone belonging to a Hayden Jeffs?
I mean, yeah, I need to look at the contents.
Oh, sure,
of the
sure.
text, just to make sure I'm looking at the right thing. Yes, I misspoke. These are devices from Mr. Jeff's phone. Or, I'm sorry, messages from Mr. Jeff's phone.
And they start on January 18th and they go to January 22nd.
That's correct, yes.
I ask you to flip to States Exhibit 36. Do you recognize the record depicted there?
I do.
Is that for number ending 1987, the device belonging to the defendant?
It is, yes.
Was there a call made at 8:53 a.m. on February 14th?
Yes.
And do you know who that call was made to?
I do.
Who's that?
A Mirror Lake Diner.
And moving to State's Exhibit 38. Are these call detailed records for a number ending 9317?
Yes.
And did that belong to Eric Richins?
Yes.
Was there a phone call between Mr. Richins and the defendant at about 11:09 a.m. that morning?
Yes.
And is there a record of a photo being sent or some sort of multimedia message at 11:27 that morning?
Yes, and that was obtained via Mr. Richins' device.
Okay, so that's not here in the call detailed records. That's it.
It's his physical device. Yes.
Were you able to see what that image was?
No.
Was that deleted from his phone?
It appeared to be yes.
And were you able to see that on the extraction of the defendant's phone?
No.
Why is that?
All of that was presumably deleted from the defendant's phone as well.
Did the activity on Mr. Richins' phone on the 14th of February 2022, did that cease between 11:39 a.m. and 1:32 p.m.?
Yes.
Was he active on that phone before and after that time period?
Yes, he was.
And can you describe the volume of his activity?
It would be what I would describe as normal phone traffic for that device. Calls and texts between friends, business-related things of that nature, yes.
Now, I'm not certain it's made it into the binder. I've handed you what's been marked as and admitted as State's Exhibit 7A. Do you recognize that?
I do.
What is that image of?
This is a screenshot obtained from a device of the defendant's phone, her navigation app within her device.
And is that from February 14th of 2022?
It is.
So this has not been deleted, correct?
From the defendant's phone, it was not in the defendant's phone. It was in Mr. Grossman's phone.
Okay, thank you for clarifying. Did that originate from the defendant's phone?
Yes.
Was that sent to Mr. Grossman?
It was.
And was that sent at approximately 9:48 a.m. on February 14th?
Yes.
Can you just give a little more description about what that navigation shows?
Sure, it's a typical screenshot of a normal navigation application. There is a location on Rockcliffe Road. The device is it's depicted that the device is traveling northbound, and it gives an arrival time, an estimated time of arrival, and a mileage for that trip that it's depicting.
And on Mr. Grossman's phone, were you able to read any text messages surrounding this time frame?
Yes.
And did the defendant indicate why she was sending this to him?
Yes.
Why is that?
She said she was on her way to see him. He asked if it was about an hour, if she was about an hour away, and she said yes and sent him this screenshot to verify her ETA.
Speaking to the defendant's communications with Mr. Grossman, do you recall approximately when those began?
For the 1152 number, which is the first one I'm aware of, it began, I have a trail, basically a digital trail on that phone beginning in November of 2021.
And what was the volume of text calls, anything of that nature, up until March of 2022?
The volume varied depending on the day, but it was pretty much daily communication between the two during that time frame.
And are these phone calls and text messages?
Mostly text, but yes, some phone calls.
And have a number of those texts been recovered from Mr. Grossman's phone?
Yes.
And if I could just have you just thumb through exhibits 29 and 30. Are those excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are they approximately December and January of 2021, 2022?
Yes.
And if I could have you thumb through 39 through 42. Are those also excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are those roughly the time frame of February and March of 2022?
Yes.
And finally, 3 exhibits, 44, 45, 46. You can look at those. Similar question, also excerpts from Mr. Grossman's phone?
Yes.
And are those specifically March 2nd and March 3rd of 2022?
Yes.
And finally, exhibits 50 and 51, if you could look at those.
Okay.
Also excerpts from that extraction?
Yes.
And a little bit later in time, March 20th and April 9th?
Correct. Yes.
So it's fair to say around the time that Mr. Richins passed away, there were ongoing messages between the defendant and Mr. Grossman?
Yes.
I'd like to ask you now about the extraction from the defendant's phone relative to the morning of March 4th, 2022. We discussed this at the detention hearing, correct?
Yes, we did.
And at that time, you were relatively new to this case?
I was, yes.
Have you had a chance to analyze further the data on the defendant's phone regarding that date?
Yes.
I'd asked you at that time about movement on the phone at approximately 3:08 a.m. You recall that?
I do, yes.
Are you able to say at this time whether that was the phone itself moving or a connected device moving?
It appears to be a connected device.
And when you say a connected device, what does that mean?
In this case, I believe it to be a smartwatch. It's a device connected to like, for instance, the defendant's cell phone that is tracking movement data.
When was the defendant's phone first unlocked that morning?
Right before 3:07 a.m.
And this movement activity, when did that take place?
3:08.
Do you recall how far the connected device moved?
I believe it was about 250 feet.
And was there a series of unlocks on that phone in the next 15 minutes?
Yes.
Was there additional movement around 3:21?
Yes.
Do you recall approximately how much?
I believe it was around 140 feet, 143 feet.
Do you see a 911 call on that device?
Yes.
What time did that happen?
Just after 3:21 a.m.
Do you recall if that approximately 140 feet movement was made before or after the 911 call? So in about that 15-minute time frame, the connected device moved about 370 feet.
Correct.
Verify your set one. Thank you, Mr. Quinterdemus. Those are all the questions I have for you this time.
Thanks.
Oh, sure. Thank you. Afternoon.
Afternoon, how are you?
Doing great. How are you?
Good.
Good. All right. Let's talk about, go to State's Exhibit 45, please. Let me know when you're there.
Okay, I'm there.
Mr. Hill had you review Exhibits 44, 45, and 46. You recall that?
I do.
And he asked you whether that indicated there was communication between Ms. Richins as well as Mr. Grossman. Do you remember that?
I do.
Okay, so let's go to 44. And on 44, how is one of the senders or the parties identified as?
On 44,
Yes.
we have Mr. Grossman.
Perfect.
Yes.
And then let's go to 45. And how is one of the parties identified as?
My princess.
And then above that, where it says under party, first number 1, it says from, and then it has owner.
Yes, 9317 is Mr. Richins' number.
So that is not Mr. Grossman?
Correct.
Okay. So just to clarify, going back to Mr. Hill's questions, your testimony that what was included in Exhibit 45 was Mr. Grossman, that was incorrect?
Yes, I was mistaken.
Okay. You indicated that you were asked about the usage on the phone, about whether it was, you indicated it was normal tracking for that device. Do you recall that? And Mr. Richins' phone, just now.
About normal usage. Sorry, yes, I do remember that.
Phone calls?
Yes.
Text messages?
Yes.
Okay. Interestingly, you said normal tracking for that device. I suspect you mean for that person.
They can be one and the same, yes.
The device doesn't do anything by itself.
Right, it has to be manipulated.
Correct.
I repeated yes.
So when you say normal tracking for that device,
Yes.
you mean normal usage by the person who that device belonged to?
Typically, yes.
Okay. You have no way of knowing really what the normal usage is unless you review everything, correct?
To the number, no.
Correct.
Yeah.
Perfect. You indicated that when responding to deletions on Ms. Richins' phone, you indicated that it was from everybody.
Yes.
Okay.
Pretty much, yes.
Was there a time frame for that?
Yes.
And what was that?
January through March. About March 10th or so.
And that was for which phone?
That was for the 1987 number.
Perfect. Testified about attending a Cellbrite certified operator course.
Yes.
When was that?
2017.
Have you been recertified since then?
I have not.
A Cellbrite physical analyzer course as well?
Yes.
And when was that?
The same time, 2017.
Then a 40-hour cell phone analysis and mapping course.
Yes.
That one was not through Cellbrite, that was through Zetex and Trax. Is that what it was?
ZX is the company?
Correct.
Trax is the program, yes.
Thank you. And so separate from Cellbrite, but when was that?
The initial was, I believe, in 2013, and the subject matter expert class was in 2017.
And have you been recertified in that?
No.
The Trax technology gathered from the testimony, that's related to mapping?
Yes.
Okay. And is that what you used here?
Yes.
Now, you were retained by the Summit County Attorney's Office, is that correct?
Correct.
Were you hired by anybody else?
No.
And it was specifically to evaluate the digital evidence in this case?
Yes.
To analyze it?
Yes.
Specifically phone extractions?
Yes.
Of Eric Richins?
Correct.
Of Kouri Richins?
Yes.
Of Carmen Lawler?
Yes.
Others?
Yes.
Now, to be clear, you didn't perform the extractions.
Correct.
Who performed queries on any of her phones?
I believe the RCFL did those.
Who at RCFL?
I don't know that.
Who did the extraction on Eric's phone?
I don't know.
Who did the extraction on Carmen's phone?
I don't know.
What about the other phones?
I don't know. The examiner's name is in each report, but I don't know them offhand.
So you didn't perform the extractions. You weren't present when they were done.
Correct.
In fact, I think, if my timeline's correct, you were hired after the extractions were done.
Yes, for most of them, yeah.
So you don't have the benefit of having observed the extraction examiner do the extraction.
Correct.
Or validate the results of the extraction.
Through the examiner, no.
And you don't have the privilege of observing the extraction examiner perform manual decoding methods.
Correct.
Or manual decoding methods in the hexadecimal code.
Correct.
You didn't confirm whether the extraction examiner validated their extraction tools.
No.
Let's talk about the Cellbrite extraction process.
Okay.
We're going to go from the device to the data.
Okay.
Okay? That, I'd like to be so visual. So, this is a target device.
Correct.
Let's assume this is a target device. Let's hope it's not a target device for my sake. This is a target device. We're going to say that this right here is UFED. Okay? So that is the Universal Forensic Extraction Device, correct?
Yes.
That's what it stands for?
Yes, e-printer, yeah.
Your Honor, I would make an objection at this point as to relevance. I don't know if this is necessary at this point in time to a probable cause standard.
Not sure where we're headed, so I'm going to give Mr. Ramos a little latitude here until I know where we're headed.
Thank you.
This is UFED. Okay? You're going to plug this into this, and then what it's going to do is it's going to spit out something.
Yes.
Correct?
Yes.
I mean, it's not the technical term, but. So once we have that, it's in a raw format.
Correct.
Now, you have been given, when you were brought on, the output, what it spit out.
Correct.
Right?
Yes.
Okay. So your testimony, both at the detention hearing and here, is based on this, on the spit out version.
Correct.
Okay. You have not received the raw data.
There is raw data available, but
Correct.
no.
Correct.
Yes.
There is raw data available. You have not received it.
Correct.
You have not analyzed it.
Correct.
You have not cross-referenced it with what you were given.
Correct.
Now, let me pause. When you state that information was deleted, it doesn't tell you in what you've been given how that happened,
Correct.
why that happened,
Correct.
where it happened.
Also correct.
The raw data could potentially hold that.
Potentially.
Now, you use Celebrite, these extraction tools, you rely on them to provide you this information so that you could then assist, in this case the Summit County Attorney's Office, with their case, correct?
Correct.
With meeting probable cause standards.
Correct.
In terms of location of individuals,
Yes.
such as Ms. Law.
Yes.
Now, to be clear, I only have what you've been given as well. So I'm relying on the information that has been spit out, but not on the raw data, just so we're clear. I want to talk to you about your validation process.
Okay.
Validation of data.
Okay.
As, or having been rather, certified, you know the importance of being able to validate the data that you review.
Yes.
One of those methods is possibly to use it with the, or compared to the raw data. That's one way.
Yes.
Another way is perhaps to use the cell data location from call detail records.
Yes.
In terms of location.
Yes.
Now, when you use the software, that was a form of validating, sorry, I apologize, what did you call it? The TRAX technology, that TRAX software.
Yes.
That's a way of validating whether the information that you received is accurate.
Correct.
You talked about the cell towers.
Yes.
Now this program, we're going back to spitting, does it spit out something for you?
It does.
Okay. Now, have you provided that to the Summit County Attorney's Office?
Yes. You're talking about the mapping?
Mapping?
Yes.
Okay. And are those towers that you referenced earlier, are they sectorized or omnidirectional?
They're sector.
Okay. When you use that program, were you aware at that point that that software had been found to be unreliable in courts?
I'm not aware of that.
You've not been aware of that. But you haven't been certified since 2017.
I've been certified since 2017, but I have not. There was no need for research on that course. It's a learning, and it's a continuing education.
What software version did you use for the tracks software?
Off the top of my head, I don't know.
When you did it, was it the most up to date?
Yes, as far as I know.
Had you updated it since 2017?
Yes, it's web-based, so it's updated constantly. So you can rely on the fact that if you're updating, say today, that it would be the most up-to-date software package.
And what about Celebrite itself, your Celebrite certification process?
Yes.
There are no requirements to recertify.
Correct.
But they do recommend that you recertify.
They do.
Every 2 years.
They do.
But you've not done that.
Correct.
Along those same lines, there is no state of Utah, say, standard for mobile forensic extractions.
Not that I'm aware of.
There's no national one?
No.
There's no international one? It's pretty much whatever Celebrite says.
Well, they're one company.
Correct. So, to my point.
Yeah.
Did you review or were you given, rather, any mobile data sets from the individuals who performed the extractions on all these phones? Like sample data sets, controlled data sets?
No.
Are you familiar with external enrichment?
I'm not.
Or you had indicated, rather, you were asked about the activity sensor of an Apple Watch.
Yes.
How did you determine between the detention hearing and now that it was in fact an Apple Watch?
Review of the download stated Celebrite extracting that it was a connected device.
Now, are you qualified in mobility metrics?
No.
Do you know what mobility metrics are?
No.
You testified about the distance that was covered on the morning of March 4th by a connected device.
Yes.
And you were very specific on the number. Okay?
Yes, more or less.
But you don't know how that number was calculated.
I don't know the internal calculation process of the devices, no.
You just read it.
Yes.
You read what was spit out.
Correct.
You don't have the data, the raw data. Correct?
Correct.
So everything you've testified to is basically because you've read it.
Well, yes, and the extractions from the devices, but yes.
Correct. Just what was given to you.
Yes.
Were there items that were deleted from Mr. Richins' phone? Eric's?
Not that I'm aware of.
But it could be.
Could be.
Have you ever worked with Mr. Todd Gabler?
With? No.
Alongside?
Alongside and, quite frankly, against.
On this case?
No. Well, with, yes, on this case.
With on
yes.
this case. And has he provided information to you?
Yes.
Has any of that information been used in your testimony today?
No.
I believe that's it, Judge. If I may just have a quick second.
Take a moment. Counsel. Ms. Nestor, just push the button.
Thank you. Sorry.
Just a couple more to go on.
Go ahead.
Has the Richins family ever hired you?
No.
Have they ever paid you?
No.
It did sound quieter.
It did sound quiet.
Let us just check for a second, folks.
It sounded like my conscience was speaking.
In fact, my mic. Brittany, you broke it. Yeah, my mic is dead. Why would we need something that's going overhead? I think, well, the things going overhead are muted, so.
A lot of things go over my head.
There we go.
Oh, there we are.
Just saying.
Last question. Did you want me to repeat that?
Have they ever paid you?
Yeah. Perfect. What was provided to you by Todd Gabler?
Off the top of my head, mostly tolls.
Tolls?
Yeah. Yeah. Call tolls, toll records from the Verizon toll records.
No further questions.
Okay.
Thank you.
Mr. Hill, any redirect?
Just pick.
Okay.
Mr. Ramos asked you about any deletions that you observed from Eric Richins' phone, and you had previously testified that a picture that he sent on the 14th was deleted. Oh, yes, that's correct, yeah. How could you tell that that was deleted? Well, it's not present any longer. It shows a file path that it used to exist, but the image itself is not there. And so to follow that, when he asked you if there's anything else that's deleted, did you see anything similar to that picture or any remnants on that phone or relics that showed deletion the same way that photo did? Not that I can recall. Thank you. That's the only question I have.
Mr. Ramos, anything on that?
No, Your Honor. Thank you.
Can we let this gentleman step down? Mr. Gunn? Yes. You can step down, sir. Thank you.
Your Honor, can I suggest, please, a brief recess? Mr. Burmister's going to set up the computer.
Okay.
It's been about an hour.
No problem. Why don't we take a 5-minute recess? who's testifying after the recess?
Your Honor, Ms. Carrington, Brooke Carrington.
Okay, she's present.
She is.
All right, we'll take a 5-minute recess. Thank you. Court's in recess. Thank you.
personal and professional. But was there an exception to that?
Yes, if the husband should die prior to the wife, then his interest would transfer to her.
So what was Kay Richins Realty?
That is Ms. Richins' business, primarily in the real estate business.
Did she have other businesses that you're aware of?
Yes, she did.
Do you know when that business was formed?
Yes. In April of 2019.
I'd like you to take a look at State's Exhibit 19, please. What is that?
This is the Certificate of Organization of Kay Richins Realty, LLC.
Does it indicate when the company was formed?
It does on yes, it does.
What is the date?
April 26, 2019.
And does it also give an address for this business?
Yes, it does.
And what is that address?
282 Willow Court in Camas, Utah.
Okay. Is that in Summit County? Did you visit your home?
It is in Summit County, yes.
Just generally speaking, how does this type of business work that Ms. Richins was?
She appears to me that she was a licensed real estate agent, so she did represent buyers and sellers, but primarily she was involved in fixing and flipping homes.
So she would buy it, fix it, then sell it? Is that what we're getting?
That's correct, yes.
This began then in 2019?
That's right.
Were there other purchases or transactions that predate 2019?
Yes.
And where did those take place?
Those were in South Carolina.
So the market in 2019, do you have any idea of what the market was like, real estate market was like in 2019?
Yes, it was robust.
Meaning properties could come up for sale and be gone within a matter of days?
I think that's a fair statement, yes.
And what were the interest rates like? Conventional loan interest rates then versus say today?
Fairly low. They were still very, very low at that time.
Rough neighborhood average?
Well, depending on your loan, but 2 to 4 or 5%.
Safe to say that's a little different today.
Safe to say, yes.
So in that business, it would seem to me that you would need to be able to act quickly to obtain properties before they're suddenly off the market.
I think that's a fair statement, yes.
So how do the practitioners of this type of business work? It would seem you'd need some capital somehow.
That's correct.
And what are the possible sources for capital?
A business in that field could have its own capital. It could borrow from financial institutions. They could borrow from friends or whatever, hard money lenders, or have investors.
Okay. So what do you mean by hard money lenders?
Hard money lenders are, well, soft money lenders would be like traditional financial institutions where it's a conventional loan, there's a conventional loan application process, due diligence by that financial institution, or and they're typically regulated by state and federal agencies. And then hard money loans are called that colloquially because they have more strict terms, the harder terms, usually a higher interest rate, very definite zero tolerance default clause usually.
Okay, so I guess the advantage of a conventional loan would be lower interest rate. The disadvantage would be response time because of the due diligence required.
That would be, yes.
The others are more responsive in time, but have these more draconian clauses.
Yes.
Prior to the April 26, 2019 date, was there something else that you found that was important for our inquiry today?
Yes.
What was that?
The home equity line of credit that was taken out on the home.
On the family home, the marital home.
The home on Willow Court, where the family lived, yes.
Do you know whose name that, well, first of all, was there a mortgage on that home?
Yes.
Do you know whose name was on that mortgage?
The home was owned by Eric Richins, and the home equity loan that was taken out was also in the name of Eric Richins.
Could you give us a very brief description of what a home equity loan is?
It's a line of credit typically that is established. There's a loan application process. There's a line of credit that's established that someone could tap into their equity that they already own in the home.
So you could make home improvements or whatever you wanted to do with it, I suppose.
A person could tap into it for any number of reasons.
In this case, there was home equity line of credit for how much?
$250,000.
And when was that?
That was in March 2019.
And so does this in effect, is it secured by the home itself?
It is, yes.
So this is essentially a second mortgage.
Your Honor, I know this isn't expert, but we're doing a lot of meetings, so I would just object and ask if we could maybe let the expert be the expert here and object.
I think it's just laying foundation and some overrules, but if we can keep it moving, Mr. Burns.
Do you know if this was, there was any in order to obtain this, I guess is where we need to look this. In order to obtain this loan, home equity line of credit, on a home owned by Eric Richins, how does that happen?
There's a loan application process, and in this instance, it was signed by Ms. Richins, referencing a power of attorney.
I'd like to direct your attention to States Exhibit 123, States Exhibit 124. Take 123 first.
Are you talking about the dockets?
Yes, I'm sorry. Docket number 123 and 220.
Okay, yes, I got those.
Do you recognize those two documents?
Yes.
Is there a difference on the date it's signed by the reported author of it, I guess?
Yes.
What's the difference in the date?
Docket 123 is signed and dated 5/8/13, and docket 124 is signed, dated 5/8/18.
During your investigation and examination, are you aware of whether those docket number 123 and 124 came under suspicion?
They were.
I'd like to direct your attention to States Exhibit, or docket number 127.
I don't have a 127. I do not have a 127. Wait, never mind. It's just in different order.
Yes,
Sorry.
it's out of order. That is
That's okay.
totally my fault.
Okay,
Do you know what that is?
I do.
What is it?
This is the expert report by Matt Throckmorton.
And those he examined 3 question documents, is that right?
That's right.
And 123 and 124, are they any of those
Yes.
question documents?
Those are 2 of the 3.
I'd like you to take a look at now. Lost control. I think we have marked them as State's Exhibit 70 for the court. I'm going to approach the witness.
Of course.
I'm not sure she has State's Exhibit 70.
Go ahead.
Can you please just describe or the title of that document for the record, number 70?
This is the Willow Court Loan Advances and Payments.
When is the first withdrawal on that home equity line of credit?
It's March 26, 2019 for $60,000.
When is the next withdrawal?
August 5th, 2019.
Could you describe the next couple of withdrawals on that?
Following that $2,100 in August, there are a series of withdrawals for the next few months.
In August, is there more than one or just the one?
There are several.
Does that strike you as important for today's
Yes.
purposes? Would you explain to the board what you draw from that?
Beginning in August of 2019, this is around this time is the first property that Ms. Richins purchased after obtaining her business license. It's a home in Heber City. As far as I know, that was her first home in Utah that she flipped.
We have State's Exhibit 71.
Mr. Brewster, are you offering State 70?
Yes, yes, I will be offering State 70 and 71 as summary charts.
Okay. Ms. Nestor, any objection?
No, sir.
Okay. 70 and 71 are admitted.
Could you read for the record the title of 71?
Encumbrance and Real Property Chronology Trust Deed Summary.
So what, does that help you state for the record what that first transaction was, and where?
Yes. It's the 550 house. The first warranty deed involving K. Richins Realty was August 1st of 2019.
Now, I'd like to portray that in another way. Did you prepare a timeline bar chart?
Yes.
Does it depict much the same information, just in a different way?
Different format, yes.
Would that be helpful in conveying your testimony?
Yes.
State would offer State's Exhibit 69, and we're just going to go for the first chart, which is the timeline.
Ms. Nestor, any objection?
No, sir.
States Exhibit 69 is admitted.
That's the whole PowerPoint, I'm sorry.
It is, but I've only laid foundation for the very first
Got it.
time. Is that the bar chart you were just referring to?
Yes.
And so, can you just explain to the judge how this chart works?
Sure. I think you've seen this before. And the colors don't mean anything. They're just to distinguish one line from another. I've just got the years along the top and the months, and then going down the different properties just as some sort of an illustration to depict when properties were held at any particular time.
And then within each bar is the address of the property purchase?
Right, and so if you wanted to know what was held in June of 2021, you could draw a vertical line to see which properties were owned at that time.
Okay, so any more purchases in 2019 by K. Richins Realty?
Not that I know of. There could be others, but this is what I have been able to compile.
How about in 2020?
2020, yes, there were others.
Okay, how many purchases by K. Richins Realty of property in 2020?
I think there were just the 5.
Is there one that stands out to you?
In 2020?
Yes.
Not particular. Well, the Franson Lane one toward the end of 2020, in October of 2020. The Franson Lane property in Oakland.
I see. Let's drill down into the Franson Lane. You said, when was that?
It was acquired in October of 2020.
Is it different from the previous 5, I guess, counting 2019?
Yes.
In what ways was it different?
It was a more robust project, more ambitious project in amount. You know, it was. I think she acquired it for $1.3 million, and the others had been somewhere in the neighborhood of like $300,000 or $400,000 or $500,000.
Did she require money, outside money?
Yes.
To make this investment?
Yes.
What sort of investors?
They were hard money lenders.
Do you know who they were?
Yes.
Who are they?
Sierra West Capital was the primary lender, which is this, as is the case on several of her properties. And then there were other investors who contributed the funds basically for the rehab.
Was there something else different in this application that you garnered from all the financial records?
I'm sorry, I didn't understand your question.
That's the way I roll. Okay. Was there something else that you found in reviewing all of the documents, not just the below documents, that distinguished this purchase as opposed to the ones that have gone before? Involving, all right, how about this? Do you know if C&E was involved in this project?
C&E was involved in this project.
Okay. And what did you discover about C&E's involvement?
After the acquisition of the Oakley property, the Franson Lane property, C&E, there were several checks from C&E that were deposited to the K. Richins Realty account, and they specifically have a memo on them that tie them to this property. And so over the next, between October and when this property was sold in March of 21, there are a series of checks. I think there are 6 or 8 checks that are about $133,000, I think.
Was this property ever sold?
Yes, it was.
When?
In March of 2021.
What happened to the proceeds from that sale?
This was This was a property where the net proceeds were about $466,000, which came into the K. Richins Realty account, that 6577 account. And then from that, $217,000 was paid directly to C&E. And then there were some other payments, transfers out from the account that were associated with this property as well, and left her with about, around $200,000 in net proceeds.
In your examining of all the evidence in this case, were there other things that you looked at to inform your examination that took place in October of 2020?
There were other things in October of 2020, yes.
Did you take a look at State's Exhibit 22? Are you familiar with that document?
Yes.
Could you explain what it is?
This is an intake form from a divorce attorney describing that Eric Richins was wanting to consult with his attorney on a potential divorce, and it's dated October 8th of 2020.
In the wake of that, are you aware of any other instruments that were created out of that?
Yes, there are the notes that the attorney appeared to have handwritten during the course of that first meeting.
Were there financial arrangements made after that meeting that you're aware of?
Yes, the notes indicate that there was some new information by Mr. Richins that there was the HELOC had been taken out on the home, that as if this was new, and then from this he set up the Eric Richins Living Trust and also a will.
Was there something dramatically different about the trust situation as before?
Ms. Richins was not the beneficiary of his estate. It was to be for his children, and the trustee was going to be his sister, Katie.
So I'd like to go back to 7. This should be the HELOC loan balance for Will. By August of 2020, what was the balance?
August of 2020, $246,931.
Is there a significant, well, up until that point, how was there money being paid on that debt?
Yes, they were the interest-only payments. The minimum payments were about $900, $1,000, something like that, that were made every month.
Did something different happen in October of 2020?
Yes.
What happened?
There's really the first significant payment, and it's $50,000 on October 12th.
Do you know what the source of that fund was?
Yes, Ms. Richins had sold the Cleveland Avenue house in Salt Lake, and from that she received net proceeds of about $63,000. There was a transfer, and then this $50,000 was sourced from that.
On October 12th?
Yes.
Bringing the balance to approximately what?
196,000.
Do you know whether in October she was in a financial position to just pay that $196,000 off?
She was not.
Let's go into 2021. I guess we've still got the timeline up. Direct your attention to timeline. Could you describe for the record a summary of what purchases, et cetera, took place in 2021?
Yes. So she acquired a property in Heber City before she got the proceeds from Branson Lane. And then after that, she acquired a number of properties throughout the summer especially, and then ending the year acquiring 3 on the same day in November. And I think there may be another property that she was working on that I don't have on here, but all in all, she had about 15 properties in 2021.
So, did she go to the same lenders for all of these 15 properties?
No, there is some consistency in the lenders, but she did diversify a little bit.
Can you tell the court some of the lenders that you found she used?
So she primarily used the Sierra West, and that's pretty consistent through here. And the those investors who would have been taking second, third, or fourth position were pretty consistent as well.
Those are like Cockerhands?
Cockerhands, Ellis, Soto, Lieb. There's a number of them. And then she also went to a company called Iron Bridge, a company called Boomerang. She did 4 projects with Boomerang.
So let's take, first of all, when did she go to Iron Bridge and when to Boomerang?
Those were in the summer of 2021.
And Iron Bridge, how would you describe what Iron Bridge is or does?
They appear to be a hard money lender. The terms are somewhat more flexible than typical hard money lenders, but the interest rates on that loan, I believe, is 13%. Was 13%.
And in 2021, is that high?
That would be high, yeah.
So, how did the application process go between the defendant and Iron Bridge?
There is an original application that is submitted. It appears to be online. I don't know that for sure, but it appears to be online. And then there was a series of emails back and forth where the person analyzing the loan or underwriting the loan is asking her to submit some additional documentation.
Okay. Can you take a look at State's Exhibit 58, please?
5-8.
Yes, 5-8, State's Exhibit. Is that what you were talking about? Some email going back and forth between Iron Bridge and the defendant?
Yes.
Okay. Is there something about a bank statement in there?
Yes. It asks for personal bank statements, the most recent.
Okay. Based on your experience in the training, why would they want to know that stuff?
Typically, they'd call that proof of funds. They want to, they need to verify. In banking terms, it's KYC, know your customer. Every financial institution needs to know and verify the individual and entities that they're dealing with.
I'd like you to take a look at State's Exhibit 59, if you would. What is State's Exhibit 59?
This is a secured promissory note for what I call the 299 house in Heber with Iron Bridge.
And first of all, This is K. Richins Realty purchasing this, is that what it is?
That's right, and I misspoke, this is 10%. I had misstated the interest rate earlier.
And what is the amount that they're loaning?
$346,500.
When?
This is in July of 22. I'm sorry, July of 21, sorry. It's signed July 7th, 2021.
Now, did you examine a bank statement from Iron Bridge purportedly given to them by the defendant?
You mean from Iron Bridge, meaning?
It was obtained from Iron Bridge, so but submitted to it that it used to.
It was part of the Iron Bridge loan information that we received, yes.
Okay. Would you take a look at State's Exhibit 11, please? What is State's Exhibit 11?
This is America First Credit Union bank account statement for May 31st, 2021 for K. Richins Realty, account number 6577.
And do you know where this was sourced from?
This was sourced from Iron Bridge as indicated by the number on the top.
Okay. And how do you know it's K. Richins Realty?
The header on the bank account statement purports to be K. Richins Realty.
And then in the body of that statement, does it give the amount in the bank account?
Yes.
What is that?
The summary of the accounts for the 3 accounts that are included in this bank account statement is $210,898.61. That's the ending balance.
So I'd like to direct your attention now to State's Exhibit 12. What is State's Exhibit 12?
This is the America First bank account statement for K. Richins Realty for that same month, May of 2021, for account 6577. This is the actual statement that we received from America First Credit Union.
In what way is it the same and in what way is it different from the State's Exhibit 11?
The header is the same, but the body, the transactions that are contained are different.
What is the total balance?
The total balance is $15,609.
All right, let's take a look at State's Exhibit 13. What is that?
This is the actual bank account statement for C&E Stone Masonry, ending in 7664. This was the document that was received directly from America First Credit Union.
And how do you know it's C&E's?
The header indicates that it's C&E's, and the transactions appear to be consistent with what C&E would be doing, and it matches the bank account statement that Iron Bridge produced, but it has the different header on it.
So let me make sure I understand this. 11 has a header from her account, K. Richins Realty, but yet the body of C&E's May 31st bank statement.
That's correct.
I'd like you to take a look at State's Exhibit 60. That's 60. I believe that's an email exchange, is that right?
That's right.
What's the subject?
Quick question.
Okay, and is the quick question below, physically below the response? Is that,
Yes.
so what is the quick question?
This is from Mr. Kaney, I don't know how to say that, from Iron Bridge, emailing Ms. Richins asking for an explanation about her credit score, the credit cards, and referencing that bank account statement.
Okay. Is he perplexed? I mean, what
Just
is-
speculation.
Sustained.
Specifically, what does he say to her?
He says when he first ran her credit, it was lower than expected. There were some delinquencies on the credit cards, but he can see from the bank account statement that she provided that she's got plenty of money in the bank to cover expenses.
How does she respond to that?
Do you like me to read it?
Yes, please. Can you just read what she says to that question?
She says, "Hi Richard, hope you had a great 4th of July weekend. Yes, sure. Everything is paid off now. It just probably hasn't updated. I recently learned about all of this as well, LOL, and then my husband decided to explain to me that this was his doing a while ago. We are in the process of separation for one of many reasons, but this is one of them. To keep it short and sweet, LOL. It's been crazy to say the least. I look forward to working with you guys on our first and hopefully many projects."
Okay, you said she obtained some loans from Boomerang 4, I believe you said.
Yes.
I'd like you to take a look at State's Exhibit 14, if you would. What is State's Exhibit 14?
This is from Boomerang, but it's an America First Credit Union bank account statement for Kate Richins Realty, account 6577 for June of 2021.
And how do you know it's Kate Richins Realty?
Just the header.
And what is the balance on that?
The ending balance is $702,831.
Let's take a look at State's Exhibit 15 then. Now, what is that?
This is the actual statement that was obtained directly from America First Credit Union for K. Richins Realty, account 6577 in June of 2021.
The header says K. Richins and Realty and 6577?
That's right.
What is the ending balance?
Ending balance is $15,339.
Okay, let's take a look at State's Exhibit 16. And what is that?
This is the actual bank account statement that was obtained directly from America First Credit Union for C&D Stone Masonry LLC, account 7664 for June of 2021.
And it presumably says C&E 7664
Yes.
in the header?
In the header, yes.
What's the ending balance?
The ending balance is $702,831.
That's the same as State's Exhibit 14?
The one that was issued to Boomerang, or submitted to Boomerang, yes.
So, once again, cut and paste a header for K. Richins Realty and the data, the amount of money on hand from C&E.
That's correct.
Direct your attention to State's Exhibit 61, if you would. Could you describe for the record what this is?
Yes, this is from Boomerang. This is a document that came directly from Boomerang. It's a kind of an internal review, summary of a potential loan, kind of ahead of, that would be prepared in the midst of the approval process.
And what was the property?
This is for the 75 East Midway House, I think. Yes. The smaller Midway House.
And in there, does it reference, well, first of all, how much is the loan amount?
The loan amount on this is $454,750.
And does it talk about the defendant's liquidity?
It does on the second page.
And what does it say about it?
Let's see. It says under liquidity and net worth, Kouri has liquidity in the amount of $702,000. She has a net worth of $2,719,000 made up of cash, securities, life insurance, retirement funds, and real estate investments.
And so that number 702,000 is that same figure from CME that she's submitted in State's Exhibit 14?
Don't remember the exact exhibit number, but yes, that number's drawn from that bank account statement that was actually CME, not Cape Richins Realty.
Did you find any other instances where this similar type of cut and paste header with some other account was submitted to lenders?
Yes.
How many times did you find that?
I found 6 so far.
Including these two?
Yes.
Now, I'd like you to take a look again at the timeline.
Yes.
Okay, so these purchases in 2021, you already mentioned 15, more and more. Did any of them sell?
Yes. Great number of them did, yeah.
Okay, tell us about that.
Like the Mill Creek house, for example, that was acquired in the spring. That's a home in Salt Lake County. And so there was a primary lender on that and multiple investors who gave K. Richins Realty money for the rehab costs. And then when it was sold, most of those were paid from closing, like at the title company. Some were not. Some came out of K. Richins Realty's net proceeds.
So she's turning over property, isn't she gaining money by doing it?
Yes.
Okay, what's happening to her debt load?
That was increasing, especially she started in the middle of summer of 2021. She started acquiring personal property loans that they're not secured by real property and were secured by advanced, her future receivables.
Is Greengrass holding one of those?
Yes.
Okay, turn your attention to State's Exhibit 20. So could you, first of all, tell us what State's Exhibit 20 is?
This is a revenue purchase agreement dated, it's in September of 2021.
And could you explain the basic terms of this?
This is an agreement with K. Richins Realty and then some other companies pledging $87,000 of advance receivables for $60,000 upon execution of the agreement, and e-signed by Kouri and Doreen Kouri.
So let me make sure I understand this. So she's saying, I will give you $87,000 of money I haven't earned yet in but I'll pay it to you in the future if you give me 60,000 now.
Yeah, and what's represented here that it's been earned and it's going to be coming in, but it's not in yet. And so she's saying, I'll pay you back $87,000 for $60,000 now.
Okay. And what did it obligate her to pay?
$5,438 every week.
Did she pay that?
For a series of payments, yes.
How much did she pay that you're aware of?
I think she paid about $20,000. I'm not exactly sure of the amount on there, but she paid about $20,000 and then defaulted in December.
Did something happen as a result of that default?
Yes, they filed suit in New York.
Okay, the state would direct your attention to State's Exhibit 21. Could you describe for the record what State's Exhibit 21 is?
This is the summons and the verified complaint associated with that lawsuit.
And so in a lawsuit like that, there's some alleged facts?
Yes.
Okay, so I'll direct your attention to page 5, fact number 11.
Yes.
And what is the allegation there?
That she did pay $21,752, leaving the balance of unremitted receivables of $65,248. And then there's default fees of $2,500 and attorney's fees of $19,574.
Did you find any other agreements or attempted agreements between the defendant and these type of lenders?
Yes, I found several.
Okay, what are they?
QFS Financial is one she entered into where she pledged $167,000 for future receivables for $105,000. That was the largest one by far. Most of them are in the $20,000 to $30,000 range.
Is Blue Bridge something like that?
Blue Bridge is one, Delta Bridge Funding, Zahav, Asset Management, Crown Funding. There are over a couple of dozen, or I'm sorry, over a dozen, yeah, about 20 or 25.
You mentioned early on that the defendant had an account with Navy Federal.
Yes.
Navy Federal, do you know what kind of account she had there?
At Navy Federal, she had a checking, a savings, and a credit line.
Okay. During the period of August to December of 2021, do you have any idea? Well, first of all, what was the maximum amount for that, the credit limit for that revolving line of credit?
That was $15,000.
For that period, August 2021 to December 2021, do you know what her balance was, relatively speaking?
Well, it was almost maxed out most of the time. During that specific review period, I would say, I think that's about $13,000.
Okay. Can you take a look at State's Exhibit 26, please? Is that a multi-page document?
It is.
And what are they?
These are the bank account statements for the account ending in 0060, starting in July of 21. Ending in March of 22, and for Kouri Richins.
And does the statement include the balance on revolving credit?
Yes.
And throughout that time period I just mentioned, it's more or less maxed out?
Yes.
I'd like you to take a look at State's Exhibit 27. you know what those are?
Yes.
What are these?
These are checks from the account of Kouri Richins at Navy Federal, and these checks were deposited into the account of K. Richins Realty. I believe all of these were deposited into that account, and none of them cleared.
Let's just do an exercise on one of these. Let's take a look. What's the check number on the very first one of State's Exhibit 27?
Check 271.
And when is that?
The date on the check is 8/28/2021.
Can you find that transaction in State's Exhibit 26, which is those statements for that appropriate time period?
Yes. Yes. It's on, the Bates number ends in 99 at the top, and it was returned on 8/31/21.
So that check, and how much was that check for, that particular one?
$2,100.
And all of the checks then in State's Exhibit 27 are similar in that way?
That's right.
So now we're at December of 2021, the end of the year there. What is her financial status?
All in all, with all of the property, she had acquired and sold a number of properties. She retained several as rentals. She still had loans on those properties. So at that time, it was about $4 or $4.5 million that she still owed on those. Well, the trust deeds, she had paid some on them, but there's that. And then with all of the personal property loans, it's hard to tell for sure, but I think somewhere around $500,000 or $600,000 she owed on those personal property loans as well.
Now you mentioned that one, for example, was green grass.
That's right.
Required her to pay.
Reflect that the hearing is taking place outside the presence of the jury panel. I received a note from the jury foreperson. It's been marked as court's exhibit number 24. First question is, can we have more paper? We have taken more paper back to him. And the next question is, how do we zoom in on the videos? I don't know how to do that. We don't. That's why we asked you to bring your IT person. And so,
What do we have?
sure. I mean, I don't know if we can show them, if we can show the foreperson how to do it, or we'll have to bring them back in the courtroom.
Do you know, is there a way to zoom in on certain videos?
Well, Mr. Draskovich did it.
I know how to do
Yes.
You did it.
Mike knows how to do it.
I do. I just tried
Okay,
it.
but they have a laptop back there.
And I was told it did have a Zoom capability, so that was.
Okay, will you just come up and state your name for the record?
Sure. My name is Jetta Baldami.
Okay, if we brought the laptop out, would you be able to determine?
Sure, I can take a look at it. Depending on what the player is, it should have that capability.
Do you know what the player is on the?
I've never seen the player before, so I would have to inspect it.
Oh, you mean the laptop, whatever's on the laptop?
Yeah, yes.
Okay, so I'll go out and I'll ask the officer of the court to ask the foreperson to bring the laptop out. You want to come in the hallway?
Sure.
The attorneys can come back here.
All right, thank you.
Oh, sorry.
May the record reflect that the hearing is continuing to take place outside the presence of the jury panel. The state, and that's an employee from your office, correct?
That's correct.
Jetta Balgami. She went with the court officer back into the jury deliberation room, showed the jurors how to do it, and they did that without objection. Is that correct?
That's correct.
Mr. Jaskovich?
Yes, Your Honor.
Okay, and so they're continuing to deliberate.
Thank you.
Thank you.
Your Honor.
$5,000 weekly?
5,438 weekly, yes.
Were there some that were daily?
Yes.
And how many payments did she have to make for the month of December, for example?
She made about over 90 payments on debt. You know, toward the, there's a difference. There's the debt load and there's the debt service. So she owed the amounts that I stated, and the debt service are the payments that she paid on that debt. And they're a little, well, there's over 100 that she paid payments.
So for the month of December, how much debt service is just what she paid? Not necessarily, it could be the same as debt load, but...
In this instance, no, it's different.
Okay.
Yeah.
What was the debt service for the month of December, do you know?
It was over $300,000.
I'd like to take a look at, this is back to States Exhibit 69. I'm going to move on to the next chart. Can you describe for the record what this next summary chart is?
This is the debt payments that she made during these months.
Once again, this is debt service, not debt load.
That's right.
Okay.
This is not the amount of debt she possessed. This is the amount of payments that she made on that debt.
Okay, and for the months of
June of 2021 through February of 2022. And I do need to make a note that in preparing for this hearing, I've noticed that in December of 2021, I made a duplication. So we need to reduce that number by about $44,000 in December. It's still about $320,000.
Now, in January and February, it appears to go down, is that right?
That's right.
Let's once again look at the same information expressed differently. Can you describe this for the record? This is the third chart on the PowerPoint.
So this is drawn from that previous data. And so it's just showing it in a pictorial format.
It seems after December, it seems to be going through the floor.
That's right. These are the payments that she made on the debt. She did pay off one of her lenders, one of the personal property loans. She did pay that off in January, and that was about $19,000. But mostly because of what had happened in November and December, so many transactions had been returned and not cleared by the bank. They did not. Some of them continued to try to draw in January and February, but they were unsuccessful. And so those payments were not made.
So this doesn't depict her debt load, the amount of debt she has, but rather she's just not paying.
That's correct. At least from the accounts I have. At least from the accounts that I have reviewed.
Sometime around this time period, did she take on another project?
Yes, she did.
Is it different than previous projects?
Are you talking about the Legacy Way project, the large house?
Oh, okay, yes. Tell me
Yes.
about that.
She, the first REPC, which stands for Real Estate Purchase Contract, was in December of 2021, and it's a very large property on Legacy Way in Midway, and that's the property that she did end up closing in March 22.
Okay. It begins though in December and concludes when in March?
Well, the settlement statement I've seen is dated March 4th. Some documents were signed March 4th, some were signed on the 7th and recorded on the 8th of March.
How is this different from any of the other previous projects?
It was an unfinished house and just quite large, a very, very ambitious project. The purchase price, I believe, was $2.9 million.
What was its state of repair?
It was under construction, so it didn't have much inside, down to the studs, exposed wiring, things like that.
Did she ever, that you're aware of, give an estimate to lenders about what she anticipated those costs would be to rehab it?
Yes.
What was that?
Her estimate was between $3 and $4 million to rehab that property once it was acquired.
And how did she obtain this property?
Through hard money lenders.
All borrowed then?
Pardon me?
All borrowed?
Yes, all borrowed.
Okay, I want to talk about life insurance. Have you had the opportunity to look at life insurance policies that were owned by the Richins family?
Yes.
Do you know about how many there were?
I think there were 6.
This is the fourth chart from State's Exhibit 69 PowerPoint. Can you describe what that is?
Yes, these are the life insurance policies on Eric Richins' life, and I've taken the effective date. Some of them were in 2015, 17, 18, and there's the one in 2022.
And those dates, those years are the date of purchase?
That's right.
Are they different for, I guess, different purposes?
It appears to be, yes.
In what ways?
Oh, the first one on the top is a mortgage insurance policy. So basically, it would pay off the pay down the mortgage. I think it's some odd amount, like 72.05% or something. But
okay, was there one for business?
I believe so, and I am unclear as I sit here if that's that $1 million one or not. So I'm sorry. There is one on the business where Eric and his business partner, if one passed away, then it would benefit the other and allow the other one to buy out the business from the estate of the other.
Okay, so it doesn't go to the spouse, but rather to the other business partner.
The business partner.
To buy out the spouse.
Yeah.
Are you familiar with a company, life insurance company called True Stage?
Yes.
Is it some sort of business association with PenFed?
Yes.
To your knowledge, what is that relationship?
Well, True Stage is an insurance company, And they typically market their product to credit union members, all sorts of credit union members, different credit unions.
Do you know whether the defendant was a member of PenFed?
She was, yes.
How about, do you know whether Eric Richins was?
I know that he was not.
Direct your attention to State's Exhibit 62. And what is that? Just for the record.
These are the bank account statements for Kouri Richins at PenFed Credit Union, the account 9118, for the period starting in October of 2021. It's just through April of 2022.
And State's Exhibit 63. What is that?
This is a declaration of custodian of records, no records, and this is from PenFed Credit Union, stating that Eric Richins did not have any accounts at their institution.
Are you aware of an application from the defendant to True Stage for life insurance in January of 2022?
Yes.
Direct your attention to State's Exhibit 17. What is State's Exhibit 17?
This is the application for True Stage individual term life insurance, 218. And this is dated the end of January 28th or 29th of 2022.
And who's applying for what in this application?
This is for life insurance for Kouri Darden Richins and for Eric Richins.
Now, is there something unusual about the information provided, contact information for each of those two applicants?
Yes.
Tell us about that.
The contact information is the P.O. box that Ms. Richins used for her business. Her email address is on there. There's no email address for Mr. Richins, and the phone number that's listed for Mr. Richins is not correct.
How is it different? Do you know off the top of your head?
Yes. It says 892. His number starts 792.
And then ends with the 9317?
That's correct.
To be clear, the mailing address is the business address for K. Richins Realty for both of them?
Yes, this was pre-populated. It appears to be pre-populated this way with Kouri Darden Richins and her P.O. box in Camas.
And when is it effective?
This policy was effective February 2nd, 2022.
Okay, direct your attention to State's Exhibit 65. Now, before I go there, I'm sorry, I skipped over something. Early on, we talked about docket 127.
Yes,
That was, if I remember correctly, that was Throckmorton's report.
that's right.
And in there, he has how many question samples?
3 questioned samples, yes.
So 1 and 2 are the power of attorney we've already addressed.
That's right.
So question number 3 is?
It's the signature on this life insurance policy.
And so is your understanding what?
He calls them simulated forgeries, and that they're probably not Mr. Richins' signatures.
Okay, so now let's go to State's Exhibit 65, if you would. What is State's Exhibit 65?
This is a letter from True Stage Insurance to Eric Richins at that P.O. Box 759, dated February 4th, 2022.
And what is it informing Eric Richins of?
This is a welcome letter. Thank you for choosing True Stage Life Insurance, and talking about the premium. The premium would be deducted from the checking account 6577, which is the K. Richins Realty account, on February 14th for $46.50.
And that's an automatic withdrawal?
That is.
Have you examined AFCU account for K. Richins Realty at 6577 for December, January, February of December of 21, January, February, March even of 2022?
Yes.
So in 6577, is there that automatic withdrawal that you were talking about?
There is, in February, yes.
Is there any other insurance premiums that are paid from 6577?
No.
Now, let's take a look at State's Exhibit 64, and I'll let you just take a look at what 64 is and 37.
What was the second number, Mr.
37, 37. Could you describe for the record, what is 64?
64 is part of December. So this is an America First Credit Union bank account statement from America First Credit Union.
Which account?
Eric Richins account 2204. So this is the joint account where the typical household expenses were paid. And it is for December 2021, pages, and it goes through, March 1st of 2022.
So, looking at those, are there any of the insurance premiums that you've mentioned before paid out of 220?
The payments that had previously been made, historically been made, I should say, are paid here, but not that one.
But not the new one, just
Not the new
all the
one.
previous ones?
That's correct.
So, just a second. Have to steal my courage? Oh, okay. So, I'm looking at, in your chart there, I guess that you find evidence of payment of those top four in your chart?
I'm not sure
From the
what you mean.
2204?
The payment of the premium?
Yes,
Yes,
but not the bottom one.
that's correct.
Do you know if the defendant made any claims on those insurance policies?
Yes, she did.
Particularly the true state?
Yes, she did.
Okay. How does the claim process work?
Mr. Burris, you're getting back in front of that mic. Please.
How does the claim process work?
A claim is made, the insurance company would initiate a claim, given a number, and then proceed to do their due diligence.
Okay. A couple of things. Based on your experience and training with working with insurance companies, is there a convention for naming these claims?
Yes, everyone's got a little bit different process, but in this situation, there are two different claims, and we can see from the information contained in the diary that the insurance company kept, and also the name, the number of the claim. We can see what date it was opened.
I see. Okay, so in addition, is there any, are insurance policies treated differently if they're made, a claim is made on them near in time to when they're opened versus if you've had a policy intact for 10 years or something?
Yes, I worked on, I don't know, a few dozen death investigations, and what happens, every insurance company will have a different policy, but typically if a life insurance policy is taken out and there's a death of the insured within a certain period of time, usually it's a year or two, there's a standard death investigation that takes place. And I worked on many of those throughout my career.
Okay. I'd like you to take a look at what has been marked as States Exhibit 18. What is States Exhibit 18?
This is notes for claim 2204-28003. So this would be the claim opened on opened on April 28th. It's probably the third one that they assigned that day or something.
Okay. And so that, do you know which policy this is referring to?
This one is the larger of the two. This is the $250,000 policy that from 2017.
And is this what you referred to earlier as a diary?
Yes.
Okay. I think we have an States Exhibit 67. We just, at the beginning of the day, I think, offered States Exhibit 67.
Yes.
And I don't know.
Yes, it's right here.
I have it.
And can you identify for the record what States Exhibit 67?
Yes. This is a similar document. This is for the other claim, number 2204-22032. So this is the claim that was open on April 22nd, 2022, and this is for, so this is the first one, and this is for the $100,000 policy.
And it was opened on April 22nd, 2022.
That's right.
Let's look a little closer then. First of all, with States Exhibit 18. Can you describe what this is recording and how it works with business?
This is a chronological diary, just note-taking about the date and time of a call or a contact, and just some notes. So over time they can go back and refer to what happened and when.
Now this is States Exhibit 18 is referring to the 2017 policy.
That's right.
And it was made then by April 28th, so a week after the other one.
Yes.
Okay. In there, does the defendant ask some questions, or I guess is the insurance company asking the defendant some questions about the case?
Yes.
Do they want to know about fentanyl?
Yes. They needed the final death certificate showing the cause of death, and then they need to know if the fentanyl was prescribed.
And does the defendant respond to that?
She does. Toward the bottom, she said the fentanyl was not prescribed, so she can't give any information about it. She also added that she don't have any idea how did her husband got that. Just for the record, that's what it says. That's not my grammar.
Let's turn to State's Exhibit 67. Now, to be clear, this is first in time request.
Yes, it is.
And the policy that she opened, that I believe was effective, you said?
February 2nd. Yes.
At some point, I think in July of 2022, is there a conversation between the defendant and the insurance company about what's taking so long?
Yes. This would be, well, there were several conversations in July. They're talking about needing the medical records from the medical facility. And then finally in August, that they say, she called to know the status of the claim, and then they said that they had received the medical records from the clinic.
Okay, I wanted to. All right, so they finally get them when? The medical records?
That's, according to this, is 8/15/22.
In the, you see the entry 822, at the bottom of page 2?
Yes.
Are they talking about the medical records there, that last?
It looks like yes.
And did they receive them on what day?
Well, this is when they received the invoice.
It's the invoice, so. All right, so do they describe what is important to them as far as this investigation in at least one of those 822 entries?
Yes. Yes. It looks like they received the records on 8/2 and 8/11. I don't know if that matters. Okay, yes, they received the 36 pages of records on 8/11. And then there's substance use other than prescribed. It's marijuana once or twice a year, and no concerns about substance abuse in the household.
Have a moment,
Yes.
That's all the questions I have.
Who's doing the question? Ms. Nestor, level with me. How much time do you think you have with Ms. Arrington?
30 minutes.
Okay. Do you have about some words?
I'm not law enforcement at this time.
I don't think he's ever been law enforcement, but that's true.
And how did you know Mr. Gabler?
We've been colleagues for 30 years or so.
And by colleagues, do you share office space? Do you work together on cases just randomly, or what do you mean by colleagues?
No, I have worked on the same cases that he has worked on. I would not say we've ever worked on cases together.
Okay. And he approached you and asked if you would be interested in working for Eric Richins' family, who was dealing with trust issues, right?
With the trust, the Eric Richins Living Trust, yes.
Who's the trustee of the Eric Richins Living Trust?
Katie Richins Benson, his sister.
And so would she have been the individual basically responsible for paying you as the trustee?
Yes.
And did you meet with her?
I don't know that I ever met with her. We had phone conversations.
Okay. And did you have a contract of employment with her or with the trust?
An engagement letter, yes.
And what did they agree to pay you to help them?
My hourly rate and, yeah.
How much was that?
$325 an hour.
And I believe you said you worked for them up until the county attorney approached you, is that right?
That's right.
So how long a period of time did you work solely for the trust?
I don't remember when I first started working for them. In the summer. It was in the summer, I believe, of 22.
So a few months after Mr. Richins had passed.
Something like that. I can get that exact date for you. Something like that. And then toward the fall of that year, they engaged in some litigation, and I was pretty much out of the picture at that point.
So maybe 5 or 6 months, do you think you worked for them?
Probably 4 or 5, yeah.
And do you remember a total how much they paid you during the time you were employed by them?
I think it was about $9,000.
And during that time, did they provide you with records to analyze?
I did have some records, yes.
Right. And so these are being produced to you by Eric Richins' family?
That's right.
And that would include these life insurance documents?
I did have some. Whether or not they're this, I honestly don't remember if it includes this one. I don't think it did. There were several New York life insurance policies that I reviewed.
Do you know how they obtained those records before they gave them to you? Are you aware? You may or may not be.
I don't know.
What other records did the Richins family give you to analyze?
I had some of the C&E Masonry bank account records. I had some tax returns. I know I had some other things. I had some odds and ends. So nothing, and I do not know how they obtained them.
And then how did it come about that you switched from working from Eric's family to the prosecution team in this case?
Well, in my view, they are separate entities, separate cases, separate engagements, and I did not feel like I could work on both. And at that time, when I was engaged by Summit County, I had not had any contact, well, I shouldn't say any. I had really not had much, if any, contact since like the fall. I did have a Zoom call with their counsel where they just kind of wanted to see where I had left off, but the complaint that they filed doesn't include any of my work.
And the complaint that they filed is basically an effort to make sure that Kouri does not get a single penny from Eric Richins' trust, right? Is that your understanding of the litigation?
I actually don't know much about that litigation, and on purpose I have tried to ignore it. I try to stay in my lane and in my box, and this is the box I'm in, and so I really don't know the status. I don't know what's been happening there. My overall understanding is they were trying to enforce the trust, the Eric Richins Living Trust, and associated documents. Is that? That's a weird way to say that, but that's my understanding.
And when you were in their box, when you were in the box with the trust, was it your understanding that Kouri Richins was aware that a trust had been created before Eric passed?
I was under the impression of the opposite, that she did not know about the trust. And whether or not she knew or didn't know, I really do not know the answer to that question.
So you've not reviewed any police reports in this case that talked about interviews of Katie the morning of Eric's death?
I know that there were some that took place, but I have purposely not reviewed them.
So you don't have personal knowledge, one way or the other, about whether Kouri knew this trust was in place before Eric died?
I cannot testify one way or another about that.
Okay. Did Todd Gabler ever give you any documents to analyze, or it all came from the attorneys of the trust?
I didn't get anything from the attorneys.
Where did you get the documents from the trust?
I believe I got everything from Katie.
From Katie, the sister?
I believe so.
Okay. All right. Are you still retained in any way by the trust?
No. I haven't engaged in conversation with them. I haven't responded to anything for the better part of a year.
Did you review new documents before you testified today that you did not review before the detention hearing?
Yes.
What are the new documents you reviewed before today?
We have more bank account statements. There are loan documents that I did not have before, and that includes promissory notes. And I know that payment ledgers have been requested, and there's very little of that due to the nature of the loans. I searched and obtained many more deeds in South Carolina and in Utah, and the UCC filings of the personal property loans, the unsecured loans, the insurance documents. I'm sorry, I'm getting a little conversational, but at the detention hearing, it was early in the week, say a Tuesday, for example, and most of the documents, the financial documents that I reviewed, I had for just a couple of days.
Okay.
Literally.
I want to talk about these properties that you've looked at as far as Ms. Richins. It appears from your testimony with the county attorney that you were looking at the debt that those properties put her in. Is that right?
Yes, and I did testify about that exact point at the detention hearing, because at that time, that's all I had access to were those recorded documents. So I could see the amount of the trust deed, and I did acknowledge that that does not necessarily represent what she owes on it, but what she encumbered. That's why I'm calling it an encumbrance.
So these charts that went up dealt with what she owed on the property to the best that you could determine looking at publicly available records, right?
Not necessarily. The timeline chart that has all the colors, I mean, that has a date, well, it has a point at which she no longer owned it. Her name is no longer on that.
Okay.
And so that represents that she no longer had that debt.
Successfully flipped that property, right?
Successfully would be a judgment call, and I've not been asked to give opinions.
Okay. All right, so let's talk about equity.
Okay.
When someone owns a home, you have what the home is worth when you buy it, but then you put money down on it, you pay money towards your mortgage, and at some point you build up something called equity in your house, right?
That's true.
And when you have a lot of equity in your house, you can go, like she did on their house in Willow Creek, right? And go and say to a banker, hey, I have this property that has about $600,000 worth of equity in it. Can I borrow $50,000? And what is the banker likely to say to that?
A banker's likely to look at a lot of factors, right? Go through some due diligence. Given a lot of different factors, probably going to say yes.
Right. Because equity has value.
That's true.
And it's part of your net worth. That is true. So when you're evaluating someone's net worth, you're looking at their debt for sure, but you're also looking at things they have that have value.
That's true.
Their jewelry, right?
That's true.
Their artwork,
Yes,
their stocks and bonds,
yes,
their equity and property.
yes.
You were not asked to make that evaluation by this county attorney's office, correct? Because I don't see that you did a net worth evaluation here.
I have done some. There's some holes in it. There's some holes in it, so.
Okay. So you haven't today put on evidence of Ms. Richins' net worth?
No, and there are a lot of things that I don't know, like I'm aware that she has a tax liability, and I know that I can estimate a range, but I don't know how much that is, and that would factor into her net worth.
And I know you're an experienced accountant. You would never make a statement about someone's net worth if you knew you were missing critical documents to make that evaluation. Fair?
I would definitely put a footnote on that.
Okay. As far as the profits that Ms. Richins made when she flipped these houses, unless you have the settlement statement, the closing statement, all the records, it's not always possible to tell what her profit margin was, is it?
Well, profit margins, the answer is maybe yes, maybe no. Do you mind if I explain?
Go ahead.
Okay. For example, Ms. Richins has a schedule that she had submitted to some lenders that talked about the projects that she'd done. And she included in there is the acquisition price, the rehab budget, what it was sold for, and her profit. And I've gone through a few of those, and they're not accounted for correctly. The sales price does not reflect what her margin is. You asked me about margin, and the margin is not correct. Her profit is not correct on that. What I can tell you, the answer to your question, is I do have the settlement statements on a lot of those. And the settlement statements are prepared by the title company at closing. And so that'll go down the sales price and the deductions from that, like the property taxes that need to be paid, the encumbrances, like the first trustee, the second, if there are more, some other agreed upon amount that needs to be on one side of the ledger or another. And then we get to a net proceeds amount. And then I can go to her bank account statement and I can see those funds hit the bank account statement. The way she had borrowed money, not everybody who was involved, I use that term as, not everyone who had participated financially in that project would have had a deed filed that would have them hit the settlement statement. So once the funds hit her bank account, then she also had to pay out some funds associated with that property.
So once she flipped a property, paid off everybody that helped her out to buy it or rehabbed it, whatever's left in her pocket after she pays everybody is her profit.
That's right.
And you can't say that, what that amount was on every one of these properties, can you?
Not every single one, but I can on many.
And if you, as I understand it, she was servicing some pretty major debt and servicing it, right? Sending those checks out.
That's correct.
Check after check after check, making payment to her lenders, right?
Yeah, they mostly were auto withdrawals, but yes.
And out of all those properties that you have with the pretty colors on your chart, how many of those got foreclosed on before she flipped them?
Before she flipped them? Well, she doesn't own any anymore.
So none is the answer, right?
None then.
So she successfully purchased the property, got what she needed to rehab it, flipped it, and it never went under on any of those properties, except for after she got arrested, before she was arrested.
And again, I'm gonna not use the word success because everyone's got a different version of what that term means. I think what you're trying to say is, did she end up selling them? Yes, she did.
Okay. All right. Did you ever interview any of Ms. Richins' hard money investors?
Yes.
Did any of them, other than Greengrass, did any of them ever file suit against her for defaulting on their deal, as far as you know?
I do not know that.
Right. The joint account with Eric and Kouri that they paid their bills out of and their kids' soccer fees and things like that, did you ever compare the deposits from Eric into that account versus deposits from Kouri into that account?
I'm aware of how much was kind of coming and going.
And who put more money in that account?
Eric's paycheck was auto-deposited there, and that was more than Kouri's. There were funds coming and going, and so, but they were for different purposes, so.
Disagree with me that Kouri substantially deposited more in that account than Eric did, in the joint account, from her KRR account.
I don't know if I would agree with that or not, because there's a lot, there are a couple of instances where C&E, there is money coming from C&E. I will say that there are a lot of instances where there are, say, like there's a $5,000 payment from K. Richins Realty account, the 6577, into the joint account. But there are some instances where there's a lot of money coming from Eric's resources too.
Okay, now I want to back up just a little bit when you very first got on the stand and you were talking about the accounts, who had access or whose name they were in. So spouses have their own decision about who does the money, who doesn't do the money. And you were not privy to that arrangement between Eric or Kouri, were you?
No.
So you don't know if they sat down at dinner every night and looked at every one of their bank accounts together, do you?
I do not know that.
You do not know if Kouri gave Eric the password to all their bank accounts and said, babe, it's shared money, look at whatever you want to look at. You don't know if that happened.
I do not know.
You don't know how often they talked about finances or what Eric knew or didn't know about Kouri's business.
That's correct.
You do know that Eric invested in at least one property himself through his C&E account, the Branson
Lane.
Thank you.
I would not call it investing. I know that there were the C&E checks that went into the K. Richins Realty account.
Okay. Looks like they invested in the property. If you were just looking from the outside, fair?
I have other information that tells me that's not the case. That's why I've not included it in my testimony.
Okay. You also looked at the prenup agreement, and we all know what prenups or agreements are from TV, right? It's an agreement before you get married about how you're going to split stuff up if you get a divorce, right?
That's true.
Okay. And in the prenup that was signed when they got married, was the home contained in that prenup that you've reviewed? The home they lived in?
I don't recall. I'd be happy to look at it if you want me to.
Take a second, please. It's exhibit number, it's docket 106.
I'm skimming this. I don't recall it's in here. Was that correct?
It's not.
Okay.
Thank you for checking. So if you don't have your home in a prenup, regardless of whose name is on the title, would you agree with me that as a spouse, you have an interest in your marital home? Correct?
That's...
Well, hold on. They're about to object and it calls for a legal conclusion.
Your Honor, if I can argue this because
It calls for a legal conclusion. Sustained.
Okay. Let me ask you this way. You testified earlier that Ms. Richins got a HELOC on that house. Is that right? personal interest, because you're not a divorce lawyer, right?
That's that legal conclusion.
Okay. So, and you also don't know if Eric knew about the HELOC or when he knew about it or what he did about it.
Objection calls for speculation.
Well, I think that's what she's establishing, but you can answer the question.
I am aware that there are indicators that he knew about it in October of 2020.
That's right, because he told it to the lawyer that he was seeing about maybe getting a divorce, right? So when he told the divorce lawyer, hey, she took out this money on my account, that was October of 2020, right? So
And the indicators are that's when he learned about it.
Right, so a little less than 2 years before he passed away.
A year and a half, yeah.
Okay. And how many payments did you see Eric Richins make on that HELOC after October of 2020? In your review of every payment that was made toward that HELOC, how many did Eric? The realty account.
Mostly out of the 5244 account, which was Kouri's account.
Okay, so she's paying it. The HELOC that she took on it.
Yes.
Okay. And he knew about it in October of 2020.
Right.
Okay. And they stayed together, obviously. All right. If the home was not contained in the prenup, since you did work for the trust, is it not true that the trust is taking the position that the home gets poured into the trust upon death?
I don't know.
She's just asking what Ms. Carrington knows. Let's
What-
find out.
Thank you. Do you know?
I don't know.
Okay.
To be clear, I think my knowledge on these issues is
Better than
superior
all of
to
ours.
that than anybody else in the room, and so I can keep it straight.
Well, yeah, and I appreciate that, John, because I think the court in summary judgment motion 2 weeks ago ruled on this very issue.
I can give you chapter and verse on these if we need it.
Okay, thank you.
We can just keep it.
I'll try to
Which
skip
is my point, Your Honor, we
I
can keep
understand.
it.
We'll just keep it.
Okay, just making sure I don't miss anything. I want to talk about those life insurance policies that were on your chart. If you could look at that chart in front of you, those 6 policies.
It's not up, but that's fine.
Oh, I thought you had a binder, I'm sorry.
It's okay.
I can bring back up.
Thank you. It's exhibit number, is
Number
exhibit
69.
69, yes, sir.
Just get back when you're done.
Thank you, Your Honor. Now, of those policies on exhibit 69, the very first policy is a mortgage policy.
That's correct.
Which just pays off the mortgage if you die.
It doesn't pay it off, it pays it down significantly.
Right, sorry, you said that, 70 some weird percent.
Some weird percent, yeah.
Okay, so that life insurance policy is made payable to the mortgage company.
And as far as I know, it was paid directly to them.
Okay. In your chart, it says it was paid to the trust. Do you see that? They were the
do not.
beneficiary?
I say they were the beneficiary, that was, no, that's not what I said, but it was paid toward the mortgage is my understanding.
So, Kouri, and when was that policy obtained? Back in-
15.
Okay. And do you even know Eric applied for that, right, himself?
I do not know.
You don't know.
I don't.
Okay,
I don't recall.
second policy, what's the second one?
On my chart is the $250,000 trustage from 17.
And that's 2017.
That's correct.
And do you know whether Eric, that is not one of the questionable signatures, right? You've agreed that's Eric's signature on that application.
Let's make it clear, I'm not making any determination out of signatures. That's not me.
Okay. So the report you read from the handwriting analyst
That one.
didn't look at that signature of the True Stage $250,000 policy, correct?
Actually, I don't know. He looked at, in his report, he lists a few dozen exemplars. I don't know if that's one or not.
Okay. Do you know whether or not Eric Richins had to take a medical exam to get that life insurance policy?
I don't recall. I think I've got the documents for that, but I don't, off the top of my head, no.
So you can't say right now, as you sit here, whether Eric was involved in getting that policy or not, you just don't know.
I don't recall. There's both of those next two. There's the True Stage and the auto owners. That was part of a group of policies where there's one on Ms. Richins, one on Mr. Richins, and somewhere along the line there's some on the kids too.
That auto insurance policy, that's the big one. That's $1 million,
The
right?
auto owners. Mm-hmm.
And what is the date that insurance policy was applied for?
That's also in 2017.
So, help me with math, 5 years before he died.
That's right.
And that $1 million policy, there's no way they're gonna insure somebody for $1 million if they don't have a medical exam. Do you think that's fair?
I think that's a fair statement, yes.
Okay. And then the next insurance policy was what day?
This is in April of 2018 with New York Life.
So that's 4 years before he passed.
That's right.
And do you know who applied for that?
I have the documents, but I don't recall. I'm sorry.
And do you know whether Mr., and how much was that one for?
$500,000.
And do you, again, that's pricey, plus you got her. That's a pricey insurance policy. Again, I would imagine that would require a medical exam. Do you know if Eric submitted to one?
I know that he did on a policy. I've seen that, and I can't recall which one it were ones. I just don't recall those details.
So that really just leaves, and the policy that he had with his partner, the buy-sell policy, which partners do all the time, right?
That's
in
correct.
business,
Yes.
that money goes to the partner. That doesn't go to the spouse.
They're set up specifically that way. Yes.
Right. So the only policy on there that was obtained within any short period of time before Eric died was the very last one for $100,000, right?
Right, and that's usually, typically in my experience, that's an amount that probably would not have required an exam.
Totally agree. And that policy is one of those ones that we all get in the mail if you belong to a credit union, where they send you a little flyer, you get it in your junk mail, and it says, hey, you want to up your insurance? No exam, just sign here and we'll add some more for free. Please do that. Is that what that is?
It is a brochure from the credit union, but what you've just described it's not contained in there. It was an offer of life insurance though.
Made by the credit union
Yes.
to all their credit union members. It's just like a perk for being a credit union member.
It's a marketing brochure, yes.
Here's some pretty cheap insurance, grab it if you want it, right?
That would be a fair statement, yes.
Okay. And that's the policy that was taken out, I guess, that was signed to become effective a few weeks before, or a month and a half before he passed.
A month, yeah.
Okay. And again, that's $100,000 out of a total insurance amount that had been obtained years before, exceeding $2 million.
That's
right?
correct.
Were you ever asked to look at Eric's financial records in his company or his business? Anybody ever give those to you?
I do have his bank accounts, the bank accounts for their company, yes.
And the bank accounts that you talked about where, I'll strike that. Okay, court's indulgence, I think you just about 30 on it. Can I ask a quick question? Honor. Thank you very much. Thank you, Ms. Carrington.
Mr. Burr, is there any redirect within the scope of process?
Yes. Ms. Carrington, you were asked about a successful flip.
Yes.
If we're measuring success as an amount above and beyond all costs that go into purchasing, rehabbing, taxing, etc., the flip, that is a measure of successful flip. Were these purchases and subsequent sales successful?
If they were sold, if that's your measure of success, then they were sold, so that would be successful. There were several instances where the investors were not going to get their money out of that particular property, so their trust deed, their investment was transferred to a different property where there was room for them to be repaid.
So some of these subsequent sales did not even meet the investment that went into them.
That's right.
So at the time of the defendant's death, March 4th, what was the summary of debt owed? Do you have a figure for that?
Yes. 3 of the homes had recently, prior to Eric's death, had been sold for about $170,000 in net proceeds. And then Kouri Mrs. Richins had retained, I believe, 5 properties at that time. The HELOC was over its limit. It was at $252,000 on its balance. Her credit line at PenFed had been exceeded. Her credit line at America First was about maxed out, and she had ended the year in 2021 in the hole. I think in her 5244 account she was in the hole $15,000, and in the 6577 account she was in the hole $22,000. There just were no resources.
When you say there's no resources, so then she's unable to service all the debt she's acquired.
That's correct. And at that time, again, it's kind of mix and match to try and figure out how much debt load she had. She owed about $4 million on, well, let me restate that. The trust deeds associated with the property that she retained were about $4 million. So she probably owed a little bit less than that. And then the personal property loans, the accounts payable loans, I believe her balance at that time was about between $500,000 and $600,000.
Somewhere then between $3 million and $4 million is her total debt load she has at the time of March 4th, 2020.
No, it would go the other direction. So she had roughly $4 million in real estate that she owed on, and then another $500,000 to $600,000 in those personal property loans. So $4.5 million, something like that.
You mentioned the HELOC in talking to defense counsel. Do you know, other than that one $50,000 payment on principal in October of 2020, were there any other payments that you're aware of that were substantially beyond just paying the interest?
No, they were pretty much the minimum payments for the rest of the life of the loan.
When did she stop drawing money on the HELOC?
Do you mind if I look at my notes? In October of 2021 is the last draw of $2,300 payable to K. Richins Realty.
And why didn't she just take some more out of there?
Objection to speculation, Your Honor.
I think he's asking a financial question overruled.
The balance of that account, the limit was $250,000, and as of that time, the balance was $253,199.25. So there's no room to draw more.
Did these lenders that you're aware of analyze the defendant's net worth when she was taking out these loans? Accounts receivable?
It appears, yes, they did.
Okay, so how much did she have in artwork?
I don't recall any artwork listed.
Okay, how about jewelry?
I don't recall any jewelry listed either. When you look at the AFCU bank accounts, from which bank account were the payments made to the top insurance 1 through 4? Those are paid from the joint checking 2204.
Okay. And that's distinguished from the last one, the one made on February 4th, or entered into on February 4th, with apparently no notice to Eric. That was paid from which account?
From the 6577 account for K. Richins Realty.
I have no.
Ms. Nesbitt.
Nothing, Your Honor, thank you.
Ms. Carrington, you can step down. Thank you. Okay. Mr. Bloodworth, what's the plan?
Your Honor, the state does not intend to call any more witnesses.
Does the state rest?
The state.
Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, is the defense going to be calling any witnesses?
No, Your Honor, we won't be.
It's late. There's a lot of information here and a lot of counts. I'm disinclined to cram that in today. What's a reasonable time to come back to tomorrow, confirm that Ms. Richins wants to waive her right to testify, and argue about the showing of probable cause?
Whatever time.
You're allowed to have a preference.
Later the better.
Later the better. Later
Okay.
the better.
Do you want to do it in the afternoon?
How about 10 o'clock?
10 a.m. Mr. Bloodworth?
Yes, sir.
Okay. Very good. Mr. Ramos?
Yes, sir.
All right. Ms. Richins, we will retire for the evening. Court will be in recess until 10 a.m. tomorrow morning. I wish you all the very best. Please listen to the deputy's instructions. We do this in an orderly manner. We'll be back on the record at 10 a.m. tomorrow morning. Thank you. Court's in recess.
Well, today Koberger made his first quarter